Uh, Submission. This is a land grabbing matter, my lord. Earlier, the lordship has directed to trial court, the land grabbing court to consider my applications along with the findings given by this court, man. When left on Monday, man.
May I make a mention for serial number 41, my lord? 41. I appear for respondent number 3. I have informed the petitioner counsel. May I request for 2 weeks adjournment, my lord?
I represent petition.
42 also, my lord. I am 42.
Malad,
Much obliged.
Bill number 22.
I inform the Mr. Krishna also, BD advocate. Please.
My lord, serial number 22, my lord. Serial number 22.
Lords,
I'm the proxy counsel for the respondent number 1. The respondent number 1's father has met with an accident.
Milords, I'm appearing for the petitioner. There is some urgency. Milords, I understand. Milords, they are on caveat. Milords, the trial court LGC matter is to. Milords, may I just request for the matter to be taken up? We have the LGC matter is tomorrow. Milords, even on the last occasion, they had sought for time. The matter is tomorrow, Milords. If the matter can be taken up, Milords. Milords, I absolutely understand. The only difficulty is, Milords, cognizance has been.
My lord, they already have an interim order.
The interim order is only in respect of the injunction order passed, Milords. There's also cognizance taken. The trial court matters coming up tomorrow where the court is insisting for the appearance of the parties.
My lord, I cannot give any undertaking. I'll seek instruction.
Milords, they.
See, number 21, my lord.
I apologize, my lord. It may be taken up during the course of, I'll seek instructions whether they want to. My lord, I'm the proxy counsel. I'll seek instructions as to whether.
Milords, there is also some urgency in respect of the interim order of injunction. Milords, there are the matters covered by the orders of the honorable court. Milords,
Serial number 39.
Milords, after 4 weeks, Milords, we are led by Mr. Raghavan in the matter, Milords.
I represent the petitioner. 39. I represent the petitioners, my lord. My request for a week's time in that matter, please.
Serial
Number 21, my lord.
28.
No, I seek some time to prepare and argument. We are seek some time to prepare and because the issue involved is something whether the DSIR is a competent authority or not regarding quantification and 35(2)(a)(b) method. It requires some time to prepare and argue the matter.
Serial number 28.
21,
Your
my
lords.
lord.
Serial number 28. Request for 2 weeks, my lords. I have requested the documents from the client with respect to the earlier proceedings. It's taking little time, lords.
My lord, serial number 21, my lord.
Lords.
21, my lord. For the petitioner, my lord. Seek for 2 weeks of time, my lord. We inform the response. Interim order, my lord.
With my lords, kindly, my lord, serial number 38, my lord, I appear for the petitioner. My lord, in fact, this matter was moved day before yesterday to advance it to yesterday, my lord, since there was inconvenience my senior today. My lords had directed me to make a mention today for 18th, my lord.
Lord, in this case, my lord, your lordships are directed that they must file a memo giving the details as a sum due, that they have not complied with
My
the
lord,
order.
they are furnishing it today. We'll serve it in advance, my lord, and please, my lord, we,
Ten, 12.
18th, please.
Not 18th, that other RFA is listed, my lord. So this may be had on 21st, my lord. 21st. And Thursday, 20th.
20th,
Very well. Allah, paravila. Tavu yavat helidare. Please,
please, my lord. I'll make sure that it's
I
done.
request them, my lord, to argue next date, my lord.
Please,
Now,
my lord.
order sheet nodidre, my
We
lord.
are ready, my lords.
ಎಷ್ಟು ಸತಿ ಅಂದ್ರೆ about 50 times it has been adjourned.
We are ready, my lords. We'll do the compliance, my lord, and we'll argue the matter on the next day. Obliged.
May I please your lordship? May I
Mr.
please your
Shankar.
lordship?
Yes.
I am on video, my lord, today.
He's on.
I am able to,
Going for seal number 1, my lord. 1. He appears in 1. Yes.
I am appearing in one, my lord.
Okay.
My lord,
Ha.
my lord, we have raised one additional question of law, purely being a pure question of law as per the decision of the Supreme Court in National Thermal Power Corporation. So the question of law is there at para 6 of the petition before your lordship, whether it's time barred or not, my lord. The relevant dates are at para 3 of the petition memo I have filed, my lord.
6.4,
6.4. Yes, my lord. Correct, my lord.
and the frame on additional. It's always open to them to frame. Berkeley. The senior advocate appearing for the assessee draws our attention to the memo dated 27/1/2025 filed by advocate on record for the assessee seeking leave to raise additional substantial question of law. First. Crops up, and therefore the same is treated as additional substantial question of law, which reads as under 6.4 page 3 dalli I have kept this. 9 years. Ready, okay.
I think the internet connection is unstable, my lords. Any date pertaining to this court, right?
2 weeks. 2 weeks.
My
Call
lord,
this matter.
The matter be posted after 2 weeks, my lord. Little unwell today, my
Put
lord.
this matter after 2 weeks as requested by learned counsel appearing for the assessee. Finally,
I can make one more submission, my lord.
yes, sir.
Sorry, my lord. I'm little unwell today, so I couldn't appear before your lordship personally. One more matter
You
of
have to
mine.
unmute.
I am unmuted, my lord. I am able to hear your lordship. You're not able, you're able to hear me, your lordship?
Yes, yes.
Sorry, my lord. I have one more matter. Sorry, I was a little unwell. I couldn't appear personally.
Okay,
My
okay, okay.
one
Which
serial number
is
serial
that
number
matter?
31, my lord. 2 weeks.
All
my
right.
lord.
31, we will have it next week.
2 weeks. Next week, I'm in Delhi, my
2
lord. 2
weeks.
weeks.
Got it. 31
Oblige.
after 2 weeks on the on the health ground of arguing counsel. Okay.
Deeply obliged, my lord.
Got it. Yes. On paying of amended cost status. A compliance of order dated 6/2/2025 within 2 weeks, failing which leave to amend wither survey.
My lords, if I may make a submission, I'm appearing for the respondent. The issue involved is very, it's a short compass, my lords.
Let us see, he is not here, na?
My lords, may a date may be fixed in the matter.
All right, after 2 weeks. Banu Prakash. Il amended petition ಹಾಕ್ಬೇಕಲ್ಲ. amended petition to be filed within 2 weeks in terms of order dated 27/1/2025, failing which the leave to amend accorded would wither away. ಅವ್ರಿಗೆ ಒಂದು ಫೋನ್ ಮಾಡಿ ಹೇಳಿ ಹಿಂಗ್ ಆರ್ಡರ್ ಆಗಿದೆ ಅಂತ. ಎಸ್. $299 days.
I'll file my objections.
Have you filed your objection?
My-
Ah,
Your Lordship, rework and change the work by Jason, Fried and David, my lord.
ಎಷ್ಟು ಪ್ರೈಸ್ ಎಷ್ಟು ಅದಕ್ಕೆ? ಪ್ರೈಸ್ ಹೇಳಿ.
Price ಗೊತ್ತಿಲ್ಲ.
ಅದೊಂದು ₹30 ಪುಸ್ತಕ
ಇಲ್ಲ, ಇಲ್ಲ.
ನಾವು ಒಪ್ಪಲ್ಲ. ಬರ್ಕಳಿ.
More than 500. About 5.
Appeal is filed after brooking a long delay of 299 days. Semicolon. It is accompanied by an application supported by an affidavit seeking its condonation. First stop. Additional affidavit is also filed. First stop. The respondent SSC has notified his objections to the application. First stop. Having heard the learned counsel for the parties and having perused the appeal papers, we are of the considered opinion that refusal to condone delay would cause great injustice to the revenue, since there is an arguable case on merits. First, condonation of delay would not add any merits to the appeal to the disadvantage of the other side. First, we also note that much older matters are still languishing in the court cupboards. First, it is not that had this appeal been filed in time, by this time, it would have been taken up and decided. First, next one, in the above circumstances, application is favored, delay is condoned, subject to the condition that appellant shall present 2 books of so and so to the Advocates Association Library, High Court Advocates Association within 10 days, failing which this application is deemed to have been negatived, and as a consequence, appeal also meets the same fate. Okay.
2 weeks.
2 weeks, 3 weeks.
Much obliged.
Ah.
Both are connected.
Connected.
Common order passed by the.
ಕಾಮನ್ ಆರ್ಡರ್ ಇದು ಸಪರೇಟ್ ಬುಕ್ಸ್ ಕೊಡ್ಬೇಕು ನೋಡಮ್ಮ, ಸೇಮ್ ಆರ್ಡರ್ ಮಾಡಬೇಕು, ಅದರಲ್ಲಿ ಬೇರೆ ಬುಕ್ಸ್ ಅನ್ನು ಕೊಡ್ಬೇಕು.
ಋತ ಸತ್ಯ ಧರ್ಮ DVG ಅವ್ರದ್ದು.
ಯಾರ್ದು?
ಋತ ಸತ್ಯ ಧರ್ಮ.
ವ್ರತ ಸತ್ಯ ಧರ್ಮ. ಚಿಕ್ಕ ಪುಸ್ತಕ, ದೊಡ್ಡದೇನಲ್ಲ ಅದು. ಚಿಕ್ಕ ಪುಸ್ತಕ ಅದು. ಒಂದ್ ಸ್ವಲ್ಪ ದೊಡ್ಡದು. DVG ಅವರ ಮರಳ ಮುನಿಯನ ಕಗ್ಗ ಕೊಡಿ. ಅದು ಮಜಾ ಇದೆ. ಫಸ್ಟ್ ಸ್ಟ್ಯಾಂಜಾ, ಮರಳು ಮುನಿಯನು ನಾನು ಮಂಕುತಿಮ್ಮನ ತಮ್ಮ ಅಂತ ಬಿಗಿನ್ ಆಗ್ತದೆ. ಚೆನ್ನಾಗಿದೆ ಅದು. 2 books to ಕೆಳಗಿನ ಲೈಬ್ರರಿ. ಓಕೆ, ಸೇಮ್ ಆರ್ಡರ್. ಮರುಳ ಮುನಿಯನ ಕಗ್ಗ, ಮಂಕುತಿಮ್ಮನ ಕಗ್ಗ ಇದೆಯಲ್ಲ, ಅವ್ನ ಬ್ರದರ್ ಯಾವ ರೀತಿ ನೋಡ್ತಾನದ್ ಅನ್ನೋ ರೀತಿ ಬರ್ದಿತ್ತು. ಓಕೆ.
Is the matter, my lord, where the learned single judge followed 2 division bench orders and said that because the reassessment order was passed without disposing of my
ಏನ್
objection.
ಅಫಿಡವಿಟ್ ಅದು?
As to the delay in furnishing the reasons, your lordships wanted to know why the delay, they have filed that affidavit.
ಡಿಲೇ ಕಂಡೋನ್ ಆಗಿದೆ ಏನಿಲ್ಲ?
ಇಲ್ಲ, delay, not in writ appeal, delay in giving me the reasons.
ಅಲ್ಲಿ ಸೆಕ್ಷನ್ ದಲ್ಲಿ ವಿದಿನ್ ವಾಟ್ ಪೀರಿಯಡ್ ಡಿಲೇ ಶುಡ್ ಬಿ ಫರ್ನಿಶ್ಡ್ ಅಂತ ಇಲ್ಲನು?
ಇಲ್ಲ, because GK and drive shaft, Supreme Court said if
Reasons have to be
148
assigned.
notice is issued and if the SSC files the return, they should furnish the reasons so that the SSC has an opportunity to question the jurisdiction. on the basis of
Which
which
is because of that judgment of the apex court.
apex court in GK and drive shaft.
I think I have referred it in one judgment, now
GK and drive shaft is repeatedly.
repeatedly this one. Okay.
The
My
learned single judge follows the
submission,
What is the delay?
ಇಲ್ಲ delay ಏನಾಯ್ತಂದ್ರೆ my lord. It's like,
Extent of delay ಮೊದ್ಲು ಹೇಳಿ.
ಅಲ್ಲ, ಇಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ-
ಆಮೇಲೆ explain ಮಾಡಿ.
I'll explain. 31st March, the notice was issued. 148 notice was issued on 31st March 2018.
5/4/2018.
5/4,
The notice is dated 31st March 2018.
1 second. Dated 31/3/2018, served on you
Served on me a day or two later, served on
On-
me on, received by me on 5th April.
5th April.
And on 27th April, I have requested them to furnish me the reasons. On 27th April 2018, I have requested the assessing officer to furnish me the reasons for reopening so that I could file my objections.
furnished reasons in terms of apex court judgment.
Yes.
ಅದನ್ನು ಕೋಟ್ ಮಾಡಿದ್ರ ಅದರಲ್ಲಿ?
ಹೌದು.
ಆ ಜಡ್ಜ್ಮೆಂಟ್ ಯಾವ್ದು?
GK and drive shaft. GKN drive shaft. The reasons came to be furnished to me only on 18th December 2018. I filed my objections to the reasons. Without disposing of those objections, they passed the as a reassessment order on 30th December 2018.
That is a preliminary objections order.
Yes. No, they
Rejecting
passed the, without disposing of my objections.
preliminary objection order ಮಾಡ್ಲೇ ಇಲ್ಲ.
ಮಾಡಲೇ ಇಲ್ಲ, final assessment order ಮಾಡ್ಬಿಟ್ಟು. Deepak exclusion and the other one. Pass it on.
Final assessment was made on
30th December 2018. 12 days after furnishing me the reasons.
yes.
The two
Facts
decisions.
correct, facts corrected.
Two decisions of this honorable court.
No,
division-
ಅವರ appeal ನಲ್ಲಿ ಏನು ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಹೇಳಿ. ನೀವು I'll come back to you.
Yes.
Yes, facts we have certain. Yes.
No, my lord. Because of lack of time, because the matter was getting time barred. My lord,
ಎರಡು lacuna. ಒಂದು, you have seen what the House of Lords said more than a century ago. When power is given to exercise, you have to exercise it reasonably, and reasonably means within reasonable time. Number one. What is reasonable is like a chancellor's foot from 9 inches to 13 inches, depending upon the circumstances, we understand. Let us see that one. Number two, after you furnished the reasons, after brooking a delay of more than 7 months, he filed his objections to that. You did not consider that. Straightway, you passed the order on 30/12/2018. Although you had lot of time, because on 18/12, they have given the objections. This is the fact matrix. What is, in view of that, what the tribunal said?
No, the learned single judge
Said-
following two division bench orders of this
He
honorable.
followed that, and in this fact matrix granted relief to you.
That's it.
That final assessment order is set at naught.
Yes.
That it did not go to tribunal at all?
No, we filed a writ petition, my lord, because GK and drive shaft says if they don't dispose of my objections or if I have aggrieved
WP is
in the
maintained.
manner in which the writ, the court said that we can avail the writ remedy.
Writ remedy. Yes.
My lord, my only submission would be, my lord, because facts are not disputed here.
ಈಗ
No,
ನೀವು
no,
ರೀಸನ್ಸ್
not-
ಏನ್ ಕೊಟ್ಟಿರಿ ಅಫಿಡವಿಟ್ ನಲ್ಲಿ?
Affidavit, please.
ಬಡಿ ನೋಡೋಣ. Whether this officer is still there?
ಇಲ್ಲ, ಏನಾಯ್ತಂದ್ರೆ originally the assessments were done in Bombay. Then, my lord, the files were transferred to Bangalore.
Originally ಬಾಂಬೆದಲ್ಲಿ ಯಾವತ್ತು
I have
ಮಾಡಿದ್ರು?
given the dates, my lord, in the affidavit. Page number 2.
This affidavit was sought for by the
By this
coordinate
honor-
bench,
No, no, by your lordships.
by myself, or ourselves.
My lord, 31/3/2018. My lord, 14/5/2018, a proposal was made to transfer the files.
14/5.
And it's in, my lord, page number 3.
Two thousand eighteen.
The file was
Notice.
Bombay, it was being assessed in Bombay.
But notice was issued dated that one, when it was at Bombay only.
Bombay only.
Bombay.
Correct.
Notice was issued by the
The
Bombay office.
Address of the SSC came to be, my lord, came to be changed to Bangalore. Consequent to that.
But that was served on him on 5/4.
5/4, my lord, when he was in Bombay, it came to be issued, no doubt. Then, my lord, this whole assessment jurisdiction was, my lord, transferred after hearing the SSC under 127 of the Act.
Transferred with effect from which date?
Transfer order, my lord, 5/7/2018.
5/7/2018. In
That
the
is,
meanwhile, so much time was available to you.
Then, my lord, what happened was, my lord, the files were transferred on 8/10/2018,
No, you are saying subsequent to transfer.
subsequent to transfer.
But before
Bombay
transfer,
office-
a lot of time was, you could have built Rome. One Bhakra Nangal could have been built. What is the answer?
I can't justify, my lord, the delay.
Then ಏನಿಲ್ಲ appeal ನಲ್ಲಿ. ಇದನ್ನ record ಮಾಡಿ dismiss ಮಾಡ್ತೇವೆ. If you cannot justify the delay, which is obviously not justifiable.
Lord, I only want to, my lord, place one judgment, my lord,
Which says,
which says, my lord, non-passing of speaking order on the objections filed against the reasons recorded in writing. It's only, my lord, a procedural, non-compliance of a procedural law, my lord, laid down by the Apex Court. And it can go back to the assessing officer at the stage of, my lord, passing a speaking order and then pass an assessment.
ಆಮೇಲೆ ಈ ಮ್ಯಾನುಫ್ಯಾಕ್ಚರ್ ಮಾಡ್ತೀರಿ ನಿಮ್ಗೆ ಬೇಕಾದಂತ ರೀಸನ್ಸ್ ಅನ್ನ ಈ ಹಂತದಲ್ಲಿ ನಾವು ಕಳಿಸಿದ್ವಿ ಅಂದ್ರೆ.
Reasons ಮಾಡಕ್ಕಾಗಲ್ಲ.
ಹಾ.
Once it is recorded, my lord, it will stay.
ಎಲ್ಲಿ ರೀಜನ್ಸ್ ರೆಕಾರ್ಡ್ ಮಾಡಿ when you gave reasons to him, he sought for reasons.
Please,
Is it not?
please.
He sought it on 18/12/2018.
No, no.
No.
I sought it on 27th.
7/4/2018. And they gave on 18/12.
Yes.
That's the delay. Now, how that has prejudiced your case?
My lord, Supreme Court says without disposing of my objections on the jurisdiction, they can't proceed to pass the.
Then
final-
remand ಆಗ್ಬೇಕಾಗ್ತದೆ.
My lord,
If that is accepted, it's a case for remand.
no, no. The thing is, by mandate of the Supreme Court, my lord, once I file my objections to the reasons questioning the jurisdiction,
They have to
and
pass.
without disposing of that objection, saying that I have jurisdiction, how can he proceed to pass the final assessment order?
Therefore,
Because
that
I
is
have a
bad.
remedy. I have a remedy to challenge that order before this honorable court. That remedy, my lord, I have lost.
No, ultimately, what will the matter is, it's a matter for remand.
No, no.
Final order itself.
This honorable court has taken the view that if objections are not disposed of, as directed by the honorable Supreme Court in G. Can Drive Shaft, the assessment order passed thereafter is null and void because the officer doesn't assume jurisdiction.
Therefore, there is no order now.
There is no order now. That's
Therefore,
what-
order has to be passed.
No, once the order goes, my lord, now the time limits have gone in accordance with law. Now, there are no time limits. The time limit, prescribed time limit is gone because they
What
passed
is
the order.
What is the,
Karnataka judgments, my lord.
what is the time limit?
Time for passing the assessment order in this case was 31st December 2018.
31st December 2018.
Yes,
They had passed it on 30/12/2018
That's right.
wrongly.
Correct.
It is no order at all.
Gather.
All right. What if the period spent in this litigation is minus because of Baroda judgment?
No,
Then
but
it will-
this litigation has been started after they passed the final assessment order, not during. This writ petition came to be filed after they passed the final assessment order, after the limitation.
So by limitation period expired before one knocked at the doors of court.
Correct.
ಅದನ್ನ ಕಂಡೋನ್ ಮಾಡ್ಲಿಕ್ಕೆ ಪ್ರಾವಿಷನ್ ಇಲ್ಲ.
ಇಲ್ಲ.
ಪ್ರಾವಿಷನ್ ಇಲ್ಲ.
ಅದಕ್ಕೆ this honorable court took the view that the assessment order becomes null and void.
ನಿಯರ್
Without
ಬೈ one judgment
One
ಮಾಡಿದ್ವಿ
judgment, my lord, and just,
ಕೊಡಿ.
I have placed also, my lord,
ನಮ್ದೊಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಮಾಡಿದ್ವಲ್ಲ ಎಲ್ಲೋ ಒಂದ್ ಕಡೆ. ಸೆಕ್ಷನ್ 14 ಆಫ್ ಲಿಮಿಟೇಷನ್ ಆಕ್ಟ್ ನಲ್ಲಿ ಹೆಂಗಿದೆ ಅಂತ ಪ್ರಾವಿಷನ್ ಇಲ್ಲಿ ಇಲ್ಲ ನಿಮ್ಮ ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್ ಆಕ್ಟ್ ನಲ್ಲಿ ಅಂತ ಬರ್ದೆ ನಾನು ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್ ನಲ್ಲಿ. Last perhaps 10 days, 15 days back, where Will Gola appeared in the matter. You also appeared.
penalty case. It was a penalty case.
No, there we considered how limitation law operates within the framework of income tax act ಅಂತ ನಾವು ಟ್ರೀಟ್ ಮಾಡಿದ್ವಿ. ಆ ಜಡ್ಜ್ಮೆಂಟ್
My
ಇದೆಯಾ?
lord, here what happened was, the very next day, my lord, the limitation, my lord,
Expired.
expired.
ಅದಕ್ಕೆ ಏನ್ ಮಾಡ್ಲಿಕ್ಕೆ?
Literally, this particular case. My lord, may I take my lordships to this GK and drive shafts with the first judgment, and the second one, my lord.
No, question of remand will not arise because it is time barred now. Time barred is there.
Because the Madras High Court says, my lord, it's only a non-compliance of a procedural law laid down by the Honorable Apex Court. So, my lord, it can go back to the assessing authority for making a speaking order and
No, that
passing
is,
fresh
that
assessment.
amounts to extending the period of limitation. Where is the provision? Either there should be provision for condonation of delay, or there should be provision for extension of the limitation period, which we find in criminal procedure code. 366, 368, something, some provisions are there. Court can extend the limitation period. But the such provisions are absent. ಏನು ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ.
Yes, I leave it.
Yes. Intra-court appeal dismissed, broadly agreeing with the reasoning of the learned single judge.
Great.
Reasons to follow. Yes. Hello, ಹೆಸರು ಬರೀಬೇಕಾ? ಸೂರ್ಯನಾರಾಯಣ.
Your Lordship, in this case, in the last date of hearing, my lord, your lordship had called for the records from the tribunal, my lord. The records are received, my lord, in the connected matters. The paper books are filed by the SSC. I have to secure the copies of this records, my lord.
My
One
lord, senior counsel is on his legs in before Court Hall 8. Kindly pass over the matter.
Passover.
My lord.
That is in first matter, they are seeking for passover, my lord. It is all three are connected, my lord. The question is, my lord, whether there was a employer and employee relationship between the Indian company and the persons who have been sent by the foreign company. The foreign company employees come to India, they work for the Indian company, whether there was employer-employee relationship between Indian company and those employees. It depends upon the clauses in the agreement. Those agreement copies, your lordship secured records from the tribunal, my lord. Have to-
Your version is there was no employer-employee relationship at all. Anta.
No, because
he was, his umbilical cord was the foreign
foreign
company.
their contention is that they still continue to be employees of the Indian company. But your lordship, payments are made by the Indian company to the foreign company.
Yes.
Your lordship, whether it is in the nature of technical services.
Ready?
Yes, my lord.
Yes.
My lord, on the last occasion, I had pointed out that the writ appeal has been filed on the basis that the learned single judge followed a division bench judgment of this court. My lord, they say that he should not have followed because in some sense they are saying that judgment was per incuriam. Why? Because they filed a review petition. Review petition has been dismissed now. In fact, this judgment is followed by another division bench.
Review in this matter or
In that matter, which the learned single judge has followed.
on the ground that it was per incuriam?
In the sense, my lord, they don't use the term per incuriam, but they say it should not have been followed because the judgment does not consider ABC. And my lord, now the review stands this.
They have not named it as per incuriam,
They didn't,
but ingredients they have given.
if your lordship just, I don't want to, my lord, say anything. If your lordship just sees,
Yes.
my lord, page 15.
But what that division bench said, what question it considered?
My
Other
lord,
bench?
that bench, my lord, considered the fact, if your lordship just sees, my lord, just give me a moment, my lord. If your lordship sees, this is about secondment, my lord. And my lord, and what we are saying is that these people who come to our country, we enter into employment contracts with them. My lord, this court, my lord, had taken a view that these are employment contracts here, and my lord, these amount to payment of salaries. My lord, that's the square question before the learned single judge also. And if your lordship sees page 15, what they say in para 18.
Now, let us see the provision of law now. Padi, how statute is worded.
My lord, in fact, this arises under the Indo-US Treaty, double
Yes.
taxation treaty. And my lord, there, in fact, if your lordship sees, my lord, the learned single judge has formulated around 5 or 6 questions. In each of those questions, my lord, the learned single judge follows either a Supreme Court judgment or a division bench judgment of this court. And what, my lord, the learned single judge says is that, my lord, ultimately, this was in relation to deduction of tax, my lord, at source. It filed an application saying no requirement because what is being paid to the other company is only a reimbursement towards the salary that we pay to India.
Employees of that company.
They become employees here,
Under what provision?
my lord, under an employment contract with us.
Sure, sir. Sure. That's the only issue.
That's the only issue. Now, my lord, if I may just, my lord, show to your lordships the impugned judgment of the learned
Yes.
single judge.
Yes,
It's a very well considered judgment, my lord.
yes.
My lord, if your lordship sees, kindly see, my lord, the findings start from page 31. 31 to 44 is on the maintainability of the application. Judge, my lord, learned single judge holds in our favor. Issues on merit start, my lord, at page 42 onwards. Proposition B, my lord. Very neatly, my lord, all propositions have been stated.
FIS means?
My lord, this is fee for inclusive services. This is a specific
for
category.
Inclusive service.
Services under the treaty, my lord. This is under Article 12. Now, my lord, what the law on that is, my lord, and learned single judge considers the judgment of the Supreme Court in engineering analysis to say that if the DTA terms are more beneficial to an SSC, then in terms of section 90, subsection 2 of the Income Tax Act, the DTA terms will be preferred over our statute. My lord, that's the well-settled law by our courts, my lord, to say the act itself says that whatever is favorable, the SSC can follow. And therefore, my lord, the issue arises not under the Income Tax Act, but under the DTA under Article 12(4). The first part of this.
DTA becomes part of income tax law.
Correct, my lord. DTA, in fact, the Income Tax
Tax DTA.
makes a reference and says whatever is beneficial, you can adopt. Now, my lord, that proposition is stated by the Supreme Court in engineering analysis. If your lordship sees page 42, the learned single judge quotes that. And then, my lord, if your lordship sees Article 12 is what is in consideration and 12(4), that is quoted at page 43. My lord, your lordship wanted to see that.
FIS.
FIS. For the purpose, my lord, if your lordships permit, may I read?
Yes.
For the purpose of this article, fee for included services means payments of any kind to any person in consideration for rendering any technical or consultancy services, including through the provision of services of technical or other personnel, if such services make available technical knowledge, experience, skill, know-how, or processes, or consist of development and transfer of a technical plan or technical design.
Where is the requirement of vinculum juris of employer-employee here?
Nothing. That's why, my lord, in fact, the law on this subject is that when we speak about FIS or FTS, there must be a technology transfer of something of the like from the foreign company to the Indian company. Here, these employees are coming into India, entering into employment contracts directly with us and are carrying on day-to-day operations, like a finance manager or a management, my lord, personnel. Now, on an analysis of this clause and the law laid down on this, learned single judge clearly says that, my lord, this uses the term make available, if your lordship sees.
No, I want to.
In clause B.
They're saying they were employees of the foreign entity and they are not employees of the assessee here. That's how.
My lord, that's why we said that when they come here, They enter into an employment contract for a particular period here.
No, I am asking, where is such a requirement to seek benefit? Where is such a requirement of the vinculum juris of employer-employee should be employees of a foreign country, they are deputed to your company?
No
Become
requirement.
your company employees.
No such requirement. We can do it, my lord, contractually, we can do whatever, whosoever we want to employ, we can employ.
Because the words used are, kindly see that. Any person in consideration for rendering of any technical or consultancy services.
My lord, apart from the fact that these are not technical and consultancy services at all, they are rendering services as our employees to us. Foreign company is not rendering any service to us. But the crucial clause, my lord, is clause B, on which, my lord, make available technical knowledge. And this has been interpreted, my lord, to mean that when you say make available, there must be something tangible in terms of a technology or something which is
Available.
which is made available so that you can work with that technology independent of the company which is providing you this. This is the law. Now, my lord, if your lordship sees how this is analyzed by the learned single judge, he, my lord, considers this interpretation. And my lord, if your lordship sees para Roman 9,
Directly also we can.
para Roman 9 at
No, if you
the
are
bottom
having
of
any
page
vendor,
44.
Okay.
In
Directly
terms
also
of
we can.
Article 12.4b, for the purpose of considering FIS, it is necessary that the rendering of technical or consultancy services must make available technical knowledge, experience,
No,
skill,
vendor, I don't have anyone
know-how, or
here.
processes.
You directly
Further,
charges,
it
I
may
will send
also
you.
consist of
There are
development
many
and
packages
transfer of a
available. So
technical
in that
plan
something we
or
have
a
to
technical design. Nothing like that is being done here. Accordingly, it is not mere of a rendering of a technical services, but the requirement of make available in terms of 12.14b, which is required to be fulfilled. Then, my lord, para 11, the DCIT, while passing the impugned order at para 36, has concluded that the payments made to Walmart will fall in the category of payments made to any person in consideration for rendering technical consultancy through the provision of services of technical or other personnel. It is observed that Walmart has, through the seconded employees, provided technical services to Flipkart Internet, as technical services would also include provision of services. In the impugned order, what has been lost sight of is the requirement of make available under Article 12.14b. A perusal of the MSA would refer to, my lord, there are two separate clauses, and we are concerned only with the second clause. B. The MSA, if subjected to scrutiny as regards the aspect of secondment, does not reveal the satisfaction of this requirement of make available, which is a sine qua non for being FIS. The DCIT has proceeded to pass the impugned order without examining this aspect. The fact that the employees seconded have the requisite experience, skill, or training capable of completing the services contemplated in secondment by itself is insufficient to treat it as FIS, as has been concluded, deserves the satisfaction of make available. Then, my lord, if your lordship sees, he goes point by point to say that ultimately, my lord, the Supreme Court in GE says that until the payment is in the nature of income in the hands of the foreign company, no requirement of deduction of tax. And, my lord, income, this is a pure reimbursement. These employees were initially employed by the foreign company.
Foreign entity.
And they paid some amounts to this. We reimburse because it's our liability.
Whatever the employer paid to them.
On an actual cost basis.
Because their help was taken for technical the transfer of technical know.
It's a payment to them there in their bank account.
That you have reimbursed.
That I have reimbursed. So the next part is following Supreme Court in GE, my lord, the learned single judge finds that these were pure reimbursements, and unless something is in the nature of income in the hands of the foreign company, no question of deduction under section 195(2). Now, my lord, if your lordship sees, he goes point by point, follows Supreme Court judgments on every proposition. And if your lordship sees at page 51, this is totally covered by the Supreme Court judgment in GE, which the learned single judge quotes and follows.
Please read that para 14.
Yes, my lord. Para
14. One more aspect needs GE.
Yes, my lord. Para 14.
Page 51.
Yes, my lord. Page 51.
Yeah.
My lord, I'll read from the top. The difficulty of ascertainment of income of component is being an impossible burden on the payer in the context of Section 195C. My lord, we are not concerned. In fact, GE Technology India, the apex court at para 14 has specifically recorded the distinction as follows. One more aspect needs to be highlighted. Section 195 falls in Chapter 17, which deals with collection and recovery. Chapter 17B deals with the deduction at source by the payer. On analysis of the various provisions of Chapter 17, one finds the use of different expressions. However, the expression "some chargeable" under the provisions of the Act is used only in Section 195. For example, Section 194C casts an obligation to deduct tax, tax is tax at source in respect of any sum paid to any resident. Similarly, Section so-and-so, inter-alia provide for deduction of tax in respect of any amount referred to in the above provisions.
So that expression is absent, conspicuously absent.
Yes, and therefore, my lord, in terms of 195, we are also concerned with 195. Supreme Court said that unless it is chargeable to tax under the Act, no question of deduction of tax at source. So he follows the judgment of the Supreme Court to say that because this is in the nature of a reimbursement and this is not liable in the hands of the foreign company, no question of the next point, my lord, is on reimbursement, where again, my lord, on a full analysis of the agreement, if your lordship sees the finding, clear finding, and again following, my lord, judgments of the Supreme Court.
Page 47 now.
Page number?
My lord, my friend also wants me to point out page 47.
Page 60. Where he follows Abbey on this principle.
One second, you're jumping. My lord, I'll just
Some chargeable under the Act is a precondition
for deduction of tax at source. And if it is in the nature of a pure reimbursement, there is no question of an income. There is no question, there is no markup. Now, my lord, after this, if your lordship sees where, my lord, this ground in the writ appeal to say that this court's judgment, division bench judgment, if your lordship comes to page 63 for a minute. My lord, I'll take your lordships to the rest of the propositions. Each of these propositions is covered. But kindly come to para 37. This judgment, my lord, they say is not correct.
Abbey Business Services.
Abbey Business Services.
It's on the same second.
It's on the same issue of secondment of employees. My lord, if your lordship is para 37. Your lordship will start seeing from para 36. Curiously, the file
Secondment agreement concept it
correct,
employed.
Correctly. Curiously, the file contains a note by, my lord, I'm sorry, I'm reading para 36 just to give context, my lord.
Yes.
Curiously, the file contains a note by the same DCIT who has eventually passed the impugned order, which note dated so-and-so addressed to the CIT seeks for granting approval for granting deduction of tax TDS at the rate of 0% on a cost-to-cost reimbursement. However, the opinion was directed to be reconsidered as per the endorsement in the file, and eventually an order was passed by the DCIT contrary to the earlier view and has rejected the application. This is what happened in our facts. Initially, he said, okay, no deduction required. Accordingly, the findings in the impugned order and the conclusion regarding the employer-employee relationship is based on a wrong premise and is liable to be set aside. As observed by this court in Abbey, it is also pertinent to note that the secondment agreement constitutes an independent contract of services in respect of employment with the SSC. Hence, the DCIT in the impugned order has missed this aspect of the matter and has proceeded to consider the aspect of rendering service as to whether it was FIS. In the light of the setting aside of the impugned order in the context of legal position as above noticed, the only order that can now be passed is one of granting nil. So this court, my lord, had already taken the view in Abbey, and now kindly see, my lord, their ground at page.
When you say that abyss was per incurium, though you have not used it, but all ingredients you have taken up.
Yes. Para 18 of the.
That is what he says.
My lord, firstly, my lord, I'll submit on facts. Certain payments are made by the respondent to a foreign company.
To the employees of the
to a
foreign company towards reimbursement
I'll
of what was paid to employees who came here and gave the services
and
to
it
Flipkart.
is claimed that it is nothing but reimbursement. Now, my lord, for reimbursement, they should have made a payment which I should have made to my employees. the payment ought to have been made to the workers with whom I had a relationship, employer-employee relationship. And for some reason they have made and I am reimbursing it.
Right.
So on the factual matrix, my lord, when when the authority looked into the clauses of the agreements specifically, it was found that the relationship of the persons who received that salary, employer-employee relationship, was with a foreign company. And that's why he came to conclusion
That he does not deny at all.
May have been earlier.
They were-
Now when they come
were-
here,
They come here, they serve us. Therefore, whatever is paid to their families by the foreign entity, that we are reimbursing to the foreign entity. Therefore, it is not chargeable to income tax. If it is not chargeable to income tax, TDS is not the idea invocable.
that's right. That is right.
Lord, any
Mean
income,
to say,
any income earned in India would be taxable in India,
There's no
any
income.
income,
earned in India.
correct. ಅದು ಇನ್ಕಮ್ ಆಗುದಿಲ್ಲ ಅಂತ ಅದು ಚಾರ್ಜೆಬಿಲಿಟಿ ಟು ಟ್ಯಾಕ್ಸ್ ಇದ್ದಾಗ ಕ್ವಶನ್ ಆಫ್ TDS arises. If the income is chargeable to tax,
Please.
if income is not chargeable to tax under that double tax, ಎಂತದು ಯಾವ್ದು?
Double taxation avoidance
Avoidance
agreement.
treaty,
Agreement.
which agreement, which the Income Tax Act takes cognizance, gives recognition,
Please.
then it will not be a factor at all. Is this one?
So
They
it
followed
would, so
this
it would
decision.
be a factor. In each case, those agreements will have to be looked into. What is a clause between myself and the foreign company? Myself means what is a respondent company and the foreign company?
Individually, that should be decided.
It is.
It has been decided in
with
this.
the application to double taxation avoidance agreements.
But your officer at one point of time said in their favor.
Correct. CIT reverses it.
In their
Your
favor,
officer.
CIT has not, and my lord, communication between the authorities
right.
of the.
It's all
What
right. It's
happens
not
is-
an order issue. It is
Please look into these aspects.
intra-departmental communication. it is.
Communication, probably the higher authority has said, have you looked into certain clauses, which normally has to be looked into, and it was looked into and an order is passed. My lordship may kindly go to only one page, I'll take, 2 pages, 141.
Well, just one other fact I wanted to point out, just for clarity on facts, if your lordships permit. My friend, my lord, after that, go on. As far as salaries paid, including what is paid outside India, to the Indian employees is concerned, full TDS on their salaries is deducted by us here under section 192, which is the provision for salaries.
No, he says it was not a reimbursement at all.
please.
I am coming to that. I'm coming to that.
That company
This
had
is very
already
important.
paid.
This is very important. My lord, supposing I am the employee here, I am earning 1 lakh rupees. Who pays me is not the question. Who pays me first is not the question. 1 lakh rupees is what I am earning. That income in the hands of the employee is chargeable to tax in India. As an employer, is this also income in the hands of the foreign company with whom he was working? What has the foreign company done? Out of this 1 lakh, say 80,000 was paid by the foreign company in his bank account outside India so that his family can be taken care of. I merely remit this 80,000. I am liable to pay this employee 1 lakh. 20,000 I pay him in cash here. 80,000 I remit to the foreign company that you have paid this employee on my behalf. Please take this back, which is a reimbursement. Question which is being raised here is whether this 1 lakh rupees, apart from being income in the hands of the employee who's worked in India, on which there is no dispute that it is taxable and tax has been paid, is also income in the hands of the foreign company. It's bizarre because that foreign company doesn't retain anything. They only, as a matter of convenience, pay that 80,000 rupees
Advance.
on my behalf.
Thereafter, you reimburse.
I am only reimbursed. How can it be income in their hands? This employee is already paying tax in India on the full amount that he receives, whether first there or here, full amount. And there's no dispute. And once I, my lord, deduct TDS under section 192 on the employee's income, accepted without demur.
Only the remaining amount you sent it to the foreign company.
Foreign company, because they had paid it initially on my behalf. And that's the real question. And therefore, my lord, the analysis is that ultimately, how can you treat this as an income in the hands of the foreign company? You are only making a reimbursement. And G says, Supreme Court says, that unless it takes the character of income in the hands of the foreign company, no question of TDS.
So your contention is that amount which you are remitting to them is by way of reimbursement.
Reimbursement,
Because they had already paid to the family of.
which was my liability.
Liability.
Which was my liability. And on that entire liability, as far as the income in the employee's hands is concerned, full TDS has already been deducted. As salary.
Understood.
So that, my lord, that factual
Yes.
clarification.
You wanted to
My
say
lord,
something.
the whole arguments are that, my lord, they are the employees of the Indian company. Who was the petitioner in writ petition, now the respondent. The observations of fact finding by the authority is quite contrary. The arguments would be fine, my lord, absolutely correct, if there is an employer-employee relationship between the persons who received the salary and the respondent company. Now, my lord, I'll take only, my lord, 2 minutes, 141 page number, where, my lord, the
Now,
specific.
why you say there should be,
Specific- Please,
One
specific
second.
clauses of,
one second.
Ah.
Why do you say there has to be employer-employee relationship like our workman-employer concept? The question is, if this company takes the services of an employee of a foreign company, and for taking that, it makes the payment, and that too after deducting the TDS, that money is remitted to the foreign company because foreign company had already paid to their bank account. How can you treat the amount this company sends to the foreign company as the income of the foreign company is his question.
Correct.
my lord, I did not find a submission
Evidentiary material.
material to say that already these salaries have suffered to tax in India.
Oh. It's part of my application to the authority.
Just show that.
It's part of my application. Please see my
You
application.
have deducted TDS.
Yes,
TDS.
yes.
And the remaining amount you sent it to the foreign company.
I have deducted TDS on the entire amount, treating it as the 1 lakh mulad in my example.
Income in earned in
Full
India.
amount, whether I send it out
But
or
where do you stand?
full amount I have deducted TDS. I am all saying I don't require to deduct the second TDS by treating it as the foreign company's
Income of the foreign company. Income
That's
at
all.
the hands of the foreign
Okay.
company.
My lord,
Application
issue again would go, my lord, whether.
You
it-
said the TDS is not paid. Now he is asserting that it is paid. Where have you taken up the contention? No TDS is paid by this company while making remittance to the foreign company.
Because the issue on which
Now, where have you taken up that contention? Offhand ವಾರನೆಗೆ ಆರ್ಗ್ಯೂ ಮಾಡಿಬಿಡ್ತೀನಿ ನೀವು. ಆ ರೀತಿ ಆರ್ಗ್ಯೂ ಮಾಡಿದ್ರೆ ನಮ್ಗೆ ಎಷ್ಟು ಸಮಸ್ಯೆ ಆಗ್ತದೆ. He's very, on a very simple point it is. Brother Yadav is a great intellectual of our High Court actually, to be frank with you. That's another thing. He proceeds on the assumption, on a premise, which appears to be sensible. They belong to the employment of the foreign company. So foreign company made the payment to them. But they came here to serve this company. That service cannot be mufat, it has to be for consideration only. That money they remitted after deducting the TDS, they remitted it to the foreign company because foreign company had credited their salary to their accounts there, so that their families also will hold body and soul together on that idea. That money he has reimbursed to foreign. How can that money be treated as income at the hands of a foreign company is the question.
234,
Now,
my lord, I have stated it, never rebutted, neither by the officer nor in the writ court.
I'll explain, my lord. I'll
234,
answer.
just kindly see 234 so that factually your lordships are clear what I have done. My lord, page 234, bottom 3, my lord, bullets if your lordship sees. 234. bottom three bullets, my lord, in view of the above, the company submits that it is the real and economic employer of the seconded employees and accordingly withholds tax on salary payment made to the employees in India under Section 192 of the Act. The company further submits that the reimbursement of salary.
What is that seconded employee idea?
My lord, they are
Employees of some other company.
somebody,
So they come here as our employees.
as a, so because that, my lord, employment for a particular term, that's why the term secondment is used. And then kindly see, notwithstanding and without prejudice to the above, the company submits that it is deducting tax under Section 192 on the salary paid to the employees, which is much higher than the tax of withholding. So no question of us, my lord, withholding tax again for the second time in the hands of the company, foreign company outside.
Stand before the single charges at page 30, where they say that deduction. I'll answer.
Please,
Does
please.
not obviate.
Let us see. Kindly be seated so that you will make your submission. Wait. Yes. Ashte case. Ashte
Now,
case.
how
You
does-
show where is the, how that
I'll come to
judgment
that,
is,
I'll come to that.
Abbey's judgment is
But,
per incurium.
An amount paid by an Indian company functioning in India, who is the respondent company, to a foreign company, my lord, it would include all the amounts normally for getting certain, my lord, certain services under the agreement. How the foreign company does its business or renders its services, whether all the employees are stationed abroad or some of them are stationed in India, is their business. Now, a case is made out by the Indian company that the amounts paid by us to the foreign company is nothing but reimbursement. If it is a case where the foreign company has made the payments to my employees in India, and if TDS is made, and if they have paid their taxes for their earned on the salary, it is one thing.
This is reverse.
This is if they have made the payments to their employees in India, the Indian income which has been earned has been offered to tax.
No, they have made that remittance to the bank account of those employees abroad.
Adanne, unless, my lord, there is an employer-employee relationship, they will be making payments to so many employees.
Correct.
And all the employees could be working for the purpose of rendering services to me. I mean, me means Indian company. And to say that all the payments made by the Indian company to that company who is rendering services, providing services, are all reimbursement.
No, when they deducted the TDS, it amounts to you are admitting that the amount is towards their salary only. Otherwise, where is the question of TDS?
Whether, my lord, they were my employees, whether they were the employees of the Indian company.
No, that question will not arise because they paid it by way of salary. They remitted the TDS to you. The remainder they sent to the company because company had remitted to the bank account of the employee. Then you are stopped from contending to the contra. Because you accepted that TDS money. You should have said, why are you sending the TDS money? No, we don't take it TDS that at all. Because they are not, this amount is not towards the salary of the employees of that company. It's not a reimbursement at all. It is something else. You are accepting the TDS. Because what they paid here, they remitted it to the foreign company. Only by way of reimbursement. This stands adumbrated because the TDS component is deducted and paid to you, which you have accepted without a demur. You are stopped from contending to the contrary. Because you accepted the TDS. Here is the case. Of course, this aspect is not treated by Mr. Yadav is one thing, but in the course of argument, this arises.
But then it's a question of fact.
That's true. Having accepted the TDS without a demur, what is the TDS? It is the salary payable to the employee earned in India. That is the income earned in India on that TDS because it is chargeable to income tax. After deducting TDS, whatever amount remains, 80%, 25, 90%, whichever amount, that he remits to the employer, foreign entity. How can you treat the amount paid to the foreign the entity as the income, having accepted TDS? They have not raised at that point is another thing. But this point arises on the admitted position because Mr. Gulati has shown to us that particular paragraph at 234. At 234, he has mentioned that. And it is not your case that they have not remitted the TDS at all.
Tea gone, I guess.
ಏನಿಲ್ಲ ಅದು ಒಂದೇ ಪಾಯಿಂಟ್ ಮೇಲೆ ನಿಮ್ಮ against
He been top
rest of the
only.
things ಅವಶ್ಯಕತೆನೇ ಇರಲಿಲ್ಲ. Now you want to argue.
Kindly add some points to that. Your Lordship, the basic question involved in this case, whether the foreign company has provided technical services, managerial services through the person whom they
Whom
have
it sent to
they
India.
have deputed to India.
Correct.
Your Lordship, Section 917, technical services, that definition is there. That conditions has to be satisfied by Indian Income Tax Department to say that we are charging you because you have provided these services.
Terms of the agreement ಏನಂತ ಇದೆ?
Your Lordship, whether
ಆ terms of agreement ಓದ್ಬಿಡಿ.
that has to be analyzed, my lord. I will come to that.
ತೋರಿಸಿ ನಾವು.
ಅಲ್ಲ ತೋರಿಸ್ತೀನಿ. Next point ಗೆ ಬರ್ತೀನಿ. Your Lordship, our case is that when the employees were sent by the foreign company to the Indian company, certain work they have done, whether those work which has been done, it is in the nature of managerial or technical services. Your Lordship, that has to be analyzed. In my case, what it has been done is not, the tribunal does not go into any of the facts. The tribunal only goes into the assignment letter and says that there is no such managerial or technical work provided by those employees. Therefore, it is not taxable under Section 917. That is my case, Lord. Your Lordship, in this case, Lord, whether in the connected matter in writ appeal, whether this factual aspect can be gone into by the honorable single judge without analyzing the contents of the agreement, that has to be seen.
Now you prima facie show.
There,
The power of the High Court,
Yes, Lord.
the power of the High Court, it's in appeal.
Yes, Lord.
Appeal power is coextensive with the powers of the authority whose proceedings are put in challenge here.
Yes, Lord. Whether those
Do you agree with
services
this?
are satisfied or not, I have to.
Now
put
you
it in
show
the
that.
agreement.
Prima facie you show that.
You know, how the officer has, my lord, appreciated the agreements, you know, it starts from 140.
ಯಾದವ್ ಸಾಹೇಬ್ರು ಎಲ್ಲ ನೋಡ್ಕೊಂಡು ಮಾಡ್ಯಾರ. Lot of work here.
Please.
It's ಮತ್ತೆ
ಹೌದು.
ಹರಿನಲ್ಲಿ ಮಾಡಿದ್ದಲ್ಲ ಅದು. They considered
Yes,
judgment.
yes.
140.
140, 139 in the.
Ah.
The employer-employee relationship between Flipkart Internet Private Limited and Walmart with
With
reference
respect to seconded employees
is submitted by the SSE as under
as follows.
employment arrangement of the seconded employees with Flipkart Internet Private Limited. The company submits that the seconded employees of Walmart Inc. are working on the following terms and conditions. The seconded employees are working as the employees of the company.
Of Flipkart. They are working for the benefits and the responsibility
That is their submission.
to the company. That's all.
That is their submission.
Okay.
They are working as their employees of the company.
Yes.
They are working for the benefits of and are responsible for the company. The responsibility of the seconded employees during the tenure of their secondment is with the applicant, and the arrangement is not in the nature of contract for technical or consultancy service between WMI, that is a company, my lord, and the applicant. The seconded employees are working under the control and supervision of Flipkart Internet and report to its chief executive officer. The company has the right to take disciplinary actions against the seconded employees during the period of secondment in India. The seconded employees have legal recourse to the company in relation to any disputes arising in relation to their secondment in India. While on secondment, the tax equalization and PF deduction in India will be managed by the company. The seconded employees are on the payroll of the Flipkart Internet, and the cost of their remuneration is borne by the company. The terms and conditions and procedural work hours, code of conduct, designation, discipline, etc. has been decided and is being regulated by the company. Then, my lord, 10, para 10, place of work, tools, materials, etc. are being provided by the company. Seconded employees,
Already, 1 to 12 vidavalla.
that is their submission.
These are the indicia which Lord Denning said in deciding employer-employee relationship in England, which we have adopted. They have made this submission. Then repealing that, what you are going to say?
Then, my lord, on these findings, my lord, next page, with the reference to this, my lord, next page, para 10, 141. May I, my lord, para 10?
I have considered the contents
I have
of.
considered the contents of the applicant. The same are discussed here under 5 broad subparts regarding employer-employee relationship, requirement of deduction under section 195 when deduction is already done under 192. My lord, second one is nature of services rendered, whether or not FTS or FIS, whether tax needs to be withheld if payment is in the nature of reimbursement, whether or not the make available clause is satisfied. Regarding employer-employee relationship, gist of the applicant's argument is that seconded employees work as the employees of the applicant company. The argument is not tenable for the following reasons. The perusal of managed master service agreement shows that WMI, that is a company, shall decide on continuance of their services with the WMI in US after the termination of their secondment in India. This
Yes.
clause alone proves that relationship with the seconded employees and the WMI does not cease to exist. That, my lord, relationship still continues.
Now, one thing I am missing from both the sides. Where is the requirement that there should be employer-employee relationship between the Flipkart and the employees of the foreign entity whom it has sent for serving the Flipkart? Where is the requirement of employer-employee? Question is, where they take the services of these people, they make payment to them because it is not a free service. Number one. If that payment is already made by the employer abroad, and whatever payment they are making to these so-called seconded employees has suffered TDS, and the remaining amount is remitted to the company which had paid to those bank accounts of the employees, then where is the requirement of the vinculum juris of employer-employee? I am asking.
My lord, in fact, one factual correction here. In my example of 20,000 paid in India, 80,000 paid abroad and reimbursed, I am deducting on the entire 1 lakh, not just on 20,000. On the entire 1 lakh here, I am deducting under
Which you are
120.
paying to them X amount.
Not just to
On
them
that,
directly.
you are deducting the.
Even on that 80,000 which was first paid by the foreign company to their bank account, even on that I am deducting. Because ultimately the whole 1 lakh is his salary in India. I am only making a reimbursement. Their question is that apart from having deducted full TDS as salary on 1 lakh, on 80,000 which I have remitted as a reimbursement, you should once again deduct because that is income in the hands of the foreign company. That's their question. So full 1 lakh has suffered TDS in India as a salary.
Lord, my lordship's question, if I understood it rightly, a part of the payment made, if it has already suffered to tax in India by way of deduction of taxes,
That is bad.
Why should again be done?
Company only, it's good, I am telling.
while making the reimbursement or payment?
Our client is company, not director. No?
My answer would
But there
be,
will be personal penalty also, no?
my lord, taxes, my lord, income is offered to tax under different heads. The question posed to me by my lordships is, if these payments which are in the nature
Under,
of salary,
what head they had deducted?
I'll come to that.
TDS.
I'll-
Just
I'll-
an answer ಮಾಡ್ಬಿಟ್ರೆ ಮುಂದ್ ಮುಗ್ದೇ ಹೋಗ್ಬಿಡುತ್ತೆ.
I think probably for salaries. No, what
The
is
deduction
is
which you
for
have done.
salaries.
Is it under salary?
Yes, yes, 192 applies only to salaries.
So it has been,
So it's an admitted position.
I am answering.
AO also says that.
AO says that, and before the learned single judge, if your lordship,
That AO's observation.
My lord, in fact,
Lord, may I just complete, my lord?
One second, ನಮ್ಮ confusion, you
sorry.
complete correct. ನಾವು ಒಂದೊಂದು ತಿಳ್ಕೊಬೇಕಲ್ಲ ಈಗ
bottom.
ಆ ರೀತಿ ಮಾಡ್ಲಿಕ್ಕೆ
144
ಬರ್ತದಾ?
bottom
ನಮ್ಗೆ
paragraph.
ನೀವು ನಾವು ಓದ್ಕೊಂಡ್ ಬಂದಿರ್ತೇವೆ.
page 144, if your lordships were to have,
Bottom.
bottom of the page.
Paragraph 15.
Para 15, my lord.
It's under section 195.
192.
It is already under 192.
192, which is salaries. And they want us to deduct again under 195 by treating it as a income of the foreign company, not just income, as something which is relatable to make available technology. There is no question of any make available technology. That's what the learned single judge says. It's not just income. Income is one point. But where is the question of they having made any technology of an enduring nature? These people are carrying on day-to-day activities here. They have to satisfy both grounds, not just income. Income, there's no income at all. But how is it satisfying the make available clause? Where some technology is being sent here on an enduring basis.
Ali, what Bombay High Court said in Marks and Spencer,
Now,
the
my
same
lord,
issue arose,
yes, my lord. If your lordship sees, Mr. Marks and Spencer.
which he has referred to, na?
Yes. My lord, in fact, if your lordship sees, we have page
Do you
200,
have copy of
my lord,
the
we have a full, in fact,
Please give.
compilation
Let us
which
see
was
how
there
they have-
before the learned single judge. My lord, we are just passing that on. This is, my lord, on the precise question that once you deduct tax as salaries, then you can't, my lord, if your lordship sees page 230.
230.
No, my lord, I'm passing on the compilation. This was the compilation before the learned single.
But that contention was not taken up by you in the,
My lord, they in fact argued, we said it's unnecessary to go into that question. They take a contention that despite deduction under 192, that contention is noted by the learned single judge at page 30
Bombay High Court judgment is
of the impugned judgment. My lord, kindly just see page 230 first. What was Marks and Spencer's?
230.
230, my lord, 230.
You're right.
If your lordship sees para 3. First of all, my lord, the question, memo of appeal, revenue says that facts are under, and my lord, the question was whether it's a pure reimbursement or not. This is also on seconded employees. And then para 3, my lord.
4.2 is the question which they also had posed there.
Correct, my lord.
Here is also same.
Correct, my lord.
But only difference is there they had not deducted the tax at source.
And therefore, proceedings under 201.
But
We, my lord, started off by saying we are filing an application. Please grant us a nil certificate so that we don't have to. We didn't take a chance. Now, my lord, this in fact issue, if your lordship sees this court's judgment in Abbey, this part is dealt with, my lord, Marks and Spencer, but this court's judgment in Abbey covers the issue completely.
since the said payment to the employees is already subjected to
To
tax
tax.
in India, therefore there is no question of treating the assessee in default for non-deduction of tax at source.
Correct. Now kindly see, my lord, after this, just see, my lord, what the division bench of this honorable court has said.
Paragraph.
Abbey, my lord, that is at page 223. Abbey business, which they say, my lord, is not correctly decided.
Yes.
226.
My lord, sorry.
Paragraph.
My lord, first, if your lordships were to just see some facts at page para 2 at page 224. And then, my lord, para 7 and 8. the arguments on make available, etc. And findings of the court are from para 9 onwards. And para 11 is crucial, my lord.
Advert to the facts in hand.
Yes. Para 11, if your lordships were to see, those are the
Treated as the employer of the seconded employee.
yes. And the basis, my lord, why they filed a review
May
and what they say in their writ appeal. My lord, just allow me this because this is important. And if your lordship sees, the court, my lord, distinguishes a particular Delhi High Court judgment in para 12 called Centrica.
May I persuade my lordship to see, my lord, para 11 of 226 again,
yeah,
para
yeah, the
11.
rest of the-
Para 11.
Friends, otherly, the fifth line, it is pertinent to note that the second agreement constitute an
An
independent contract
of service
new
in respect of
compilation?
employment with the
with the
SSC.
SSC.
Yes.
Here it is with the foreign company.
यहाँ पे था अभी तक. It's not. Disappeared suddenly. Doesn't matter, I'll just. Again.
Yeah, got the point. But I wanted to know, where is the requirement of employer-employee relationship as such?
Your lordships can.
My lord, may I explain if your lordships permit?
Yes.
My lord. My lord, what happens is, there is no direct
Because in
requirement.
as he rightly points out, at para 11,
Yes, my lord.
they were treated as the employees of Indian entity only.
Here also.
Here also.
Here
If-
also.
If that were to be so, where is the requirement of deduction at source?
That is why I'm saying. That is, my lord, your lordships have actually pinpointed the real issue. If they are my employees, my lord, if your lordship sees those 12 points which my learned friend read out from the assessing officer's order, the entire control supervision, PF, everything is being done by me as an employer, totally unrebutted. Undoubtedly, they work under my supervision and control, follow my directions, follow my policies, all statutory compliance.
They are your employees.
My employees. Now, my lord, where they come from, and that is, my lord, what is important, is to say, my lord, when will it become an income of the foreign company, first of all? Generally, I'm not even on the make available clause. If that foreign company is rendering services to me, my case is why that these are employees which do day-to-day operations for me. They don't report to their foreign company.
As our employees.
As our employees. And that's why it's that employer-employee relationship is important. They don't report to the foreign company during the term here as if they are working on their behalf and rendering services on behalf of the foreign company to me.
But there is an independent
Contract of
service.
employment with me. That's the point. Because for that foreign company to have income, these salaries becoming income in the hands of the foreign company, they would have had to earn it. And earn it as how? I'm not placing it even at a much lower threshold. It's not just that if it's income in the foreign company's hands, TDS is deductible. it has to be of a nature which qualifies for the make available clause. That's why the learned single judge says, and if your lordship sees in Abbey also, ultimately the court didn't go into that, didn't have to go into that. Once they found there's an employer-employee relationship, they didn't have to go into the make available. But arguments are raised in Abbey also on make available, saying that unless there is a technology transfer or something of the like of an enduring nature by the foreign company to the Indian company,
That question will not arise at
that
all.
question, and that's why learned single judge says that leave everything apart. Where is the question? They are carrying on day-to-day activities. Where is the question of providing anything of an enduring nature of the nature of technology by the foreign company to the Indian company?
That's not there at
That's not there at all.
These people are working for you as your employees.
As a finance manager, as a technical manager, as a marketing manager, etc., etc. Where is the question of any technology transfer? And that law, my lord, is far too well settled. So for them, my lord, they had to jump several hurdles. One, this is not a reimbursement. Two, it is in the nature of income in the hands of the foreign company. Three, it is the nature of an income which qualifies for the make available clause. Learned single judge has gone, my lord, in detail on each of these questions and held in favor to say that one way or the other, you can't say that there is a requirement of TDS under 195(2). And my lord, if your lordship sees DBS also, page 191 of this compilation, the make available clause, this is a leading judgment on this, which is being followed, my lord, everywhere.
Then Marks and Spencer is not going to come to your aid much at all.
My lord, because
May
that
not
was
be
irrelevant.
relevant.
That was irrelevant. My lord, that question was raised, but the learned single judge, my lord, didn't really feel it necessary to go into that because, my lord, a question of estoppel would be slightly, my lord,
Different and other.
so learned single judge didn't think it important. Now he says, first of all, the onus is on the revenue to establish that this is income in the hands of the foreign company of a particular nature which will attract TDS. Once I find, and my lord, on reimbursement, my friend says that who paid first and who paid second, all these questions don't arise. There is a Supreme Court judgment. My lord, if your lordship just sees DBS for a minute, my lord, page 180, that will clear the air, my lord, on how my friends can even justify this.
At page 191.
At page 191, my lord, DBS starts at 180. This is, my lord, this court's judgment again.
Division bench.
Division bench judgment.
At para 22, page 191.
At page 191, my lord, if your lordship sees, this court explains what is meant by make available. Kindly see para 22 at, my lord, page 191. All these issues are covered by division bench judgments and Supreme Court. Para 22, sir.
What is the meaning of make available?
Correct. My lord, if your lordship allows, may I read this, my lord?
Yeah, very good.
What is the meaning of make available? The technical or consultancy services rendered should be of such a nature that it makes available to the recipient technical knowledge, know-how, and the like. The service should be aimed at and result in transmitting technical knowledge, etc., so that the payer of the service could derive enduring benefit and utilize the knowledge or know-how.
Within that description, this service will not fit into.
Absolutely, absolutely. So, my lord, both on the construction of this make available, on the issue of reimbursement, there are, my lord, judgments of this honorable court division bench with the learned single judge has followed. On the question that it has to be income of a particular nature in the hands of the foreign company, therefore he follows, my lord, Supreme Court in GE. All of these questions, my lord, are therefore concluded by either division bench judgments of this honorable court or by the Supreme Court. And my friend says this can't be, my lord, reimbursement. Supreme Court judgment, my lord, at page 96 in AP Mauler, where, my lord, somebody pays in the first instance outside India and the other person only reimburses. Supreme Court has come to a clear conclusion that this is only reimbursement. My lord, AP Mauler, if your lordship sees, this is a Supreme Court judgment.
There also technical services.
And there also, my lord, the question was whether it qualifies as technical service or not. And at para 9, my lord, if your lordship sees, Supreme Court says a pure reimbursement, not a technical service.
There also double taxation avoidance agreement.
Correct? Correct? No profit element. No, this is a pure reimbursement and it is not income chargeable to tax. These are the findings in para 9 and 10.
Anything in your agreement between the foreign entity saying that they will make whatever payment they will make, you have to reimburse it.
My lord, as far as we are concerned, if your lordship sees the learned single judge quoted two clauses of the agreement,
A, B.
A and B. We are concerned with B. We have nothing to do with the foreign company. We identify the employee. If they are agreeable to send him, we have a direct contract with the employee. Nothing. And this fact that there is no markup has remained unrebutted. Whatever is paid to the employee on our behalf, because this is our liability to pay him here, whether we pay him fully here or we pay him partly here and partly reimburse the foreign company for convenience, my lord, there is no income in the hands of, and how, my lord, in any case, can they satisfy the make available? There's not a shred of evidence to say that the make available clause can be satisfied. That's why, my lord, it's a very detailed judgment by the learned single judge. He's gone into, my lord, great detail. Formulated the questions, followed, my lord, judgments of this honorable court and of the Supreme Court and said.
Just see on the findings on page 52, which is on reimbursement.
And finally, if your lordship sees the findings at page 52 on the question of reimbursement by the learned single judge.
Yes. Let us see what, how he proceeds with that.
Yes.
Yes.
My lord, I'll come back to the fact. My lord, one observation made by the officer authority on the submissions made in the application made, my lord, originally, page
It was-
number 142.
A was observation.
Oh, yeah, was up.
140.
142.
Yeah, para 10 you read.
I'm reading, my lord, para 10 I read, para 11.
Yes.
Perusal of master services agreement shows that the company shall, the foreign company, WMI, my lord, I'll read it as foreign company, shall decide on continuance of their services with the company in US after the termination of their secondment in India. Then I'll skip that, my lord. Further, as per clause 4.2, the foreign company raises invoices after incurring the secondment costs, expenses and incidental costs. The relevant clause is reproduced as under composition and payments. In consideration of the secondments, the party placing the secondees shall invoice the party receiving the same on a quarterly basis the compensation and wages costs of the secondees as incurred by home country, including all secondment costs, expenses and incidental costs. Had the WMI ceased to be the employer, there is no requirement for WMI to raise invoices on the applicant. Whether the applicant pays an equivalent amount to the overseas entities or not, the latter is obliged to pay the salaries to his employees. The terms of the agreement make it clear that salary is paid first by the overseas entities and thereafter an invoice is raised and the amount is made good by the applicant to the overseas entities. Thus, when the applicant pays reimburses, the event of payment and salary has already happened. Now, my lord, 2 is important. Seconded employees have no right to claim their salary from the applicant. The right of the employee to claim salary is only against his employer, that is the overseas entity. As per global assignment letter, sample given by the applicant in the case of one of the seconded employees,
Grant code.
grant code dated 4/9/2018, the equity eligibility of the seconded employees continues to be tied to WMI. The relevant extract is as under.
ಅದು ಒಂದು ಎಕ್ಸಾಂಪಲ್ ಆಗಿ ಫಾರ್ಮ್ಯಾಟ್ ಕೊಟ್ಟಿದ್ದಷ್ಟೇ ಅದು ಅಲ್ಲಿ.
No, but this would be applicable to all the other employees also. The same format will be followed in all. Your annual equity eligibility will remain tied to your home country equity plan. However, the form and vesting of your annual equity award may be modified by the appropriate committee of Walmart's board of directors based on the location of your expat assignment. Equity awards are subject to the approval of the appropriate committee or its delegate of Walmart board of directors. In this assignment, subject to the terms of the respective plans, you will continue to be eligible for the following programs related to your employment in Canada. Executive Retirement Plan. This plan allows you to receive an annual contribution to your ERP account of 13% of the salary and annual incentive payout paid by you in the fiscal year. Deferred Profit Share Plan. This plan allows you to receive an annual contribution to your DPSP account based on Walmart's annual profit. The above referred global assignment letter also reiterates the right of WMI to terminate the services of seconded employees when it states as under conclusion agreement. Unless the company otherwise agrees upon the end of the assignment, you will either return to your home country or will be localized to the host country. As stated in the global assignment policy, Walmart Inc. may end your assignment at any time, including prior to the expiration of the anticipated term of assignment stated above for the business needs. At the conclusion of your assignment, if you are not localized to India, you agree to resign your position with the secondment of Flipkart. Thus, the employer-employee relationship of the seconded employee is with the WMI, with the applicant is only a temporary assignment.
Yes.
Now, my lord, if a part of the payment is made in the name of, a payment is made, I will not even use part of the, a payment is made in the name of
Foreign entity.
to the foreign entity, which is being called as reimbursement. The first condition should be, my lord, and that would be a part of, my lord, the whole agreement. This payment of salary would be a part of the total payment which is made to them. So if this particular payment which has been made to the employees in India, which has suffered taxes, TDS in the name of as salary, my lord, that would, my lord, is a consequence of them being employed by the foreign entity for having worked in India.
No, if it is a,
Now,
case of-
now, my lord, then can the payment made to the foreign company from India, whether it can be called as, my lord, reimbursement of salary?
if a foreign company has made the payment to them and
Ah,
they
that is
are
be-
remitting
that
it
is-
after deducting TDS part.
That is between them. That is why, my lord, may I read one section, my lord, section 9,
Page number,
page number, I'll come. Page number 58. Page number
ಈ ನಿಮ್ಮ tax book ನಲ್ಲಿ ನಂಗೆ
9,
page number
7.
difficult.
58, my lord. This is 2024 edition. 1.58.
1.58.
58, I'm sorry. Section 9.
Section 9 begins from 1.5.
I'll read, my lord, 7 down that page. 1.58. I am reading from 1.58.
7. Income by way of fees for technical services payable by
By
government.
A, the government. B, a person who is a resident except where the fees are payable.
Like a business or profession carried on by such a person outside India or for the purpose of making or earning any income from any source outside India. A
Or
person who is
earning
a
any
professional.
income from any source outside India.
How
or
this is
payable.
applicable?
I'll come. a person who is a non-resident where the fees are payable in respect of services utilized in a
Business or profession carried on
profession carried on
by
by
such
a such
person
person
in
in
India.
India for the purposes of making or earning any income from any source in India, provided that, then my lord, I'll come to explanation 2.
For the purposes of this clause,
Fees for technical services means any consideration, including any lump sum consideration for rendering of any managerial, technical or consultancy services, including the provision of services of technical or other personnel, but does not include the consideration for any construction, assembly, mining, or like project undertaken by the recipient or consideration, which would become the recipient chargeable under the head salaries.
this is explanation to clause 7. So you have to show clause 7 is applicable first, then you can take the matter to explanation. Explanation explains what is the principal clause. First, your case should fit into this. Then you can go to explanation. Unless you convince us that explanation itself is a substantive clause, but wrongly mentioned as an explanation to another provision. That's not your case.
Just to cut it short, this section doesn't apply.
Apply.
Why? Because, my lord, as I had said, that's why if your lordship sees the discussion in the learned single judge's order, he's gone only on the DTA provisions. We have never argued, neither side has argued
this provision.
on this, because this,
It is
even if
given
it is taxable according to this, it won't apply because the DTA provision is what we have, is more beneficial. And in terms of 90 subsection 2 of the Income Tax Act, that will take precedence. So none of this is argued and is not applicable at all. Because that's why the learned single judge goes plainly by the DTA provision.
Then, my lord, I'll stick to my lord, the authority's observation in page number 141.
Heard. Dismissed, broadly agreeing with the reasoning of the learned single judge.
But if your lordships want, I can give a, I had a submission ready, but if it's not necessary.
Just give, if you have submission, give it.
Yes, my lord.
But what I could not understand is why
Yes, ma'am.
this file became so thick when issue
lord,
is very, very
Very
pointed.
narrow, very narrow. Unfortunately, my lord, arguments went on for 3-4 days, my lord, continuously.
But generally they won't do here. They will stick to their, they will articulate the points and they will canvas and leave it.
Correct.
Lordship, my connected appeals are there, my lord. That is
How's that?
independent. I take income tax appeal, my lord, 653 and
Adu same, huh?
with your lordship, facts are similar, my lord, but I have raised other questions also, my lord.
Ah.
Your lordship, in this case, lord, the assessee in this case is a non-resident company.
My lords, I'm appearing for the respondent. I have a slight predicament my local counsel just pointed out. And otherwise, if my lords,
Yes.
if my lords are inclined to hear the matter, in this case, my lords, the findings of the tribunal.
In this one.
Yes.
All right.
They are in support of.
You share a copy.
I've given it. I've given it.
For them.
Earlier also.
I've given-
Whatever you have argued is here.
Yes, yes.
We have served him earlier also.
It's only in support of what, my lord.
Understood.
My lord, I didn't point out. This Abbey, my lord, at serial number 38 onwards are the review petition dismissals of by this court. That obviously was not there at the time the learned single judge passed the order. My lord, at page 50.
We will take up a rest of the matter some other day.
No.
Ah.
My lord, learned single judge relied on Abbey, which is a division bench judgment of this court.
The review is rejected.
The review is rejected. Those orders are there at serial number 38 of this.
So this and 38 will go together.
No. Serial number 38 of my compilation.
In your compilation.
In my compilation, this court's judgment is, well, the review is rejected, saying Centrica, which they want to rely upon, which is a Delhi High Court judgment, is different and our court's judgment is correct. Compilation.
That order you are not challenged.
No. That has
order
become
you are
final.
not challenged.
That has become final.
Which one?
Review
Abbey.
order.
Abbey review order.
Your lordship, Abbey was taken to Supreme Court.
Just see the review
At-
order at page
at-
serial number 38 of the
SL
compilation. My lord, your lordship will see the
Abbey is one which the learned single judge has followed.
followed. They, my lord, take a ground in the writ appeal before your lordships that Abbey is wrong
But Abbey was put in review.
in review and the
Review
review is dismissed. Review is dismissed. That order I wanted to just show to your lordships at page serial number 38.
Abbey was decided by Justice
division bench.
Aradesa.
That's right.
No,
No.
review was Justice by Justice P.S. Dinesh Kumar.
My lord, review is by
review
Justice
is-
Dinesh Kumar.
But Abbey was
Yes.
decided by
Arade.
Aradesa.
Justice Arade, my lord.
All right.
It's referred in the written.
And there, my lord, ground is at page 15 saying Abbey is not correct.
Your lordship, in my cases, there are two assessment years. my lord.
Other cases will decide independently.
Please,
Solve these matters, because after seeing this,
yes, ma'am.
then how far that judgment we are affirming that, but we may give additional reasons also.
Yes, ma'am. Because
That-
this
Let
is
us
appeal, my lord.
call these matters after 2 weeks, 2 weeks.
7.1 and 7.2, my lords.
Yes.
Very grateful.
Yes, thank you, Mr. Gulati. Okay, thank you. Okay.
Appear for the petitioners. But these matters arise out of execution proceedings seeking to execute, my lord, an order that has been passed by the consumer forum.
Yes.
The question, my lord, that I place for your lordship consideration is that these execution orders, in fact, travel beyond the original order. If I am right in that submission, then, my lord, all these writ petitions must be allowed.
But
That's the principal question.
just is out. Yes,
And for the home buyers.
yes. Your friends can go for a coffee round.
Oh, yes.
It will take time.
Yeah.
Yes. ವಸಂತ್ ಕಾಫಿಗೆ ಹೋಗ್ಬೇಕು ತುಂಬಾ ಹೊತ್ತಾತ್ ಕೂತ್ಕೊಂಡು. That facility we don't have. Even if Cobra comes at our feet, we have to wait till our Chamedar comes.
That is true, my lord. The doors are also closed.
For you, they are open. For us, they are closed.
Closed. That's what I'm saying.
Yes, Mr. Raghavan.
My lord, on a complaint that had been filed before the Consumer State Commission, a certain order came to be passed. The complainants, my lord, were home buyers. They alleged, my lord, that the the flats had not been completed within the time specified in the agreement, and therefore there was deficiency of service, and therefore they were entitled to certain directions, including a direction for specific performance of the contract. My lord, now your lordship may kindly say, I will not, because I am in execution, my lord, I don't have to trouble your lordships and detail your lordships on the merits of the controversy between the parties, because that will be foreign to
It will not be within
will
our.
not be within, yes. In fact, my grievance is that. My grievance, my lord, is that the execution court has gone beyond the order passed by the
Forum.
original order. However, right, wrong, or vague the original order may be, the execution court cannot even iron out the creases. If it is vague, my lord. So be it. Party will not get the benefit. Now, my lord, kindly see the order that has been passed in the original complaint, my lord, that your lordship will get it.
9984.
Yes, but my lord, may I trouble your lordship to kindly see 17,397.
ಯಾವ್ದು
181.
8.1. But ಎಲ್ಲ ಸೇಮ್, all facts are same.
Till
All
what
these
I
facts
mentioned,
same.
they're same. They're same. Please be kind enough to turn to page 142, my lord.
ಅಲ್ಲಿ ಕಾಸ್ಟಿಕಲ್
180.
ಮಾಡ್ಬೇಕು.
180.
ಕಾಸ್ಟಿಕಲ್ ಅಮೆಂಡ್ ಮಾಡ್ಬೇಕು.
One of the matters, still by one person's name was deleted. So we amended it, all of them are identical. I'll do it right now.
Minutes, I appear for the respondent number 3 minutes. They have filed a memo. Still my name is being shown in the cause list.
You are not appearing.
Manoj, we have filed wakalat. Thereafter, my lords, they have filed a memo to disarray me from the list.
You want to continue or you don't
No,
want,
minutes, no.
you don't want to continue? Name of Shri so and so to be deleted. ಆಗಿದೆಯಾ? ಯಾವುದೋ ಒಂದು ಮ್ಯಾಟರ್ ನಲ್ಲಿ ಆಗಿಲ್ಲಲ್ಲ?
8.25 minutes.
All right.
My lord, one humble submission, my lord.
Yes, sir.
My lord, I appear for respond number 2, my lords.
Ah.
We have not yet received notice in the batch of matters which have been filed in 2024. 2023, we have received notice. We are appearing for respond number.
Matters also can appear. This will permit you. All right?
Much.
Okay.
My lord, may I trouble your lordships kindly see page 180, my lord, 180. That is the order portion of the original complaint. In the original complaint.
It's 0. Ah,
All the
operative portion of.
Harassment. Yes, 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 yes. May I place it, my lord, for your lordship's consideration?
Partly allowed.
All the above complaint numbers so and so are partly allowed, directing OP numbers 1 and 2 to complete. Your lordship may mark that OP numbers 1 and 2. I was not either a OP number 1 or OP number 2. I was implicated in the execution case. That is why I point out what the controversies are partly allowed, directing OP numbers 1 and 2 to complete the construction work of each of the apartment agreed to be sold under the respective agreements, and to execute and register sale deed and also deliver possession of the respective apartment in favor of the complainant in each within 3 months from the date of this order. And further, they are also directed to provide the agreed amenities and obtain occupancy certificate from the concerned authority within the said period. If the OPs fail to complete the construction, OP numbers 1 and 2 are hereby directed to execute and register sale deed and hand over possession of property as it is, with liberty to the complainants to complete remaining construction according to the required specifications and plan in their apartments in coordination with each other. OPs shall reimburse the amount spent by each of the complainant to complete such construction. May I read this and then make my submission?
Who are you?
My lord, I am neither OP number 1 nor OP number 2. I am sought to be, I will show to you, well, just complete this reading of this directions, my lord, because today, no, my lord, what has happened is this. Now, the complainants have been given the liberty of doing it on their own.
Or through commission.
Or through commission. No objection. Let them do it. Now, what has happened, my lord, is the
Execute ಮಾಡ್ಕೊಂಬಿಡು.
ನಾವು ಮಾಡದೇ ಇದ್ರೆ ಅದು OP number 1 and 2 ಮಾಡದೇ ಇದ್ರೆ they can have recourse to this. Now, in fact, what has happened is this. I must also tell you who I am. I am sought to be made implemented a party because they say that I am a partner of OP number 1. Now the question is, can I be made a party? Divorce the terms of the documents on which I have become a partner.
ಒಂದು ನಿಮಿಷ. ನಿಮಗೆ ಸೇಲ್ ಡೀಡ್ ಬೇಕಿತ್ತು.
Yes.
ಈ ಸೇಲ್ ಡೀಡ್ ನೀವು ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡಿ.
My lord, this order which was made.
ನಿಮಗೆ ಲಿಟಿಗೇಷನ್ ಬೇಕೋ ಸೇಲ್ ಡೀಡ್ ಬೇಕೋ?
Sale deed ಬೇಕು, occupancy certificate ಬೇಕು, apartment complex completed in all aspects.
ಒನ್ ಸೆಕೆಂಡ್. ಸೊ ಫಾರ್ ಎ ಸೇಲ್ ಡೀಡ್ ಈಸ್ ಕನ್ಸರ್ನ್ಡ್ ಇದೆ ಅಲ್ಲ, ಕಮಿಷನ್ ಮುಖಾಂತರ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ರೆ ಇಮಿಡಿಯೇಟ್ಲಿ ಆರ್ಡರ್ ಮಾಡಿಬಿಡ್ತೇವೆ.
Without OC? If there is a direction to.
Complaints are also entered for damage to so and so. OPs are also to pay costs of original copy of this complete remaining construction according to required specification plan in their apartments. Each other official reimburse the amount spent by each of the complaint to complete such construction. Our simple question is, after reading yesterday night we spent time with this. How can in an execution proceedings be a person who is not a judgment debtor nominee be brought within the frame? That is the question.
Yes. Lord, the order is passed against the firm.
Correct. the managing partner of the firm has been made a party. That is OP number 2.
ಹೌದು, ಅವ್ರ ಮೇಲೆ.
The order dated 31/3/2016 has attained finality.
ನೀವೆಲ್ಲ ಪಾರ್ಟ್ನರ್ಸ್ ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ. ನಿಮ್ ತಪ್ಪಿದೆ ಫಸ್ಟ್.
Yes,
ಯಾಕೆ ಅಂದ್ರೆ ಪಾರ್ಟ್ನರ್ಶಿಪ್ ಈಸ್ ನಾಟ್ ಎ ಲೀಗಲ್ ಎಂಟಿಟಿ ಎಕ್ಸೆಪ್ಟ್ ಫಾರ್ ಅದರ್ ಪರ್ಪಸಸ್. ನೀವು ಪಾರ್ಟ್ನರ್ಶಿಪ್ ಮಾಡುವಾಗ ಪಾರ್ಟ್ನರ್ಶಿಪ್ ವಿತ್ ಪಾರ್ಟ್ನರ್ಸ್ ABCD because section 304 partnership is a relationship between the relationship between the persons who are members of the entity. ಮಾಡ್ದಂಗೆ ಇವ್ರನ್ನ ತೊಗೊಂಬಂದ್ ಮಾಡ್ತೀವಿ, ಇವ್ರಿಗೆ ಏನೇನಿತ್ತು ಡಿಫೆನ್ಸ್ ನಮಗ್ ಗೊತ್ತಿಲ್ಲ. ಅವರನ್ನು ನೀವು ಪಾರ್ಟಿ ಮಾಡಿದ್ರೆ what all defenses they would have put forth, we do not know. How can you rope in this one? This being said, this is one thing. ನಿಮ್ಗೆ ಸೇಲ್ ಡೀಡ್ ಬೇಕು, ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡಿ ಕೊಡಿ.
ಸೇಲ್ ಡೀಡ್ ಜೊತೆ ಮೈ ಪ್ರೆಡಿಕಮೆಂಟ್
ಇವ್ರ ಮೇಲೆ ಹೆಂಗ್ ಹೋಗೋರು?
ಅಲ್ಲಲ್ಲ, ಇದು ಅಪಾರ್ಟ್ಮೆಂಟ್ ಕಂಪ್ಲೀಟ್ ಆಗಿದೆ, ಪ್ರಾಜೆಕ್ಟ್ ಕಂಪ್ಲೀಟ್ ಆಗಿದೆ.
ಕರೆಕ್ಟ್, ನನ್ ಮೇಲೆ ಹಾಕ್ಲಿಕ್ಕೆ ಬರ್ತದಾ? ಪ್ರಾಜೆಕ್ಟ್ ಕಂಪ್ಲೀಟ್ ಆಗಿಲ್ಲ, ಜಸ್ಟಿಸ್ ಬಸವರಾಜು ಜಸ್ಟಿಸ್ ದೀಕ್ಷಿತ್ ಮಾಡಿಕೊಡ್ಬೇಕು ಅಂತ.
Somebody has
Where
to,
are we?
my lord, somebody has to complete the project.
Somebody means who?
Alla, the partnership, but the order is passed against the partnership.
Take out Partnership Act.
My lord, section 24, 25 and 26 of the Partnership Act, my lord. Current
The
state of the-
consistent view of the court says, where you are seeking relief against the partnership firm, all the partners should be pleaded. That's the consistent view. If there is change, I do not know. If you show one judgment, we'll change our view. We are open to change.
My lord,
also.
fact remains that there is only one managing partner of the firm who has been
ಹೋಗಿ ಅವ್ನ
made
ಮೇಲೆ.
married as a partner.
Arrest ಮಾಡಿಸಿ ಅವನು.
Alla, problem.
Direction ಇದೆ.
My lord, let me just explain the practical situation. My lord, these proceedings have been pending for over a decade. For the first time ever, my lord, before your lordships, the person who's absconding all this while appears without there being a notice. The FLWs have been issued.
I just want your lordship to know.
FLWs have been issued.
Point out to the left, not to me.
FLWs have been issued to the Commissioner of Police.
ಯಾರಿಗೆ?
ಅವ್ರ ಮೇಲೆ.
ಅವ್ರಿಗೆ ಮತ್ತೆ ಅವ್ರು.
ಈಗ ಅವರು, they have all along been watching, participating. I have not been able to execute any on one of the.
ಹಂಗಾಗಿ ನೋಡ್ರಿ,
Where is that?
ಯಾರನ್ನ ಹೆಂಗ್ ಮಾಡ್ಬೇಕು ಅಂತ ಒಂದು ಆರ್ಡರ್ ಇರುತ್ತಪ್ಪ. ಅವ್ರು ಯಾರು ಸಿಗ್ತಾ ಇಲ್ಲ, ನಾವು ದಾರಿಯಾಗಿರೋ ತಗೊಂಡೋಗಿ ಹೆಂಗ್ ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳಕ್ ಬರ್ತದ? ಯಾರನ್ನ ಹೆಂಗ್ ಮಾಡ್ಬೇಕು ಅಂತ ಹೇಳಿದ್ದಾರೆ, ಅವ್ನ ಹಿಡ್ಕೊಂಬನ್ನಿ. ಹೆಂಗ್ ಇಂಟು ದ ನಿಯರೆಸ್ಟ್
ಪೊಲೀಸ್ ಕಮಿಷನರ್ ಒಂದು ರಿಪೋರ್ಟ್ ಹಾಕಿದ್ದಾರೆ ಸ್ವಾಮಿ, ಇಂಥದ್ದು 6 ರಿಪೋರ್ಟ್.
ಇವ್ರ ಮೇಲೆ ಏನಿದೆ?
ಇವ್ರ ಮೇಲಲ್ಲ,
ಬಿಡಿ, ಮತ್ತೆ ಅವ್ರ ಮೇಲೆ
ನಾಟ್ ಇವನ್ ಅ ಪಾರ್ಟಿ, ಈಸ್ ನಾಟ್ ಇವನ್ ಅ ಪಾರ್ಟಿ ಅಂತ.
ಅವ್ರ ಮೇಲೆ ಕ್ರಾಸ್ ಕೊಡ್ತೀವಿ.
ಇಲ್ಲ, ನಾವೇನ್ ವಿ ಆರ್ ನಾಟ್ ಪ್ರಿಸಿಪಿಟೇಟಿಂಗ್.
ಹಂಗಾರೆ ಅವ್ರ ಮೇಲೆ ನೀವು ಹೋಗ್ಬೇಡ ಅಂತ ಬರೆದು ಬಿಡ್ತೇವೆ.
ಅಲ್ಲ, ಪ್ರಾಪರ್ಟಿ ಸ್ಟ್ಯಾಂಡ್ಸ್ ಇನ್ ದ ನೇಮ್ ಆಫ್ ದ ಫರ್ಮ್. ಐ ಆಮ್ ಓನ್ಲಿ ಸೀಕಿಂಗ್ ಆಕ್ಷನ್ ಅಗೇನ್ಸ್ಟ್ ದ ಫರ್ಮ್ ಅಂಡ್ ದಿ ಮ್ಯಾನೇಜಿಂಗ್.
Go against the firm and the person who is named here. Go against them. Why against? You see, this is called in English literature barking at a wrong tree ಅಂತಾರೆ ಇದಕ್ಕೆ. Though it's not happily ನಮ್ಮ ಸಂಸ್ಕೃತಿ ಹೊಂದುವಂತ ಮಾತಲ್ಲ, ಬಟ್ ಇನ್ ಇಂಗ್ಲಿಷ್ ನಲ್ಲಿ ರೆನ್ನೆನ್ ಮಾರ್ಟಿನ್ ಸೇಸ್ barking at a wrong tree ಅಂತ. ನೀವು ಯಾರ ಮೇಲೆ ಇದೆಯಪ್ಪ ಆರ್ಡರ್, ಅವ್ರ ಮೇಲೆ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡಿ.
The only problem is, apart from the firm,
ಆ ಪ್ರಾಬ್ಲಮ್ ಅವ್ರಿಗೆ ಯಾಕೆ?
manage, ಅಲ್ಲ ಅವ್ರು, I did not have an option but to seek arrest of the managing partner. ಇವರು ಇಲ್ಲಿವರೆಗೂ ಬಂದಿರಲಿಲ್ಲ ಸ್ವಾಮಿ. ಇವತ್ತಿಗೆ ಫಸ್ಟ್ ಟೈಮ್, ಅಂದ್ರೆ ಲಾಸ್ಟ್ ಹಿಯರಿಂಗ್ ಡೇಟ್ ಅಲ್ಲಿ ಫಸ್ಟ್ ಟೈಮ್ ದೇ ಅಪಿಯರ್ ಔಟ್ ಆಫ್ ನೋವೇರ್ ಟು ದ ಕೌನ್ಸಿಲ್. Now that they are on record, the other two JDRs may be.
I can make one submission in support of what my learned friend is saying. Please see page 102, my lord. Please see page 102. It will make all matters clear. My learned friend is right in what he is saying. That is why a direction was issued. Kindly see, and this has not been executed for some good reason or bad reason or indifferent reason. The Commissioner of, yes, my lord, 102. The Commissioner of Police to make best efforts to secure directors of JDR number 2, namely Mr. Avinash Prabhu and Dheeraj Prabhu, persons to be declared as proclaimed offenders. It is directed that their properties available elsewhere also must be made a subject matter of public auction to raise money required to complete the project. Counsel for JDR number 2 submit that 5 unsold in JDR number 2 could be attached. My lord, please do it.
They are already attached. 37 units have been attached way back in 2022.
Num property is attached.
This is the problem. My lord, they are claiming exclusivity. They want to say
ಅಲ್ಲಿ ನಿಮ್ಮ
that
ಪ್ರಾಪರ್ಟಿ ನಿಮ್ ಪ್ರಾಪರ್ಟಿ ಅಟ್ಯಾಚ್ ಆಯ್ತು ಅಂದ್ರೆ ನಿಮಗೆ ಪ್ರಾವಿಷನ್ ಇದೆ ಫಾರ್ ರೇಸಿಂಗ್ ಆಫ್ ಅಟ್ಯಾಚ್ಮೆಂಟ್.
Yes.
ಆ ಪ್ರೊಸೀಡಿಂಗ್ಸ್.
No, but I'll tell you, Lordship, what has happened now. There's some more development that has happened. My lord, building has been completed now at my cost. I said, in spite of whether I am liable or not, independent of all the legal issues, my lord, the building has been completed. Now, the only thing that is remaining now is occupancy certificate. Occupancy certificate also, my lord, my instructions are in 3 months, we will get the occupancy certificate.
ನೀವೇ ಮಾಡಿಕೊಟ್ಬಿಡಿ.
ಮಾರೇ ಮಾಡ್ಕೊಡ್ತೀವಿ.
ಕೇಳ್ರಿ ಇಲ್ಲಿ ಕೇಳ್ಕೊಳ್ರಿ. ಏ ಬ್ರದರ್
ಈಗ ಬಿಲ್ಡಿಂಗ್ ಕಂಪ್ಲೀಟ್ ಆಗಿದೆ.
ಏನ್ ಹೇಳ್ತಾರ ಅಂತ ಕೇಳ್ಕೊಳ್ಳಿ.
Current status of the building.
ಮನೆ ತೊಗೊಂಡರಿಗೆ 10 ವರ್ಷ ಆಯ್ತು ಮನೆ ಸಿಕ್ಕಿಲ್ಲ. ಮೊದ್ಲು ಇಲ್ಲಿ ಕೇಳ್ಕೊಳ್ಳಿ ಏನ್ ಮಾಡ್ಬೇಕು ಅಂತ ಅನ್ಕೊಂಡು. ನಿಮ್ ಕ್ಲೈಂಟ್ಸಿಗೆ ಅನುಕೂಲ ಆಗೋ ರೀತಿ ವಾದ ಮಾಡ್ರಿ. ಪ್ಲೀಸ್ ನೋಡ್ರಿ ಅವ್ರು ಏನ್ ಹೇಳ್ತಾರ ಅಂತ ಕೇಳ್ಕೊಳ್ಳಿ.
Now we have completed the construction.
Construction
at our cost. And we will get the occupancy certificate in 3 months. And sale deed also will be executed. Now what, yes, ಈಗ ಎಕ್ಸಿಕ್ಯೂಷನ್ ನಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ದಾರೆ ಅಂದ್ರೆ 1 lakh of rupees damages must be given per day. That is in the other execution proceedings ಅಲ್ಲಿ 1 lakh rupees per day damages ಕೊಡ್ಬೇಕು ಅಂದ್ರೆ ನಾವು ಕೊಡ್ಬೇಕು. ಅದನ್ನ ಒರಿಜಿನಲ್ ಆರ್ಡರ್ಲೇ ಇಲ್ಲ.
ನಿಮ್ಮವರಿಗೆ ಮನೆ ಬೇಕು, ಮನೆ ಬೇಕು, ಎಸ್ ಅಲ್ವಾ? ಮನೆ ಬೇಕು ಅಂತಾನೆ ಅವ್ರ ಕೇಸ್, ಅಥವಾ ಬೇರೆ ಕೇಸ್ ನಡೆಸಬೇಕು ಅಂತ ಮನೆ ಬೇಕು ಅಂತ ಅವ್ರಿಗೆ ಮನೆ ಕೊಡ್ಲಿಕ್ಕೆ ವ್ಯವಸ್ಥೆ ಮಾಡ್ತಾರೆ ಈಗ ಇವರು. ಆಯ್ತಾ? ಅಕ್ಯುಪೆನ್ಸಿ ಸರ್ಟಿಫಿಕೇಟ್ ಹೇಳಿದ್ರಿ, ಅದನ್ನು ಮಾಡಿಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ರಿ ಈಗ ಅವರು, ಅದನ್ನು ಮಾಡಿಕೊಡಿ. ಪಾಪ ತಗೊಂಡವ್ರಿಗೆ ಮನೆ ಸಿಗ್ಲಿ, ಹಂಗೆ ಸತ್ತು ಹೋಗ್ಬಿಡ್ತಾರೆ ಅವರು. ಕೇಸ್ ನಡ್ಸ್ಕೊತಾನೆ ಅವ್ರು ಜಡ್ಜಸ್ಗೆ ಲಾಯರ್ಸ್ಗೆ ಇಬ್ರಿಗೂ ಶಾಪ ಹಾಕ್ತಾರೆ. ಅದ್ರ ಬದ್ಲಿ ಯಾರ್ಯಾರು ಮನೆ ತಗೊಂಡಿದ್ದಾರೆ ಅವ್ರಿಗೆ ಮನೆ ಕೊಡ್ಸೋ ವ್ಯವಸ್ಥೆ ಮಾಡೋಣ. ಈಗ ನೀವು ನಮಗ ಬರ್ದ್ಕೊಡಿ, ನೀವೇನ್ ಹೇಳ್ತಾ ಇದ್ದೀರಲ್ಲ ನಮ್ಗೆ ರೈಟಿಂಗ್ ಕೊಡಿ.
But a lot these undertakings have been given to before the High Court 2 years back, 3 years back.
ಅದನ್ನ ಯಾವತ್ತು ಮಾಡಿಕೊಡ್ತೀನಿ?
Occupancy certificate has been applied for in 2020 on 2022. ಇವತ್ತವರೆಗೂ ಏನಾಗಿದೆ ಅಂತ ಇಲ್ಲಿವರೆಗೂ ನಾವು ಇಷ್ಟೇ ಕೇಳ್ತಾ ಇರೋದು. ಇವತ್ತಿಗೆ ಏನಾಗಿದೆ ಅಂತ. And my lord, I produced the photographs of the property as on today. Kindly look into page 11 of sorry. Page 11 of ಆಚೆ ಬಣ್ಣ ಬೆಳೆದು ಒಳಗಡೆ ಕಂಡೀಷನ್ ಏನು ಅಂತ ದೇ ಆರ್ ಕ್ಲೇಮಿಂಗ್ ದಟ್ ಅಪಾರ್ಟ್ಮೆಂಟ್ ಕಾಂಪ್ಲೆಕ್ಸ್.
ನಿಮ್ ಜೊತೆ ಅವ್ರನ್ನ ಯಾರ ಇನ್ನೊಬ್ರಿಗೆ ನೀವು ನೋಡ್ರಿ, ನೀವು ಅವ್ರಿಬ್ರು ಜೊತೆಗೆ ಹೋಗ್ರಿ. ಪಾಪ ಯಾರ್ಯಾರಿಗೆ ಮನೆ ಸಿಗ್ಬೇಕು, ಈ ದುಡ್ಡು ಕೊಟ್ಟಿರ್ತಾರ ಅವ್ರು, ನೀವು ಮಾಡಿಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ನೀವು, ಹೌದಾ? ಒಕ್ಕೊಂಡು ಮನೆ ಸರಿ ಮಾಡಿಕೊಟ್ಟು ಎಲ್ಲರಿಗೂ ಮನೆ ಕೊಡೋ ವ್ಯವಸ್ಥೆ ಮಾಡ್ರಿ. ಕೇಸೇ ಮುಗಿದು
And we have, and now we have spent money for all this completion of the construction, which really respondent number 2 eternity developers had to do.
ಆ 1 ಲಕ್ಷ ರೂಪಾಯಿ ಇದೆಯಲ್ಲ, ಅದನ್ನ ಮ್ಯಾನೇಜಿಂಗ್ ಪಾರ್ಟ್ನರ್ ಇಂದ ರಿಕವರ್ ಮಾಡಿ.
Lord, I would like to bring some facts.
Another submission. I mean, the predicament is not just execution of the sale deed. Now they are demanding that I have to pay escalated costs. I have paid the entire sale consideration way back in 2008.
My lord, I have done it.
He is citing interstate dispute
I have done
between
it
the
out of
partners.
any legal obligation. I just want to get rid of this litigation, therefore I have done it. I can't be penalized for my goodness. Or at least, my lord, I should be given the liberty of proceeding against eternity developers.
He is a partner, ರಿಕವರ್ ಮಾಡಿ. He is at liberty.
My lord,
ಅವರಿಂದ ರಿಕವರ್ ಮಾಡಿಕೊಟ್ರಿ.
Lord,
ಇವ್ರು ಆಲ್ರೆಡಿ ಪೇಮೆಂಟ್ ಮಾಡಿಬಿಟ್ಟಾರ. ಎಲ್ಲಿ ತರಬೇಕು ಇವ್ರ ಅಮೌಂಟ್?
They
ಆಲ್ರೆಡಿ ಪೇಮೆಂಟ್ ಮಾಡಿಬಿಟ್ಟಿದ್ದಾರೆ. ಅವಾಗ ಕೊಟ್ಟಿಲ್ಲ.
95 to 98%.
whatever is their balance
has been paid.
ಎಷ್ಟು ಅಮೌಂಟ್ ಪೇಮೆಂಟ್ ಮಾಡಿದ್ರು?
ಇಲ್ಲ, ನಾನು ಸ್ಟೇಟ್ಮೆಂಟ್ ಹಾಕಿದ್ದೀನಿ. ಇವ್ರು ಏನ್ ಹೇಳ್ತಾರೆ ಅಂದ್ರೆ, ನನಗೆ ಆರ್ಡರ್ ಗಮನಕ್ಕೆ ಬಂದಿದ್ದು ಯಾವಾಗೋ ಅವತ್ತಿಂದ ಕೋವಿಡ್ ಬಂತು, ಅದನ್ನ ಮೈನಸ್ ಮಾಡಿ ಇವತ್ತು ಎಸ್ಕಲೇಟೆಡ್ ಕಾಸ್ಟ್ ಇವಾಗ ನೀವೇ ನನಗೆ ಕೊಡಬೇಕು ಅಂತ ಲೆಕ್ಕ ಕೊಡ್ತಾರೆ. And he says, I am not bound to pay the 25,000 rupees per month.
ಕ್ವಿಕ್ಲಿ ಹೋಗಂಗಿದ್ರೆ ಅವ್ರಿಗೆ ರಿಲೀಫ್ ಕೊಟ್ಟು ನಿಮ್ ಅಲೋ ಮಾಡಿಬಿಡ್ತೇವೆ ನಾವು ರಿಪಿಟಿಷನ್. ಯಾಕಂದ್ರೆ ಕಾನೂನಲ್ಲಿ ಹೆಂಗಿದೆ, ಅವ್ರು ಏನೋ ಒಂದು ಕನ್ಸೆಷನ್ ಏನೋ ಒಂದು ಮಾಡ್ತಾ ಇದ್ದಾರೆ, ಏನೋ ಒಂದು ಮಾಡ್ಬೇಕು ಅಂತ.
ನನ್ನ ಹತ್ರ ದುಡ್ಡು ಎಕ್ಸ್ಟ್ರಾ ತಗೊಳ್ಳೋದು ಬೇಡ, ಕಂಪ್ಲೀಟ್ ಮಾಡ್ಕೊಡಿ.
no, but
ಕೊಡೋ ಅಮೌಂಟ್ ಎಷ್ಟು ಅಮೌಂಟ್ ಕೊಡಬೇಕು?
ನಾನು ಎಷ್ಟು ಕೊಡ್ಬೇಕು? ಐ ಆಮ್ ರೆಡಿ. ಎಸ್,
ಅದು ಕೊಡಬೇಕು.
ಎಸ್, ವಾಟ್ ಎವರ್ ಇಸ್ ದ ಬ್ಯಾಲೆನ್ಸ್ ಐ ವಿಲ್ ಪೇ.
Now, my lord, insofar as the cost which I have incurred for the purpose of completion, very well, my lord, I will not proceed against my learned friends' clients.
You
But
proceed.
I will proceed against eternity. And this attached, my lord, in this whole thing, 49 flats, 40 flats belong to this eternity developer, my learned friends' clients, my lord. 50, my lord, 59 flats belong to eternity developers. That should be remain attached. But that is the order now, my lord, because the flats belonging to respondent number 2.
Because the commission said you attach those properties and auction them.
I have to recover the money.
ಆಕ್ಷನ್ ಮಾಡಕ್ ಆಗಲ್ಲ ಅಂತ ರಿಪೋರ್ಟ್ ಹಾಕ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಯಾಕೆಂದ್ರೆ ಕಂಪ್ಲೀಟ್ ಆಗಿಲ್ಲ.
ಬಿಡಿ, ನಿಮ್ಗೆ ಎದಕ್ ಬೇಕ್ರಿ?
ಎಸ್
ನಿಮ್ಗೆ
ನೀವು ಅನ್ನೆಸೆಸರಿ ಟೈಮ್ ಅವ್ರಂತದ್ದು ನಾವೆಲ್ಲ ಮಾಡಿಕೊಡ್ತೇವೆ. ಯಾರ್ಯಾರು ಈ ಮನೆ ಮಾಡಿಕೊಡ್ತೇವೆ. ಈ ಅಮೌಂಟ್ ಅನ್ನು ನನ್ನ ಕೈಯಿಂದ ಮಾಡಕ್ಕಾಗಲ್ಲ. ಅಲ್ಲಿರೋ ಏನ್ ಬಿಲ್ಡಿಂಗ್ಸ್ ಇದಾವೆ ಬಿಲಾಂಗಿಂಗ್ ಟು ದಿ ಮ್ಯಾನೇಜಿಂಗ್ ಪಾರ್ಟ್ನರ್, ಅವುಗಳನ್ನು ಮಾಡಬಾರ್ದು ಅಂತ ಆರ್ಡರ್ ಇದೆ ಇಲ್ಲಿ. ಇದ್ರ ಬೆನಿಫಿಟ್ ನನಗೆ ಕೊಡಿ, ನಾನು ನಿಮಗೆ ಏನ್ ಕೊಡ್ಬೇಕು ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಅವರು. ಸ್ಟಿಲ್ ಯು ವಾಂಟ್ ಟು ಆರ್ಗ್ಯೂ? ಮತ್ತೆ
Lord, I would like to bring some facts to the attention of the court, my lord.
first let him surrender before the court. My lord, please make that an order. He is a proclaimed offender.
You are a proclaimed offender.
Yes, that's what.
No, my lord. No, my lord. I'll bring some facts to your notice, my lord.
Please come to 102.
Yes, my lord. I just read those lines, my lord.
What are the rights of the proclaimed offender? You are a proclaimed offender. You are not only offender. You are a proclaimed offender because ಈ ಮನೆ ತೊಗೊಂಡವ್ರು ಎಲ್ಲರೂ ನಿಮಗೆ ಶಾಪ ಹಾಕ್ಬೇಕು. ಅವ್ರಿಗೆ ದುಡ್ಡೆಲ್ಲ ತಗೊಂಡು ಅವ್ರ ಕೈಯಿಂದ ಹೊತ್ಕೊಂಡು ಹೋಗ್ಬಿಟ್ರೆ ಸಿಗದಂಗೆ ಇಷ್ಟು ವರ್ಷ ಏನು ಸೂಸೈಡ್ ಮಾಡ್ಕೋಬೇಕಾ ಇನ್ವೆಸ್ಟ್ ಮಾಡಿದವರು?
Lord, we have been appearing before the commission regularly, my
ಯಾಕೆ
lord.
ಆರ್ಡರ್ ಮಾಡಿದ ಈ ರೀತಿ? ಪೊಲೀಸ್ ಕಮಿಷನರಿ ಸಿಕ್ಕಿಲ್ಲ ನೀವು.
Lord, we have been representing him,
Where is your client?
my lord. Today, due to some personal
Ask him
inconveniences,
Ask him to come at 2:30 here.
my lord,
2:30 ಇರ್ಬೇಕಮ್ಮ ಇಲ್ಲಿ.
is not in station, my lords. That is the reason why I'm representing without him.
Very easy.
He has gone to Delhi in one of his national commission matters.
Ah.
So one adjournment kotra, I'll bring him before the court.
You have defrauded consumers.
My lords, that is the entire point I wanted to make, my lord. High Point Finance, the address ide, where notice has reached, that is the office of respond number 3, my lords. They can't say nಮಗೆ notice ಇರಲಿಲ್ಲ ಅಂತ.
ಇಲ್ಲ ನಿಮಗೆ.
ಗೊತ್ತು, my lord.
There is a limit for making submission, brother. You are a lawyer, you are entitled to make submission is another thing. But your client has defrauded all buyers of the house. And now weight is the sin is falling on his head. Anyway,
Lord.
Mr. Raghavan said, we'll direct his arrest and detention because
My
there is such an order now.
My lords,
Is he in Delhi commission? We'll direct the Delhi police
My
commissioner
lords,
to arrest him there.
one adjournment, my lord. Senior is not available today due to personal inconvenience. Have it next week, my lord. We'll argue the matter in detail.
Tomorrow.
My lord, my lord, kindly, my lord.
No, no.
Next week, my lord.
Call
My lord,
tomorrow for
my
further
my lord,
hearing.
my lord. I request, my lord, please, my lord.
What is that? He is an offender.
My lord, next week,
Offender
my
has
lord.
no right to come
Next
before the
next
writ
week,
court
any
at
day,
all.
my lord. Next week, any day, my
No,
lord.
no, tomorrow.
Kindly, my lord. My
Tomorrow.
lord, it's my request, my lord.
Kindly tell your client tomorrow.
My lord, senior,
Reluctantly adjourn to
senior is-
tomorrow.
senior is not available.
As senior ಇರ್ಲಿ ಅಂತಾನೆ.
My
ನಾವೇನ್ ಮಾಡಿ?
my lord, kindly, my lord. Next week, any day next week, my lord.
No, next
Date
week.
may be fixed, my lord.
No, next week. Sorry, tomorrow. The ಯಾವ respondent ಅವ್ರು?
Respondent number 2 ಅಲ್ಲ?
The second respondent name ಹೆಸರೇನು?
Eternity developers, my lord.
ಯಾರು ಅವ್ರು? ಹೆಸರು ಹೇಳಿ.
ಧೀರಜ್ ಪ್ರಭು ಮತ್ತೆ ಅವಿನಾಶ್ ಪ್ರಭು. ಧೀರಜ್
Avinash
ಪ್ರಭು,
Prabhu,
ಅವಿನಾಶ್
Dheeraj Prabhu.
Avinash Prabhu and Dheeraj Prabhu
My lord,
are directed to be personally present before this.
Next
ಏನ್
week, my lord.
ಹುಡುಗಾಟಿಕೆ ಮಾಡ್ತಾರ ಅವರು?
yeah, my lord. No, no, my lord. I'll make sure that he's present before the court, my lord. One adjournment, my lord. Next week, my lord.
Monday he should be here.
Yes, my lord.
ಕರ್ಕಳಿ. ಏನದು ಪಾಪ ಎಲ್ಲ ಇನ್ವೆಸ್ಟ್ ಮಾಡಿದವ್ರು ಏನು ಅವ್ರಿಗೇನು?
My lord, we are already 36 flats are attached, my lord. Properties are there in the name of the respond.
Insufficient. He should be arrested.
Correct.
They should be arrested.
My lord, property is already attached, my lord.
ಏನ್ ಮಾಡೋಣ ತೊಂಡು?
My lord, 36 flats na attach ಮಾಡಿದ್ದಾರೆ. ಅದು respond number 1 ಹೆಸರಲ್ಲಿ ಇರೋದು, my lord.
You understand?
Partnership firm ಹೆಸರಲ್ಲಿ ಇರೋದೇ ಪ್ರಾಪರ್ಟಿ ಇದೆ, my lord. Why can't they auction that and
Your clients are offenders.
my lord?
Your clients are offenders. They are fleeing justice. Police commissioner of the city is not in a position to arrest them. See,
Lord,
the
nothing like
enormity
that, my
of
lord.
their criminality.
They've been present before the state commission, my lord,
Yeah,
on
ಇಲ್ಲ
multiple
but-
occasions, my lord.
ಇಲ್ಲ
I have represented them before the state commission as well. My lord, kindly, my lord. Next Monday, I will make sure that he's present.
directed to be personally present before the court,
On 19th,
failing which
19th.
their arrest and detention may be ordered. Call this matter on
19th.
19th
Much
for
obliged.
further hearing.
Yes.
ನಿಮ್ಗೆ ಇದು ಇದೇನು ಎಂಟ್ರಿ ಮಾಡಿದೇನು?
ಇದೆ.
ಎಂಟ್ರಿ ಮಾಡ್ತೀವಿ. Okay. Yes.
That
Next
interim
date ಗೆ.
That interim order is being taken care of, saying, oh, interim order there, therefore even this commissioner cannot do anything anta.
No, that's all right. Now, you have said,
Yes.
Mr. Raghavan, Learned Senior Advocate appearing for the petitioners on the instructions of the counsel on record standing beside him, submits and undertakes that the his client, the petitioner would be accomplishing the task in terms of the commission's order minus the requirement of making payment of damages quantified at rupees 1 lakh per day.
That is in the execution, in the order 10,000 rupees.
Per day and
10,000
rupees
rupees.
10,000 as well in the execution proceedings. First up. He also submits that the petitioner would execute and register a regular sale deed in favor of the consumers. Complainants. Within what period you are doing it?
The occupant certificate, my instructions are in 3 months they will get it.
3 months.
Sale deed, we can execute it right away.
Yes, you
Occupancy
execute it.
Occupancy certificate 3 months.
No, that's clear ಮಾಡಿಬಿಡ್ತೇವೆ ನಾವು ಮೊದಲು ಸೇಲ್ ಡೀಡ್ ಕೊಡಿ ಅವರಿಗೆ.
Master.
ಅದು
And
sale deed.
balance consideration to be paid to us.
Huh?
And whatever is the balance should be paid to us.
On the payment of the balance of consideration by the consumers.
Yes.
Consumers. First up. ನೀವು ಅದನ್ನ ಬ್ಯಾಲೆನ್ಸ್ ಕೊಟ್ಕೊಂಡು ಮೊದಲು ಸೇಲ್ ಡೀಡ್ ಮಾಡಿಸಿ ಎಲ್ಲರಿಗೂ.
Yes, madam.
ಮತ್ತೆ ಅವರು ಮಾಡ್ದಂಗೆ ಆಗತ್ತೆ. ಗೊತ್ತಾಯ್ತಾ? ಇವೆಲ್ಲ ಶುಭಸ್ಯ ಶೀಘ್ರಂ ಇದು. ಮೊದಲು ಸೇಲ್ ಡೀಡ್ ಸಿಗ್ಬೇಕು ಎಲ್ಲರಿಗೂ ಅವರಿಗೆ. ಎಷ್ಟು ವರ್ಷ ಅವ್ರಿಗೆ ಎಷ್ಟು ವರ್ಷದ ಕೇಸ್ ಇದು?
ಇದು
2013
2014
complaint.
10 ವರ್ಷ ಆಯ್ತು.
Complaint
2013.
Entire sale consideration was paid way back in 2008.
ಯಾರು ಸತ್ ಹೋಗಿಲ್ಲ.
ಇದೆ.
ವಾಟ್ ಕೈಂಡ್ ಆಫ್ ಥಿಂಗ್ಸ್ ಆರ್ ಹ್ಯಾಪನಿಂಗ್? ಆ ಕಾರಣಕ್ಕೆ ಜುಡಿಷಿಯರಿ ಮೇಲೆ ಎಲ್ಲರಿಗೂ ಸೆಟ್ಟು 10 ವರ್ಷ ನಾವು ಜಗ್ತೇವೆ ಅನ್ನೋದಕ್ಕೆ. ಸ್ವಾಮಿ,
I'm told, my lord, for purpose.
ಪೇಮೆಂಟ್
I have one request, madam.
ಪೇಮೆಂಟ್
My lord, ಎಷ್ಟು ಕೊಡಬೇಕು ಏನು ಅನ್ನೋದು
ನೀವು
ಡಿಬೇಟಬಲ್.
ಎಷ್ಟು
ಅಲ್ಲ, ನನ್ನ ಪ್ರಕಾರ ನಾನು ಮೆಮೋ ಆಫ್ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಕಮಿಷನ್ ಮುಂದೆ 3 ವರ್ಷದಿಂದ ಹಾಕಿದ್ದೀನಿ.
ನೋಡ್ಬೇಡ.
ಈಗಲೂ ಕೊಡ್ತೀನಿ.
ಕೊಡಿ.
ಈಗಲೂ ಕೊಡ್ತೀನಿ. ಬಟ್
ಕೊಟ್ರೆ ನಾನು-
ದೇ ಶುಡ್ ನಾಟ್ ಕ್ಲೇಮ್ ಅಡಿಷನಲ್ ಇಂಟ್ರೆಸ್ಟ್. ನಾ ಕೊಡ್ತೀನಿ, ಇವತ್ತೇ ಕೊಡ್ತೀನಿ.
ನೀವು
ಅನಾವಶ್ಯಕ ಮಾತಾಡಬೇಡಿ, ಕೊಡಿ.
Yes,
ಕೊಡಿ ಈಗ.
ರೈಟ್ ಮಾಡಿ.
ಶೇರ್ ಇಟ್ ನೌ. ಐ ಆಮ್ ನಾಟ್ ಅಜರ್ನಿಂಗ್ ದ ಮ್ಯಾಟರ್.
ಈಗಲೇ ಕೊಡ್ತೀನಿ. I do not have it right now, but I will give it right.
ಕರೀರಿ, ನಿಮ್ ಕ್ಲೈಂಟ್ ಯಾರಿದ್ದಾರೆ?
Yes. ಇದೆ, I have the calculation.
ಎಲ್ಲ ಪೇಮೆಂಟ್ ಚೆಕ್ ನಿಂದ ಆಗಿರತ್ತೆ. ಇದೇನು
Yes.
ಇದರಲ್ಲಿ ಆಗಿರಲ್ಲ. ಚೆಕ್ ಅಮೌಂಟ್ ನಿಂದ ಆಗಿರತ್ತೆ. ಅದ್ ತೋರಿಸಿ ಎಷ್ಟು ಕೊಡ್ಬೇಕು ಅಂತ. ಏನ್ ಅಮೌಂಟ್ ಇದು ಇದೆ ಅವ್ರಿಗೆ ನೋಡ್ರಿ. ಈಗ ಎಷ್ಟು ದಿವಸದಲ್ಲಿ ಮಾಡ್ಕೊಡ್ತೀರಿ ಸರ್ ನೀವು?
Malad, I'm told, Malad, they have to get e-khata.
ಹಾ.
E-khata will take how long, sir? Malad, e-khata ಮಾಡ್ಸಿದ್ರೆ register ಮಾಡಲ್ಲ. There's some procedure that I have introduced now called e-khata. Without e-khata, Malad, registration cannot take place. Therefore, Malad, e-khata will take about a month. About a month. Immediately after that, we'll do it.
ಈ
Draft sale deed, everything we'll send it to them. No difficulty.
ಅದ್ನ ವಿದಿನ್ 1 ವಾರದಲ್ಲಿ ಕಳಿಸ್ಬೇಕು ನೀವು. ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಆಫ್ ಹಿಯರಿಂಗ್ ಆಗೋದ ಕಳಿಸ್ಬೇಕು.
19th ಒಳಗೆ ಕಳಿಸ್ಬಿಡ್ತೀವಿ ಅವ್ರು.
He also submits that he would secure the e-khata in respect of the subject properties, since it is a precondition
For registration.
for execution and registration of execution ಮಾಡಿ. Registration ಆಮೇಲೆ ಮಾಡಲಂತೆ. Execution ಮಾಡಿ ಕೊಟ್ಬಿಡಿ. ಕೊಟ್ಟೆಲ್ಲ ಸೇಲ್ ಡೀಡ್ ನಮ್ಗೆ ತಂದು ಕೊಡಿ.
We'll do the execution also.
ಮುಂದೆ ರಿಜಿಸ್ಟ್ರೇಷನ್ 4 ತಿಂಗಳು ಇರ್ತದೆ. ನಾವು we will extend the time also ಅದ್ರ ಮೇಲೆ. ನಮ್ಗೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್
19th ಹಾಕ್ಬಿಟ್ರೆ ನಾವೆಲ್ಲ ಮುಗಿಸ್ಬಿಟ್ಟು
ಎಲ್ಲ ಸೇಲ್ ಡೀಡ್ ತಂದು ಕೊಟ್ರಿ ನಮ್ಗೆ ಕೊಟ್ಟು.
ಖಂಡಿತ
ನಮ್ ಕೈಲಿರ್ಲಿ. we will hold those sale deeds as trustees of consumers.
No difficulty.
ಅವ್ರಿಗೆಲ್ಲ ನಂಬಿಕೆ ಇದೆಯಾ ನಮ್ಮ ಮೇಲೆ? ನಾವೇನ್ ಸೇಲ್ ಡೀಡ್ ತಗೊಂಡು ಓಡಿ ಹೋಗಲ್ಲ. ಇವ್ರ ಕ್ಲೈಂಟ್ ಓಡಿ ಹೋದಂಗೆ. ಬಟ್ ಡ್ರಾಫ್ಟ್ ಸೇಲ್ ಇದು ಡ್ರಾಫ್ಟ್ ಅಲ್ಲ, ಎಕ್ಸಿಕ್ಯೂಷನ್ ಆಫ್ ದ ಸೇಲ್ ಡೀಡ್.
ಸೈನ್ ಮಾಡಿ ಕೊಟ್ಬಿಡ್ತೀವಿ.
ಸೈನ್ ಮಾಡಿ
ಮಾಡ್ಕೊಡ್ತೀವಿ.
ಎರಡೂ ಸೈಡ್ ನೋಡು ಸೈನ್ ಮಾಡಿ ಕೊಟ್ಬಿಡಿ.
ಕೊಡ್ತೀವಿ.
The original executed sale deed shall be filed by the parties on the next date of hearing with the registrar general of this court, general of this court, in a sealed cover. ಕೋರ್ಟ್ ಅಷ್ಟೇ, ಕೋರ್ಟ್ ಯಾಕಂದ್ರೆ ನೋಡ್ಕೆ ಹೋಗಕ್ಕಾಗ್ತದೆ ಯಾವ್ದು ಕೊಟ್ಟಾರೆ ಯಾವ್ದು ಕೊಟ್ಟಿಲ್ಲ ಅಂತ. ಫಸ್ಟ್ the respondent consumers complainants shall fully cooperate in this direction. First off, if the payments dues are not met, comma, such a sale deed shall not be sent for registration. Registration ಕಳ್ಸಲ್ಲ. ಮೊದ್ಲಿಗೆ ಎಲ್ಲರಿಗೂ ಸೇಲ್ ಡೀಡ್ ಸಿಗ್ಬೇಕು, ನಮಗ್ ತಂದು ಕೊಡಿ. ಪಾಪ ಎಷ್ಟು ಬಡವರು ಎಷ್ಟು ಏನೇನಾಗಿರುತ್ತೆ ಎಲ್ಲರಿಗೂ.
Yes, we'll do it.
All right.
ಇದು even your lordship may just, this is
ಈಗ ಇದನ್ನ ಈ ಪ್ರಕಾರ
legal
ನಮಗೊಂದು ಅಂಡರ್ಟೇಕಿಂಗ್ ಹಾಕಿ.
ಹಾಕಿ.
ಈಗಲೇ ಹಾಕ್ಬಿಡಿ.
ಹಾಕಿ.
An undertaking to this effect is filed by the petitioner and also learned counsel appearing for
The consumers.
the consumers. First off, next part. The
without
submission
prejudice to
of
our legal rights.
the submission of learned senior advocate Mr. Raghavan that his client should be permitted to proceed against the managing partner,
Avinash Prabhu and Dheeraj Prabhu.
namely Avinash Prabhu and Dheeraj Prabhu, and that Prabhu shall be considered on the next date of hearing. First off, however, both they are directed not to alienate or encumber any of the flats.
ಯಾರು ಇಲ್ಲ ಮಾಡಲ್ಲ. ಅವ್ರಿಗೆ they are entitled to the 29 flats, 29 complaints ಅವ್ರಿಗೆ ಕೊಡ್ತೀವಿ. 24,
But there are
24.
99 units. Out of them, 55 are allotted
55
to,
are
55 are
ಸರಿ
sold.
ರೀ, ನಿಮ್ ಕ್ಲೈಂಟ್ ಯಾರೋ ಇದ್ದಾರೆ, ಬನ್ರಿ. ಏನೋ ಹೇಳೋದಿದೆ, ಬನ್ನಿ. ಏನೋ ಹೇಳಿ. ಕಂಪ್ಲೇನೆಂಟ್ಸ್
24 flats, 24 complaints.
ಎಷ್ಟು ಜನರಿಗೆ ನೀವು ಮಾಡಿಕೊಡೋದು ಈಗ?
55
ಸೇಲ್ ಡೀಡ್ ಎಷ್ಟು ಜನರಿಗೆ
24
ಮಾಡಿ?
ಅದೇ.
Allot
ಅದೇ,
24 complainants.
25.
55 units are sold.
units have been sold.
Totally 55 units.
55.
Yes.
ಕರೆಕ್ಟಾ?
So all 55.
55
Malad, that's.
ಮಾಡಿಕೊಡಿ.
Malad, ನಮ್ಗೆ, let me make it clear, Malad.
This is, we
No
understand.
intention of doing anything
We have
not
understood.
according to the righteousness.
We have understood. Though you were not
Legally
bound by,
liable.
that's what. Still, now you said that
Exactly.
but
Now,
they should not be made to suffer.
I,
Anyway, ನಿಮ್ಗೆ ಏನು ಅಮೌಂಟ್ ಬರಬೇಕು ಆ ಅಮೌಂಟ್ ಅನ್ನು ರಿಕವರ್ ಮಾಡಿಕೊಳ್ಳಿ, ಮಾಡಿಕೊಂಡು ಅದನ್ನ ಮಾಡಿಕೊಡಿ. ಸರಿನಾ?
ಸ್ವಲ್ಪ ಕಾಲಾವಕಾಶ ಅಮೌಂಟ್ ರೆಮಿಟ್ ಮಾಡಕ್ಕೆ. ಅಮೌಂಟ್ ರೆಮಿಟ್ ಮಾಡಕ್ಕೆ ಒಂದು ಸ್ವಲ್ಪ ಕಾಲಾವಕಾಶ.
ಲೇಟ್ ಮಾಡ್ಕೋಬೇಡಿ.
ಅಲ್ಲ ಇಮಿಡಿಯೇಟ್ಲಿ.
ಅಲ್ಲ, ಸೇಲ್ ಡೀಡ್ ಆಗಿ
ಮೊಬಿಲೈಸಿಂಗ್.
ಸೇಲ್ ಡೀಡ್ ಮಾಡಿ ಕೊಟ್ಬಿಡ್ರಿ.
Yes.
ಮುಂದೆ ರಿಜಿಸ್ಟ್ರೇಷನ್ ಕಳಿಸುವಾಗ
Before registration.
ಸೇಲ್ ಡೀಡ್ ರಿಜಿಸ್ಟ್ರೇಷನ್
Yes.
so that it will be justice to them. Otherwise ಬೇರೆ ಕೇಸ್ನೇ ಹೋಗ್ತದೆ. Let them hold sale deed first.
tell you the one you sent.
ಮಾಡ್ಕೊ.
29 people. 29 complaints, 24 complaints.
ಎಷ್ಟು sale deeds ಇವು?
But I'm told there will be 24 sale deeds in
There will
respect
be 24 sale deeds
24
in
sale
respect
deeds.
of 59 units.
of 55.
24 complainants ಇದರಲ್ಲಿ.
ಇದರಲ್ಲಿ
But in total sold are 55 units.
Yes, yes.
So
please
sale
don't
need to be
talk about that. My
executed in
instructions
respect of 55 units.
54 ಜನರಿಗೆ 55 units ಸೇಲ್ ಮಾಡ್ಯಾರ.
55 ಜನಕ್ಕೆ 55 units.
ಸ್ವಲ್ಪ ಜನ.
Separate consumer complaint.
ಈ ಕೋರ್ಟ್
ಬಿಡಿಯಪ್ಪ. Malad, in respect,
Yes,
don't
yes.
worry about it.
wait 1 second, he wants to say something.
There are still 5 complaints. Let them-
There is nothing.
No, we are only doing only for these complainants.
Out of 55, 59, 55 have been sold. Of those 55, 24 complainants have come forward.
So therefore,
Not sold a single unit, all units are sitting with us, but now attached by the.
now therefore, my lord, the two submissions I want to make, those who are before your lordships are 24 in number. My learned friend is referring to those who do not have an order in their favor today. We'll keep them aside if and when it happens, my lord, we will take care of that. Today, we will solve the problem of these 24 people who are before your lordship.
ಅವ್ರಿಗೂ ನೋಡಿ, 227 ದಲ್ಲಿ ಇದೀರಿ ನೀವು. ಅವ್ರಿಗೆ ಮತ್ ಬಂದ್ಕೊಂಡು ಅವ್ರಿಗೂ ಸಹ ಜಸ್ಟಿಸ್
ಬರ್ಕೊತೀರಾ?
ಅವ್ರಿಗೂ justice ಆಗ್ಬೇಕು.
Then your lordship
ಅವ್ರು
said-
ಬರ್ಲಿ ಬಿಡ್ಲಿ,
Ah.
ಅವ್ರಿಗೂ ಸೇಲ್ ಡೀಡ್ ಮಾಡಿ 227 ಇದು.
Okay.
ಹಾ,
But there are
subject to this one only.
No, madam, there are only sub issues. Now, my lord, according to us, we have come, now according to the order passed by the Consumer Commission, if the buildings are not completed by OP numbers 1 and 2, and we are neither OP number 1 nor OP number 2,
Commission
independent of
can
the
execute
commission,
ಅಂತ.
the expenses shall be recovered from OP number 2. Now, my lord,
You recover that.
exactly,
We permit you.
exactly,
ಬರ್ಕ ಅಷ್ಟೇ.
exactly.
ಬರ್ಕೊಳ್ಳಿ.
Please permit me to recover from Avinash Prabhu and the.
ಅದನ್ನ ಅವ್ರು ಹಿಯರ್ ಮಾಡಿದ್ನ
Yes,
ಕನ್ಸಿಡರ್.
my lord. Yes, my lord. Next date of hearing.
ಬಟ್ ಇದು ಇದರಲ್ಲಿ ಇದನ್ನ ಏನು ಸೇಲ್
Here,
ಡೀಡ್
man, here, man.
ಸೇಲ್ ಡೀಡ್ ಯಾರ್ಯಾರಿಗೆ ಮಾಡಿ ಕೊಡ್ತೀರಿ?
Now we will execute a sale deed not only in favor of this 20.
ಎಲ್ಲರಿಗೂ ಕೊಡ್ಬೇಕು, ಇಲ್ಲಿ ಇಲ್ದವ್ರಿಗೂ
everರಿಗೂ ಮಾಡ್ಕೊಟ್ಬಿಡ್ತೀವಿ.
ಎಲ್ಲರಿಗೂ ಮಾಡಿಕೊಡ್ಬೇಕು.
And I'm told, Bharat, those remaining people, 24, this 55 minus 24, have filed separate consumer complaints which are now pending. ಅದು ಮುಗಿದೋಗುತ್ತೆ.
ಅದು ಮುಗಿದು ಹೋಗ್ತದೆ ಅವ್ರಿಗೆ.
But ಅದು ಅವರು ಬರ್ಬೇಕಲ್ಲ, ಒಪ್ಪಬೇಕಲ್ಲ ಅವರು.
ಯಾರು?
ಅವ್ರು ಬಂದು ತಮ್ಮ ಮುಂದೆ ಈ
if so ನೋಡಮ್ಮ, if so far as the complainants are concerned. However, if other consumers who have been prosecuting the execution proceedings,
no, they have been prosecuting original complaints only.
original proceedings or execution proceedings, if they come forward for making the remainder of the payment, comma, the sale deed shall be executed in their favor also.
Yes.
First off, registry shall send a copy of this order to the registrar of ಯಾವ consumer forum ಅದು?
State Consumer Commission.
No, before district forum. We give the addresses get the addresses of all those consumers.
ಅಲ್ಲಿ ಒಚ್ಕೊಡಿ. The registry to send a copy of this order by speed post to the list of consumers to be furnished by counsel on record appearing for the petitioner.
In fact, can I make it a little easier, my lord? Instead of burdening the registrar of this court, tav ye order kotre, your lordship may direct my learned friend to issue notice to each of them because we have their addresses. Because we are the respondents.
ನಮ್ ಕಡೆಯಿಂದ ಆಗಿ, ನಮ್ ಕಡೆಯಿಂದ ಸ್ವಲ್ಪ ರೆಗ್ಯುಲಾರಿಟಿ ಇರ್ತದೆ. ಏನಾಗ್ತದೆ, ಅವರೆಲ್ಲ ಪಾಪ ಹೆಲ್ಪ್ಲೆಸ್ ಇರ್ತಾರೆ, ಅಮೌಂಟ್ ಎಲ್ಲ ಹಾಕಿರ್ತಾರೆ.
ನಿಜ, ನಿಜ.
ಎಲ್ಲರಿಗೂ ಮನೆ ಸಿಗ್ಬೇಕು.
My lord, there is no, my lord, we have nothing.
One humble submission. My lord, the Resident Welfare Association and its office bearers are also party. They are present. There are 4 individual complaints that are filed before the district commission. I am representing all the complaints. The others have not yet filed because they had approached the RERA. RERA said, no, we don't
ಎಲ್ಲ
have
ಕನ್ಸ್ಯೂಮರ್ಸ್
jurisdiction.
ಅಂತ ಹೇಳ್ತಾರೆ.
We will communicate.
ಎಲ್ಲ ಕನ್ಸ್ಯೂಮರ್ಸ್ ಎಲ್ಲೆಲ್ಲಿ ಮಾಡ್ಕೊಡ್ಲಿಕ್ಕೆ ಮಾಡ್ಕೊಡಿ.
ಮಾಡ್ಕೊಡ್ತೀವಿ.
ಆದ್ರೆ ಪೇಮೆಂಟ್ ಮಾಡ್ಬೇಕು.
Yes.
ನೀವು ಅವ್ರನ್ನ ಪಾರ್ಟಿ ಮಾಡ್ದಂಗೆ ಇದೇನೋ ಪಾಪ ಒಂದು ಕನ್ಸೆಷನ್ ಮಾಡ್ತಾ ಇದಾರ ಅವರು. ದಿಸ್ ಇಸ್ ಅನ್ ಅಪ್ರಿಷಿಯೇಬಲ್ ಥಿಂಗ್. ರಿಯಲಿ ಅವ್ರೆಲ್ಲರಿಗೂ ಯಾರ್ಯಾರಿಗೆ ಮಾಡ್ಕೊಡ್ಬೇಕು ಮಾಡಿಕೊಟ್ಟು ಬಿಡಿ. ಅದರಲ್ಲಿ ನೀವು ಒಂದು ಕೆಲಸ ಮಾಡ್ರಿ, ಆ ಡ್ರಾಫ್ಟ್ ಸೇಲ್ ಡೀಡ್ಗಳನ್ನ ಎಲ್ಲವನ್ನು ತೊಗೊಂಬಂದ್ಬಿಡಿ ಇಲ್ಲಿ ಕೋರ್ಟಿಗೆ. ಇಲ್ಲಿ ನಮ್ಮ ರಿಜಿಸ್ಟ್ರಾರ್ಗೆ ಒಂದು ಚೇರ್ ಹಾಕಿ ಇಲ್ಲಿ ಕುಡಿಸ್ತೇವೆ ನಾವು. ಕುಡಿಸಿ ಇಲ್ಲೇ ಅವೆಲ್ಲವನ್ನು ಎಕ್ಸಿಕ್ಯೂಷನ್ ನಮ್ಮ ಕೋರ್ಟ್ನಲ್ಲಿ. ನಂತರ ವಿ ವಿಲ್ ಸೆಂಡ್ ದೆಮ್ ಟು ದಿ ಸಬ್ ರಿಜಿಸ್ಟ್ರಾರ್. He should simply execute, register them after receiving the stamp duty, etc. And sale deed should be granted to each of them.
ಈ ಖಾತಾ ಬರಲ್ಲ, ಅಷ್ಟೊಂದೇ ಪ್ರಾಬ್ಲಮ್ ಇದೆ. ಅದೊಂದು ಬಾಟಲ್ ನೆಕ್ ಇದೆ ಈಗ for some time because
ಯಾರು ಕೊಡಬೇಕು ಈ ಖಾತಾ?
Corporation or BBMP or out, they are still setting up the system, my lord. It has nothing to do with the.
We'll get that.
Help others.
ಅಲ್ಲೇ
We will follow it up. We will follow it up. We are interested in ensuring that they get it.
The authorities in the BBMP shall are hereby directed to accomplish the entire task of granting e-khata in respect of the subject property on the production of a copy of this order,
yes,
as if they are parties to the same, provided that the requisite information, records and payments in that regard are remitted. First, it is made clear that the violation of this order may result into arrest and detention of the concerned authorities. Okay.
The
Well,
last
one application is already pending.
all that I have
I
said.
have filed one application to implead Commissioner, Chief Commissioner BBMP in 10069. ಅದನ್ನ ಮಾಡ್ಬೋದು, ಇಲ್ಲ ಅಂತಾರೆ they can follow.
Commissioner of BBMP na?
Yes.
Alle,
In writ petition 10069.
the petitioners are directed to array the Commissioner of BBMP as the respondent. No, we are directing it. We want that as respondent now in all these petitions. As respondent, Shri Yaro, panel councillor, BBMP, Pawan Kumar, Allah, BBMP yaru, Yaram, Shri K. Krishna, learned senior, illa, BS Karthikeyan, learned panel council is requested to accept notice for the BBMP and alnodi innond barke hogu BBMP nodal officer of BBMP na. Nodal officer of BBMP as respondents. See, Karthikeyan is requested to accept notice for these respondents, newly added respondents. petitioner to serve copy of the petition along with all the documents on the panel council. First, call this matter for further hearing on 19th.
19th.
On 19th.
Last submission. My lord, all that I have said today is without prejudice to my legal rights. So that it should not be said that I have given up any of my contention in the event, my lord, that there is any problem with respondent number 2. I do not want them to come and tell your lordship, they have missed the bus, water flown under the bridge. Therefore, none of the legal contentions survive for consideration in the held court. That is all my concern, my lord. I want to place it for your lordship's consideration. That all that I have said today is without prejudice to my legal rights and contentions. I will do it. Now, undertaking ಕೊಡ್ತೀನಿ. But it should not be that I have waived my right ಅಷ್ಟೇ. Against respondent number 2. ಅಷ್ಟೇ ನನಗೆ ಬೇಕಾಗಿರೋದು.
We have noted that the obligation undertaken by the petitioners to the court and also to the consumers who are parties before, parties here and who are not parties also shall be without prejudice to the right of the petitioner to proceed against
Respondent number 2.
the managing directors mentioned above.
Yes, ma'am. Great. That's all.
Mentioned above.
Great.
Subject to all just exception.
Yes, of course. Of course. Yeah. Grateful.
All. Thank you. ಬರೀ ಕಾಸ್ಟ್ ಟೈಟಲ್ ಅಮೆಂಡ್ ಮಾಡ್ಕೊಂಡು ಹೋಗ್ಬೇಕು ಎಲ್ಲ ಮಾಡಿ ಅವ್ರಿಗೆ ಕಾಪಿ ಕೊಟ್ಟು
ಎಲ್ಲ ಡೀಟೇಲ್ಸ್ ಎಲ್ಲ ಕೊಟ್ಬಿಡ್ತಾರೆ. ಕನ್ಸ್ಯೂಮರ್
ಎಷ್ಟು ಜನರಿಗೆ ಇಬ್ರೆ ಎಲ್ಲ ದುಡ್ಡು ತಗೊಳ್ಳೋದು, ಸೈಟ್ ಕೊಡಂಗಿಲ್ಲ, ಬಿಲ್ಡಿಂಗ್ಗಳನ್ನ ಕೊಡಂಗಿಲ್ಲ, ಅವ್ರನ್ನ ಫಿಸಿಕಲಿ ಅವರನ್ನ ಹಾರ್ಮ್ ಮಾಡೋದು, ಹೆದರ್ಸೋದು, ಇದೇ ರೀತಿ ನಡೆದಿದೆ ಎಲ್ಲ ಬೆಂಗಳೂರಲ್ಲಿ. ಎಷ್ಟು ರಿಪೋರ್ಟ್ಸ್, ಎಷ್ಟು ಸೋ ಮೆನಿ ಲೆಟರ್ಸ್ ಆರ್ ರಿಟರ್ನ್ ಟು ಇಂಡಿವಿಜುವಲಿ ಟು ದ ಜಡ್ಜಸ್. ಈ ರೀತಿ ಮಾಡ್ತಾ ಇದಾರೆ ಅಂತ. ಹೆಲ್ಪ್ಲೆಸ್ ಇರ್ತಾರ ಅವ್ರು. ಎಲ್ಲ ನಿಮ್ ಕ್ಲೈಂಟ್ ಇದ್ದಂಗೆ ಇರ್ತಾರಂತ ಇಟ್ಕೋಬೇಡಿ. There are good people, there are bad people, even in the heaven.
And the only benefit will be that we don't know who is there, who is not in heaven.
Next matter, next matter, I have to just sign the paper, I'll just sign.
ಯಾವ್ದು?
Next matter.
ಹಾ.
They promised to cure the defect, I have to just sign.
ಅಲ್ಲಿ ನೋಡಿ.
With my lords, kindly, my lord.
Counsel
Serial number 38, my lord, was mentioned in the morning, my lord. My apologies, my lord. My
ಡೇಟ್ ಚೇಂಜ್ ಮಾಡ್ಬೇಕು ಅಂತ ಹೇಳಿದ್ರಲ್ಲ.
My lord, 27th or my lord, or 21st, my lord, if it's possible.
ಸೈನ್ ಆಗಿದೆ ಏನದು? ಯಾವ್ದೋ ಒಂದು ಹೇಳಿದ್ರಲ್ಲ ಅವರು ಡೇಟ್ ಏನೋ 99 ಹೇಳಿದ್ರಲ್ಲ ನೀವು, ಆಗಿಲ್ವಾ? ನೋಡಿ ಅವ್ರಿಗೆ ಯಾವ ಡೇಟ್ ಬೇಕು ಆ ಡೇಟ್ ಹಾಕು.
Please.
One matter, RFM,
ಏನು?
RFM, it has been reserved for judgment.
ರಿಸರ್ವ್ ಫಾರ್ ಜಡ್ಜ್ಮೆಂಟ್.
ನಾವ್ ಹೇಳಿದ್ರಿ ಸೆಟಲ್ ಮಾಡೋದು ಮಾಡ್ಕೊಳ್ಳಿ ಅಂತ.
ಮಾಡ್ಕೊಳ್ಳಿಲ್ಲ.
ಸೆಟ್ಲ್ ಆಗಿದೆ.
ಸೆಟ್ಲ್ ಆಗಿ ಹೋಗ್ಬಿಟ್ರಿ. ನಾವು ಅದೆಲ್ಲ ಜಡ್ಜ್ಮೆಂಟ್ ರೆಡಿ ಆದ್ಮೇಲೆ ಸೆಟ್ಲ್ ಆಗಿದೆ ಅಂತ.
20 ಲಕ್ಷಕ್ಕೆ ಸೆಟ್ಲ್ ಮಾಡ್ಕೊಂಡು ವಿಲ್ ಪೋಸ್ಟ್ ಆದ್ರೆ
ಇವರು ಹುದ್ದಾರ್ ಸಾಹೇಬ್ರನ್ನು
ಅಲ್ಲ, ಇವರು ಜಸ್ಟಿಸ್
ನಮ್ಮ ಪುನಚ್ಚ ಸಾಹೇಬ್ರ. ಪುನಚ್ಚ ಅವ್ರು ಇಲ್ಲೇ ಇರ್ಬೇಕು. ಇಲ್ಲೇ ಇರ್ತಾರಲ್ಲ ನೋಡ್ರಿ.
ನಂಬರ್ ಕೊಡಿ.
My lord, serial number 11. 2 weeks time, my lord.
2 weeks.
Please,
ನೋಡಿ.
small corrections to be made.
Time ಬೇಕು.
Compliance.
Serial number 14, 18, please, my lords. There's some of subjection, my lord, that cleared during the course of the day, my lords. There's some urgency, my lords. Could I request for tomorrow, please?
Why tomorrow? ಮಧ್ಯಾಹ್ನ ನಾವು ಕುಡಿದ್ ಬೇಡವಾ?
Very well.
ಮಧ್ಯಾಹ್ನ ಮನೆಗೆ ಹೋಗೋರು ಹೋಗ್ತೇವೆ ನಾವು ಖುಷಿಯಿಂದ. ಮತ್ ಬೇರೆ
No, my lords. Since there are objections, my lords, I didn't want it to be defective, my lords.
ನೋಡಿ ಅಬ್ಜೆಕ್ಷನ್ ಒಂದೇ ರಿಪೇರಿ ಮಾಡಿ.
My lords, serial number 14, my lords.
The 2 weeks time, my lords.
ಯಾಕೆ ಏನು? ಯಾವ ಇಯರ್?
Reach 2024.
24.
It has to come with tag matters. The list has been
Call
provided.
this matter along with.
ಕೊಡ್ತಾರೆ. ಇಲ್ಲ, ಲಿಸ್ಟ್ ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರು ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಅವರು. ಐ ಆಮ್ ಫಾರ್ ದ ರೆಸ್ಪಾಂಡೆಂಟ್. ದೇ ಸೆಡ್ ದೇ ವಿಲ್ ಬಿ ಪ್ರೊವೈಡಿಂಗ್.
ಕೊಡ್ಬೇಕು, ಲಿಸ್ಟ್ ಕೊಡ್ಬೇಕಲ್ಲ.
ಐ ವಿಲ್ ಎನ್ಶೂರ್ ದಟ್ ಇಟ್ಸ್ ಗಿವನ್.
ಓಕೆ.
37, serial number 37 B group. Week after next.
Week after next. He sensed it is not possible to sit in the afternoon. Sorry. ವಸಂತ್ ಅವ್ರು ನೋಡಿ ಯಾವ್ದೋ ಒಂದು ಡೇಟ್.
Serial number 30. Transcribed matter. The direction issued by this honorable committee, my lord, the honorable committee, to submit certain documents, photographs. To ascertain whether it comes under the parameter.
They need a court order, my lordship. Since there is I checked with the daily order.
Order illa.
ಇಲ್ಲ ಅವ್ರಿಗೆ my one
Otherwise, they will not obey you.
that one suggestion, my lordship, it may be directed to Registry of High Court of Karnataka because within 2 days they will send it. ನಮ್ಮಿಂದ ಅಂದ್ರೆ ಲೇಟ್ ಆಗತ್ತೆ.
Okay, ಮಧ್ಯಾಹ್ನ ಬರ್ತೀನಿ, ಆರ್ಡರ್ ಮಾಡ್ತೀನಿ, ಪ್ಲೀಸ್.
The court officer?
Serial number 20 appearance. ಅದು ರಿಸರ್ವ್
ಕೊಡಪ್ಪ sir.
ಆರ್ಡರ್ಸ್ ಆಗಿದೆ. ಆರ್ಡರ್ ರಿಸರ್ವ್ ಆಗಿದೆ.
38, 24th ಕೊಟ್ಟಿದ್ದೀನಿ ಸರ್. 21st ಅಥವಾ 27th.
ಹೆಸರು ಬರಬೇಕು.
27th.
ಸರ್ ಕೊಟ್ಟಪ್ಪ ಸರ್.
ಹಾ 38.
ಅದು ಹಾಕಕ್ಕಾಗತ್ತಾ ಮೇಡಮ್? ಅವರು ಟ್ರೈ ಮಾಡ್ತೀರಾ ಮ್ಯಾಮ್ ಪ್ಲೀಸ್ ಮ್ಯಾಮ್ ಪ್ಲೀಸ್ ಮ್ಯಾಮ್.
Please. Thank you.
ಸರ್ ಇದು
ಥ್ಯಾಂಕ್ ಯು.
ಅದು ಪರ್ಮಿಟ್ ಮಾಡೋದಿಲ್ಲ.
ಇಲ್ಲ ಇದು
The court officer?
ಒಂದ್ ನಿಮಿಷ ಕೊಡ್ತೀರಾ?
ಟೈಮ್ ಕೊಡಕ್ ಹೇಳಿದಾರಾ? ಎಲ್ಲ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಮತ್ತೆ ವಾಟ್
ಡಿಫೆಕ್ಟ್ ಎಲ್ಲ ಇಲ್ಲೇ ಕ್ಯೂರ್ ಮಾಡಿ ಅಂತಾರೆ. ಸರ್ ಫೈಲ್ ಕೊಟ್ರೆ ಕ್ಯೂರ್ ಮಾಡಿ.
ಸರ್
9 ಕೊಟ್ರೆ ಕ್ಯೂರ್ ಮಾಡಿ.
The court officer?
ಟ್ರೈ ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ
ಅದು ಪುಟ್ಟರಾಜ ಸಾಹೇಬ್ರದ್ದು ಅಲ್ಲಲ್ಲ ಪೋಸ್ಟ್ ಮಾಡಕ್ ಹೇಳಿದ್ದಾರೆ ಸಾಹೇಬ್ರು. ಅವತ್ತು ಹಾಕ್ತಿವಿ.
ಇದು ರಾಮಯ್ಯ ರೆಡ್ಡಿ ಟೈಮ್ ತಗೊಂಡು
ಅದಕ್ಕೆ ಯಾಕಂದ್ರೆ ಜಜ್ಮೆಂಟ್ ಬರ್ದ್ಬಿಟ್ರೆ ಕಷ್ಟ ಅಲ್ವಾ? ಶುಕ್ರವಾರ ಏನು ಪೋಸ್ಟ್ ಮಾಡಕ್ ಹೇಳಿದ್ದಾರೆ.
ನಾಳೆ
ಅದು ಶುಕ್ರವಾರ ಪೋಸ್ಟ್ ಮಾಡ್ತೀರಾ ಸರ್? ಹಾ ಅದು ಅಲ್ಲಿ ಹೇಳ್ಬಿಡ್ಬೇಕದು, ಯಾಕಂದ್ರೆ ಜಜ್ಮೆಂಟ್ ಬಂದ್ಬಿಡ್ತದೆ. ಜಜ್ಮೆಂಟ್ ಪ್ರೊನೌನ್ಸ್ ಆಗ್ಬಾರ್ದು, ಅದಕ್ಕೆ ಸೆಟಲ್ ಮಾಡಿ ಅದು ಹೇಳ್ಬಿಡ್ವಿ ಸಾಹೇಬ್ರು ಹೇಳ್ತಾರಲ್ಲ ಶುಕ್ರವಾರ ಪೋಸ್ಟ್ ಮಾಡಿ ಅಂತ.
So court officer? So, so ಮಧ್ಯಾಹ್ನ sitting ಇಲ್ವಾ?
ಸಿಟ್ಟಿಂಗ್ ಇದೆ ಮೇಡಮ್.
Okay, so serial number 20 adjourn ಏನಾನ ಆಗಿದ್ಯಾ?
ಇಲ್ಲ ಮೇಡಮ್, ಇದೆ ಮೇಡಮ್, ಇದೆ.
Okay, thank you sir.
ಊಟ ಮಾಡ್ಕೊಂಡ್ಬರ್ತೀರಾ? ಎಲ್ಲಾದ್ರೂ ಮಾಡ್ಬೇಕು ನೀವು, ಅದಕ್ಕೋಸ್ಕರ 26 ಫೈಲ್ ಇದೆ. 6 3 ಮಾಡ್ಬೇಕು, ಒಂದೊಂದ್ ಕಡೆ 6 4 ಇದೆ. ಪಾರ್ಟೀಸ್ ನೋಡ್ಕೊಂಡು ಕಾಲ್ ಶೀಟ್ ಇಟ್ಕೊಳ್ಳಿ, ಒಂದು ದಯವಿಟ್ಟು ಒಂದು ಕಾಲ್ ಶೀಟ್ ಅದನ್ನ ಟಿಕ್ ಮಾಡ್ಕೊಂಡು ಹೋಗಿ, ಕನ್ಫ್ಯೂಷನ್ ಆಗೋದು ಬೇಡ. ಇದೆ ಕೊಡ್ತೀವಿ, ಎಲ್ಲಿ ಕೂತ್ಕೊಂತೀರಾ?
ಎಲ್ಲ ಎಲ್ಲಿ ಕೊಡ್ತೀರಾ?
ಮಾಡ್ಕೊಂಡ್ಬಿಡಿ ಬೆಸ್ಟ್.
ಓಕೆ,
ಅದು ಈಗಲ್ಲ, ಟೈಮ್ ಆಗಲ್ಲ, 1 hour 2 hour ಬೇಕು. ಊಟ ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ರೆ ಇಲ್ಲಿ ಕೂತ್ಕೊಳ್ಳಿ.
ಸರಿ.
ಇಲ್ಲ ಅಲ್ಲಿ ಕೂತ್ಕೊಳ್ಳಿ, ಕೊಡ್ತಾರೆ ಒಂದೊಂದೇ ಬರ್ದಿ ಕಾಲ್ ಶೀಟ್ ಇಟ್ಕೊಳ್ಳಿ. ಟಿಕ್ ಮಾಡ್ಕೊಳ್ಳಿ, ಮಾಡಿ.
13 ಕೋರ್ಟ್ ಆರ್ಡರ್ ಇಲ್ಲ ಅಲ್ಲ, ನಾನು ಡೈಲಿ ಆರ್ಡರ್ ಅಲ್ಲಿ ನೋಡಿದೆ, ಇಲ್ಲ ಅದಾಕದೆ ಇದು ನೀವು ಅಪ್ಲೋಡ್ ಮಾಡತ್ತಾನೆ.
ತೋರಿಸಿ ಮಧ್ಯಾಹ್ನ.
ಯಾಕಂದ್ರೆ ಫ್ರೈಡೆ ಬೆಂಚ್ ಇದೆಯಾ ಸರ್?
ಅದೇ ಗೊತ್ತಿಲ್ಲ ಮೇಡಮ್, ಚೆಕ್ ಮಾಡ್ಕೊಂಡು.
ನೀಡ್ಫುಲ್ ಡನ್.
ಅದೇ ಮೈನರ್ ಇತ್ತು.
Excuse me, sir, afternoon 1:30 or 2, sir?
2:30.
2:30.
ಸರ್ ನೆಕ್ಸ್ಟ್ serial number 10 ಮಾನಿಟರಿಂಗ್ ಲಿಮಿಟ್.
10 ಡಿಸ್ಮಿಸ್ ಆಗತ್ತಾ ಹಂಗೆ?
ಹೌದು.
ಡಿಲೇ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ಬೇಕಾಯ್ತು, ಡಿಸ್ಮಿಸ್ ಹೆಂಗಿದೆ ಆಗಲ್ಲ.
ಹೆಂಗೆ
ಯಾವ್ದು ಅಂಡರ್ಟೇಕಿಂಗ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಇಟ್ಕೊಳ್ಳಿ ನಿಮ್ ಇದ್ರಲ್ಲಿ. ಆಮೇಲೆ ಬಂದು ಹೇಳ್ತೀನಿ ಬಿಡ್ರಿ. ಕಾಲೇಜ್ ಕೊಟ್ಬಿಟ್ಟು ಎಕ್ಸ್ಟ್ರಾ ನಾವು ಮಾದ ಅವ್ರಿಗೆ ಅಷ್ಟೇ. ಒಂದೆರಡು ಫೈಲ್ ಇಲ್ಲಿ ಕರೆಕ್ಟ್ ಇಟ್ಕೊಟ್ಟಿದ್ದೀನಿ. ಕಂಪ್ಲೇಂಟ್ ಮಾಡ್ಬಿಟ್ಟು ಕೊಡ್ತಾರೆ.
ನೀವು ಏನ್ ಸರ್ ನೀವು ಹೇಳಿ ಸರ್. 6,000 rupees ಟ್ಯಾಕ್ಸ್ ಕಟ್ಟಬೇಕು. ಸೊ ನಾವು ಅಪ್ಲೈ ಮಾಡಿದ್ವಿ ಯಾವಾಗ? ಅಕೌಂಟ್ ಕ್ರೆಡಿಟ್ ಆಗೋದು ಯಾವಾಗ ನಾವು ಅಪ್ಲೈ ಮಾಡಿದ್ದೀವಿ? ಮಾರ್ಚ್ ಮಂತ್ಗೆ. ಸೊ ಯಾವಾಗ ನಿಮ್ಗೆ ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್ ಕಟ್ ಮಾಡೋದು ಅವಾಗ ನಾನು ಹಾಕ್ತೀನಿ. ನಮ್ಗೆ ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್ ಕಟ್ ಆಗೋದು ಯಾವಾಗ? ಈ ಮಂತ್ ಲಾಸ್ಟ್ ಕಟ್ ಆಗತ್ತೆ ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್. ನೆಕ್ಸ್ಟ್ ಮಂತ್ ಕಟ್ ಆಗಲ್ಲ. ಇನ್ಕ್ಯಾಶ್ಮೆಂಟ್ ಟ್ಯಾಕ್ಸ್ ಇದೆ. ಸೊ ಬೆಸ್ಟ್ ಮೇಗೆ ಕೊಡ್ಬೇಕು. ಬೆಸ್ಟ್ ಹಾಗೆ 50,000 ಹೆಂಗೆ 5 ವರ್ಷ ಕಟ್ಟಾಗ್ತದೆ. They won't care. 4,000, 5,000 urgency. ಎಲ್ಲ ತಗೊಂಡ್ಬಂದು ಎಂಗೇಜ್ಮೆಂಟ್ ನಾನು ನೋಡಿ ಫೋನ್ ಮಾಡ್ಬಿಟ್ಟು ಎತ್ತಿ ಬಿಸಾಕ್ಬಿಟ್ಟೆ. ನೆಕ್ಸ್ಟ್ ಮೇಗೆ ಕೊಡೋಣ. ನಾವು ಟ್ಯಾಕ್ಸ್ ಕೊಡ್ಬೇಕು. ಅವಾಗ ಕಟ್ಟಾಗಲ್ಲ. ಸರ್ 2 months ರಿಜಿಸ್ಟ್ರೇಷನ್ ಮಾಡೋದ ಸರ್. ಆಮೇಲೆ ಹೆಂಗೆ ಕಟ್ಟಾಗತ್ತೆ? ನಾವು ಹೆಂಗೆ ಹೇಳ್ತೀವಿ ಕಟ್ಟಾಗತ್ತೆ?
ಬೆಸ್ಕಾಂ ಜೊತೆ ಅಟ್ಯಾಕ್ ಬೆಸ್ಕಾಮು ವೆರಮ್ಯಾಕ್ಸ್ ಇದು ಕಂಪ್ಲೇಂಟ್ ಸಮ್ ಲೇಡಿ ವಾಸ್ ರಿಪ್ರೆಸೆಂಟೆಡ್
ಸರ್ 14
till number 14.
ಸರ್ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಬರ್ತಾರೆ. ಅದೊಂದು ಲಿಸ್ಟ್ ಕೂಡ ಕೇಳಿದಾರಂತೆ.
ಅವ್ರಿಗೆ
ಸ್ವಲ್ಪ ಎಕ್ಸ್ಪ್ಲೇನ್ ಮಾಡು.
ನನಗೆ ಯಾರೋ ಒಬ್ರು ಅದಕ್ಕೆ ನಾನು ನಿಮ್ದೇ ಆಬ್ಜೆಕ್ಷನ್
ಜಿಮ್ ಮಾಡಿದ ಇದ್ಬಿಟ್ಟು ಫ್ಲೋರ್ ಎಲ್ಲಿ ಮಾಡಿದ್ರಲ್ಲಿ ಕರ್ಕೊಂಡ್ಬಿಡ್ತೀನಿ ಪ್ಲೀಸ್ ಆಯ್ತು. ನಾ ಹೇಳ್ತಿದ್ನಲ್ಲ 15 ಜನ ಹೋದ್ರೆ ಎಲ್ಲ ಬಂದಿತ್ತು ನನಗೆ. ಅದೇ ಬೈಕ್ ಆಕ್ಸಿಡೆಂಟ್ ಅದೆಲ್ಲ ಹಾಕಿನ ಮುಂಚೆ ಲಾಸ್ಟ್ ಇಯರ್ 2023 ಅಲ್ಲಿ ಒಂದೇ ತಿಂಗಳು ಹೋಗಿದ್ದಿಲ್ಲ ಎಲ್ಲ ಬಂದಿತ್ತು. ಮನೇಲಿ ಎಷ್ಟು ಚೇಂಜಸ್ ಆಗಿತ್ತು ನನಗೆ. ಫುಡ್ಡು ಕರೆಕ್ಟ್ ಆಗಿದ್ದೀವಿ ಜ್ಯೂಸ್ ಎಲ್ಲ ಬಟ್ ವರ್ಕಿಂಗ್ ಮಾತ್ರ ಒಂದೇ ಪಾಠಲ್ಲಿ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಇದು ಮಾತ್ರ ತಪ್ಪಾಗಿದೆ, ಇದೆಲ್ಲ ಹಂಗೆ ಇದೆ ನಮ್ದು.
ನನಗೆ ಯಾಕಿದೆ?
ಅದನ್ನ
Sir, court officer? Sir, court officer?
Yes.
Very small, I had to just put a signature, I complied with. Complied.
ಮಾಡಿದಿರಾ? Compliance is done with view of the court. ಏನಿದು?
Question of law, madam.
First question is not a question of law.
Second and third.
Second, third month. Appeal is admitted on the substantial questions of law at 2 and 3 in the appeal memo, which read as under. Is 11. Issue notice to the rest. Emergent notice to respond. First off, the question of law shall, better be, adralle iruttade. Okay, next.
Sir, this matter.
Same,
No, it may be dismissed for
ceiling,
monitoring.
ceiling limit. Sorry. CBDT circular number?
9 of 24. 9 of
Correcta?
2024.
Okay. Serial number? 10.
This for a big time.
Ah. 12,
Place for a big time, Milord.
3 times.
If first time, Milord.
Don't say that.
Devaru by DVG, Milord.
Sorry. Subject to presenting book by book, Devaru by DVG. 2. DVG ಕೊಟ್ಟಾಗಿದೆ. AN ಮೂರ್ತಿರಾವ್ದು ದೇವರು ಕೊಡಿ.
ಅಲ್ಲ ಅವ್ರದ್ದು ಕೊಟ್ಟಿದ್ದೀನಿ, ಇವ್ರದ್ದು ಕೊಟ್ಟಿಲ್ಲ.
ಇವ್ರದ್ದು ಕೊಟ್ಟಿಲ್ವಾ? Okay, other day, anyway, all right.
Please.
To the trial court live.
Please.
Lord, I may be permitted to serve through the assessing officer.
In addition to taking usual steps, the appellant is permitted to take notice through the assessing officer. This to be done within 10 days.
Scholarship, he is filing list of connected matters, similar matters.
Your Honors, it's already filed, Your Honors.
All right, one more list is given. How can you object to that?
Serial number 14, Your Honors.
Postal log. Next. Yes.
My instructions, my lord, if my lord may remember, this matter was there last.
I remember.
Very good.
Yeah. We don't forget even one single word.
No.
Yes.
My instructions are, I have 2 options that I would like to place for everyone's consideration. One is, the client is willing to forego interest and all other aspects.
Yes.
But the calculation for them at cost, no profit, no loss, just at cost, it amounts to balance of 22 lakhs. The original demand made even as of 2019 was closer to 50 lakhs. After deducting all of those things, the at cost, what our client is requesting, the petitioner is requesting is, close it at 22. Whatever is the maintenance and all that is payable, that is a matter with the association. I had included it in the calculation only to take it and hand it over. It was not my money to keep. 22 is the at cost. The other alternative is the original complaint that was filed before the Honorable State Commission was for refund of the amount. We can return that money with some interest component also added to it, which will ultimately be used for the benefit of the grant.
There is a small child.
Yes,
Both parents are dead.
yes.
Hmm.
Which is
So,
why, my lord,
They are looking after that child now.
which is why when we include the refund amount, my lord may kindly appreciate this one aspect. The unit was purchased by the deceased father even before marriage. So no, I'm just saying that, but whatever unfortunate incidents happened, I did not cancel the
Both they committed suicide.
No,
No.
Not one
Murdered.
committed suicide.
My daughter, she was brutally murdered by the paternal grandparents.
Don't say it disturbs us. Anyway, because not within the scope of this one. Should never happen to anybody.
it is very unfortunate.
Unfortunate. You said 18 lakhs.
18 lakhs, my lord.
They are saying 22 lakhs.
My lord, this maintenance charges is not applicable as per their own agreement.
No,
And,
they have not included maintenance
I'm saying
charge.
maintenance is matter with the association.
He's not included that. That we have not included.
22 is full and final from my end. Then after that, stamp duty, registration charges are buyers.
20 ಕೊಟ್ಬಿಡಿ.
My lord,
ಮಾಡಿ ಮುಗಿಸ್ಬಿಡಿ.
my lord, we have been suffering from past 8 years.
Correct. Why they should?
Running. See, my lord, what has happened is, we, as per their instruction, we have produced the guardianship certificate. But they have encouraged and they have encouraged this paternal grandparent who are ready to cancel the agreement.
ಆಯ್ತಲ್ಲ ಈಗಲ್ಲ.
My lordship, this is a very important point. Because if they cancel the apartment, the beneficiary will be the.
Cancel, where are we agreeing to that proposal? Why are you assuming?
They were giving, preferring this paternal grandparents to bring into the picture.
All right, ನಾವು ಈಗ ಬಿಡಿ ಅದೆಲ್ಲ. ಈ ಮಗು ಹೆಸರಿಗೆ ಅದನ್ನ ಸೇಲ್ ಡೀಡ್ ಮಾಡಿ ಕೊಡ್ತಾರ ಅವ್ರು.
Yes, my lordship.
ಆಯ್ತಾ?
Yes, my lordship.
Number 1. ನೀವು 18 ಲಕ್ಷ ಕೊಡ್ತೀವಿ ಅಂದ್ರು 18 ಅವ್ರು 22 ಅಂತ ಇದ್ದಾರೆ 20ಕ್ಕೆ ನಾವು ಮುಗಿಸ್ತಾ ಇದ್ದೀವಿ. 20 ಲಕ್ಷ ರೂಪಾಯಿ
My lord, earlier we had got this apartment earlier, we would have rented out and given that for my grandchild's
Another 5
education.
years.
Please, my lord. Please
Another
request this.
5 years it will remain here.
My lordship.
And we do not know what other judges will come. They will become very competent judges is another thing. That is a hope. But earliest point of time.
Little compensation also. My
Gain
lord.
compensation.
Now, for nearly 10 years, this has been going on, sir. If we had rented out, we would have given for education.
ಯಾಕೆ ಲೇಟ್ ಆಯ್ತು ಬಾಡಿ ಕೊಡೋದು?
May I point out, my lord, in 2015, when the agreement was signed by the deceased gentleman, the marriage had not even happened. The unfortunate deaths happened in 2017. After that, the two.
ನಿಮ್ಗೆ ಪೇಮೆಂಟ್ ಯಾವಾಗ ಮಾಡಿದ್ರು ಅವರು?
It has been made in 2015, 16, 17 till around.
ಲಾಸ್ಟ್ ಪೇಮೆಂಟ್ ಯಾವಾಗ ಮಾಡಿದ್ರು? ತೋರಿಸಿ.
It would have been around 2016, my lord. May kindly see the email correspondence.
Entire payment is made now.
No, not entire.
What was the payment made?
The part payments.
ಕೂತ್ಕೊಳ್ಳಿ ನಮ್ಗೆ ಅವಶ್ಯಕತೆ ಬಿದ್ರೆ ಕೊಡ್ತೇವೆ ನಾವು. ಇಲ್ಲಪ್ಪ ಟೈಮ್ ವೇಸ್ಟ್ ಮಾಡ್ತೀರಿ ನೀವು ಎಲ್ಲ ಅಂತ ಗೊತ್ತಿರಲ್ಲ ಏನಿಲ್ಲ. ಎಸ್ ನೀವು ಮರ್ಸಿ ತೋರ್ಸಕ್ ಹೋಗಿ ನಾವು ಲಾದಲ್ಲಿ ಆಕ್ಸಿಡೆಂಟ್ ಮಾಡಿ. ಎಸ್
Kindly see, my lord, the demand notice.
What was the amount payable by them? Within how many installments it ought to have been paid? Answer the question.
Very well, my lord. My lord, the calculation is provided for in 2 documents. One is agreement.
They're asking.
Very well. The total amount that was agreed to with the original purchaser was 74.
74 lakh. What is the amount already paid?
My lord, may also keep one thing in mind. There were 2 units originally, and then the original purchaser cancelled one.
1 unit. It came down to 1.
Came down to
So
1.
that amount would be reduced proportionately
We
to
have adjusted that to this amount itself. So totally around 52 has been paid.
52. For two units, it was 74.
No. But after it, 74 was for 1 unit, but I have accounted the
Payment to 1 unit.
yes,
That is 54.
52 in total.
52.
Yes.
Where is that? So based upon this, you are saying 22 they have to pay.
Is my cost, I'm not this thing. My lord may kindly see the demand notice which I had issued to both the grandparents.
Where is that?
Yes, my lord. That is available at page number. The page number, no? Kindly bear with one moment.
Senior advocate Ashok Harnalli ಏನ್ ಹೇಳಿದ್ರು ಅವತ್ತು ಮೊನ್ನೆ ದಿವಸ?
His suggestion was, since they offered 18 lakhs, he said, see if you can consider 18 lakhs. So we.
ನಾವು
because-
ನೀವು 20 ಹೇಳ್ತಾ ಇದ್ದೀವಿ. ಇದನ್ನ
I'm
ಒಪ್ಪಂಗಿದ್ರೆ
only, sir.
ಅಡ್ಡಿ ಇಲ್ಲ. ಹರ್ಡ್ ರಿಸರ್ವ್ಡ್ ಜಡ್ಜ್ಮೆಂಟ್ ಟುಮಾರೋ.
Not
Next.
if it
Before
is
you-
concluded today,
We are
18 lakh rupees, the learned senior counsel, he has studied the whole thing and he has calculated and he has heard both the parties. And he has come to a conclusion that 18 lakh rupees is payable by this one, as per the latest, that one, that payment demand notice, everything. So 18 lakh rupees, if the matter is concluded,
Yeah.
my lord, because 1 lakh even. it
ಅವ್ರು
is-
ಒಪ್ಪುತ್ತಾ ಇಲ್ಲ. ಅದಕ್ಕೆ ನಾವು ಸಮ್ ಮೆರಿಟ್ ಮೇಲೆ ಒಂದು ಆರ್ಡರ್ ಮಾಡ್ತೇವೆ. ಜಡ್ಜ್ಮೆಂಟ್ ಟುಮಾರೋ. ತಾಳಿ.
My lord, both the matters arise out of proceedings from orders from the Honorable Single Arbitrator, my lord.
Yes.
The office objection is one of the report, that is annexure L. Couple of pages are not legible. By and large, everything is legible. Only one photocopy which is furnished by us.
ಸರ್ಟಿಫಿಕೇಟ್ ಕಾಪಿ ಅನೆಕ್ಸರ್ ಏನ್ ಹಾಕ್ಬೇಕು?
ಅದು ಇವ್ರದ್ದು ಆರ್ಬಿಟ್ರೇಟ್ ಸರ್ಟಿಫಿಕೇಟ್ ಕಾಪಿ ಬರೋದಿಲ್ಲ, ಒಂದೇ ಸೈನ್ ಮಾಡಿಕೊಟ್ಟಿದ್ದಾರೆ. Therefore, that may kindly be condoned, my lord.
Are these objections on request of the council are overruled? Overruled. ಏನಿದೆ?
My lord, in this matter, the petitioner here is the claimant, my lord. He had filed 2 applications because there was the large number of vagaries as regards the enterprise value and the value of the properties, my lord. Some 4-5 valuations were given. Therefore, there was, apart from that, my lord, in the accounts, certain irregularities were there. And this had to be found out only through forensic auditing. And also, my lord.
Your application rejected?
Rejected, my lord. 2 applications. One, we had sought for forensic auditing and for the expert to value the business enterprise as well as the property, my lord. That is rejected. And in the other application, my lord.
Emergent notice.
Either other side is appeared already.
You are there.
I'm not, I'm just appearing on for R1 to 3, your lordship. Like, I'm appearing for R1 to 3.
R1 alone. Emergent notice to 3 and 4,
I'm R1 to R3, can be issued to R1 to R3.
R1 to R3.
Yes, your
R4 is the
Not-
company where R1 is the director, represent. That's what I have shown.
R4 ಗೆ ಹೋಗ್ಲಿ.
R4, you're
ನೀವೇನಾ?
R1 is the
I'm not
director.
appearing.
Saying his thing, I'm not.
R1 is the director.
I'm not having instructions for them.
Very well, my lord.
Issue. Shri, so and so appears for response 1, 2 and 3. Issue emergent notice to 4.
May I,
Interim order as prayed for till next date of
my lord,
hearing.
may I request for hand summons so far as.
In addition to taking usual steps, petitioner is permitted to take hand summons to the respondent for as well.
Lord, if I'm not avaricious,
Ah.
problem we are, both of us are facing is, we are sought for the extension of mandate.
ನೋಡಿ,
ಮುಗೀತಾ?
ಈಗ
ಅಲ್ಲ,
ನಿಮ್ಗೆ
ಅದ್ರಲ್ಲಿ
interim order
ಏನಾಗಿದೆ?
ನೀವು ಏನ್ ಕೇಳಿದ್ರೆ ಅದನ್ನ ಕೊಟ್ಟೇವೆ ನಾವು.
ಅಲ್ಲ, ಅದ್ರಲ್ಲಿ ಏನಾಗಿದೆ, 2 ತಿಂಗಳು ಕೊಟ್ಟಿದ್ದಾರೆ. Therefore, a short date may be kindly granted, madam.
ಅಲ್ಲ ಬರ್ಲಿ, post immediately after service.
Grateful in both the matters.
Okay, ಎರಡು call along with each other.
No, sir.
Yes.
Tax effect is less than the prescribed limit.
Yeah.
My lord, it has to go on monetary limits, my lord.
ನೋಡಿ, monetary limits. Yes.
9 of 24. my lord.
9 of
Circular 9 of 24 dated 17/24, my lord. Please.
My lordship, this matter, it's already heard in the other matter, is recalling for the order of this. Yes, petitioner has filed an application for the recalling the order passed by this, my lordship. My lordship order is very clear, my lordship. He can approach with the remedy. Kindly read the order of this honorable court, my lordship.
All the applications are rejected.
Please, my lordship.
In an
Leave of the
application.
above, we decline indulgence, but reserving liberty to the petitioner to avail appropriate remedies. Though he has filed the same petition, my lordship, that has been dismissed in the year of 2024. Same. Same
Is it
party.
true?
Same party. Sir, he had filed another writ petition. 9903. Kindly read. Para 5 and 6, my lordship.
Yes, I was also, subsequently matter came before me also.
Please, my lordship. And 5 and 6 is very clear, my lordship. This is regarding the Kaveri dispute, which he cannot sort before this court, my lordship.
You should go before the water tribunal, na?
Sir. They are misleading the court repeatedly, sir. I have got documents here, and they are also having the documents. They are not telling you about that. Sir.
How this court has jurisdiction?
No,
Then
sir, I will come to that, sir.
1 second, don't waste time. Yes, I'll query. Nandu Varale Saibradidala, matters of this should go before the National Tribunal or before the Supreme Court and the judgment is recording. Water dispute, no high court, no court shall exercise jurisdiction. ಯಾವ article constitution then? Which is that article?
Sir, Article 262, sir. It is there in the order.
Constitution.
Clause 7.
Nayanatara?
I'm sorry, my lords.
All right, which is that article? Which excludes jurisdiction of the high courts?
Please, my lords, your lordships have referred to it in the previous order. I'll just find it out.
When one matter you had appeared, na?
Please, my lords, this is in fact the same matter where an application for recall was filed. Your lordships have dismissed it. This is a recall of a recall.
Yes.
Please, my lords, it's already, your lordships
that
have
article?
recorded it. Please, my
Which is-
lords, I'll. My lords, Article 262, my lords.
Read Article 262(2).
Yes, sir. Sir, now I am talking only about law, sir. I will talk only about the law.
When,
The whole case.
When court says,
Yes.
read, means you should read.
Oh,
Or I will dismiss the petition
I
because
know.
you are not obeying the court.
Sir, 262.
Read.
That is correct, sir.
Read.
That article I am not having here.
Sorry.
Parliament terms.
ನಿಮ್ಗೆಲ್ಲ ಲಾ ಕಲಿಸಿ ಆಮೇಲೆ ನಾವು ಕೇಸ್ ನಡೆಸಿರಿ ಉಳ್ದೋರ್ ಗತಿ ಏನಿಲ್ಲ ಎಲ್ಲ ಹೇಳಿ.
Adjudication of disputes relating to waters of interstate rivers or river valleys.
Correct. Kaveri is an interstate river.
Yeah.
Next.
Parliament may by law provide for the adjudication of any dispute
Correct.
or complaint with
Correct.
respect to the use, distribution or control of the waters
Correct,
of or in any interstate river or river valley.
correct.
Sir,
There is a parliamentary
sir,
legislation.
I got the point, sir.
Act idea?
Yeah, it is there.
Act idea.
It is there. But my point of view is entirely different, which they are not touching, sir.
Ali, ನಮಗೆ ಹೇಳಿ ಅವ್ರನ್ನ ಬಿಡಿ.
Okay.
ಅವ್ರನ್ನ ಬಿಡಿ.
Sir, now, sir, I will read this order and recall.
Yeah.
So that you will have some grasp of the matter, sir.
We have come after reading that.
Okay. Sir, in the para 3, it is told, it is being recorded. The party in person vehemently argues that under Article 227 of the Constitution of India, court has power to rectify the arguable defect. The defect is admitted.
Read.
Which according to him is apparent on the face of the record, and therefore the same needs to be rectified by issuing an appropriate direction. A learned Advocate General appearing for the state and the CGC appearing for the center oppose the petition, drawing our attention to the provisions of the Interstate River Dispute Act 1956 enacted by the Parliament in terms of 262 under the Constitution of India. They also submit that already the Kaveri Water Dispute Tribunal has been functioning since decades, and therefore judicial intervention is neither permissible nor desirable, since matter essentially touches interstate water dispute. Sir, here is the problem, sir. Here, they are telling Kaveri Tribunal is functioning since decades. It is not working, sir. Since 2018, it has been dissolved under the Interstate Water Dispute Act.
Go to Supreme Court.
Class 12, sir. Under class 12, it has been dissolved. So, Kaveri Tribunal is not yet existing. This is one point, sir. And another thing, the entire Interstate Water Dispute Act, there are other provisions which empower this High Court to uphold the Interstate Water Dispute Act. That they have not telling before the court, sir.
Which is that?
I will tell. Sir, Interstate River Water.
Yes.
Sorry, Interstate River Water Dispute Act 1956.
Yeah.
Kindly refer page number 3, sir. Clause 6. Publication of decision of tribunal. The central government shall publish the decision of the tribunal in the official gazette, and the decision shall be final and binding on the parties to the dispute and shall be given effect by them.
Correct.
And 6.2, clause 2, the decision of the tribunal after its publication in the official gazette by the central government under subsection 1 shall have the same force as an order or decree of the Supreme Court. So here in this case, the Kaveri Tribunal report is already there. It is existing. It is settled by the Supreme Court. So this court is empowered to uphold the Interstate River Dispute Act. And as per this, sir, as per the Interstate class.
It becomes an order as if of the Supreme Court. Therefore, any dispute relating to this, you should go before the Supreme Court.
Sir, here I have no any dispute, sir. There is a glaring error apparent on the face of the record. We are not, there is no interstate river, there is no dispute at all. There is a glaring error apparent on the face of the tribunal record. Where they have published at class 9, they have not published Karnataka's monthly share of water at class 9.
That should be published by whom?
By this respondent R1 and R2.
They are Supreme Court. You go to Supreme Court. It's a central government. It's a what? Suppose if we make order today, Madras High Court makes another order, then Kerala High Court makes yet another order. How to implement the order? That is the reason. It's the wisdom of the Parliament, the Constituent Assembly. They said, inter-water disputes iddaga 2-3 states nalli irtade. ಯಾವುದೋ ಒಂದು ಹೈಕೋರ್ಟ್ ಡಿಸೈಡ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ. ಇಂಥ ಡಿಸ್ಪ್ಯೂಟ್ ಅನ್ನ ಟ್ರೈಬ್ಯುನಲ್ ಮುಂದೆ ಹೋಗಬೇಕು. ಟ್ರೈಬ್ಯುನಲ್ ಇಲ್ಲ, ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಮುಂದೆ ಹೋಗಬೇಕು.
Okay, there is a twist in the matter, sir. We have issued a notice to the respondent R1 and R2.
Having heard no grounds found,
and
therefore dismissed. Right. Next.
I'm grateful, my lord. My lords, in fact, there's another petition pending, my lords, that is before Court Hall 1.
But how can, what can?
Very well, my lords, I'm just bringing it to your lordship's notice. My lords. Very well, I'm grateful.
Reconciling application rejected. Okay. Yes.
Transfer pricing issue, my lord. Supreme Court remand matter, question 1 and 2 requires consideration.
Hold up. 1 and 2. Read as under. Calgary, we have noted that some of these questions are being debated in an ongoing matter. Okay.
Lords, may I just point out one thing? I'll leave it to
Next.
my lords.
Admission, it's a matter of admission between the court and the
Very well.
appellate. Yes, next.
My lord, I may be permitted to retire as the advocate for the respondent.
This is also.
This
same,
is a
my lord.
remand matter from the Supreme Court.
Correct. After
The
two, so
assessor had
why-
informed us that they want to
My
engage
lords,
some
I
other
have filed a
counsel.
vakalat.
You appear.
I filed a vakalat.
Srimati so and so appears for. So and Shri so and so is permitted to retire from the case.
Grateful.
For 2 and 3 maybe.
2 and 3, question numbers.
My lords, I'm
Next.
told the monetary limits is less than the prescribed threshold.
I don't
I'm-
have file, I will just look into the papers, my lord.
Call next.
If
week.
admitted, if it is
Next week,
covered, I
next
will move the matter.
No, wait, unnecessarily. ತೋರಿಸ್ಬಿಟ್ರೆ ಮುಗೀತು ಅದು ಕಾಲ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್
Please.
ತೋರಿಸಿ ಓಕೆ ನೀವು ರಿಕಾಲ್ ಹಾಕೋಬಹುದು ಅದು ಐಡೆಂಟಿಕಲ್ ಮ್ಯಾಟರ್ ಮಾಡ್ಬೋದು ನೋಡಿ ಡಿಸ್ಪೋರ್ಡ್ ಆಫ್ ಆಸ್ ಬೀಯಿಂಗ್ ವಿದಿನ್ ದಿ ಬಿಲೋ ದಿ ಅದೇ 9/24 9/24 9/24 liberty is reserved to seek recall of the order in the event matter falls in any one of the exceptions enumerated in the circular.
Or even if tax effect is more,
You know,
or even if tax effect is more, because I have not seen no.
or otherwise.
Please,
Okay,
23 Tarmera.
all right, next.
one question, my lord. This is also same, my lord, one question.
Question number 1. Only one question.
One question.
No, sole question. As under.
26 also same, my lord, connected matter.
Yes.
I'm appearing.
25, 26 together ಮಾಡ್ಬೇಕಾ?
ಮಾಡ್ಬೋದು.
Okay. We'll call along with.
This is also same, my lord, Supreme Court remanded matter, my lord, but questions I will just check. ನಂತರ papers ಇಲ್ಲ ಅದಕ್ಕಿಂತ.
Next week.
I will just see the question, which number it is.
ನೋಡಿ.
One, two, three, my lord.
1, 2,
1, 2, 3.
1, 2, 3. All right. Next.
That's 29 is covered in my favor by the decision of this honorable court, which has been affirmed by the Supreme Court. SLP is dismissed against the appeal arising out of this order.
The subject matter of this.
My lordship will kindly say, my lord, counsel for the revenue try to distinguish and this honorable court is not convenient.
The subject matter of this appeal is substantially similar to the one in ITA number 329 of 2017.
Which has been followed by the tribunal.
PR, Principal Commissioner of Income Tax versus Bangalore International Airport Limited. Heard and disposed of by a coordinate bench of this court, while order dated 19/9/2022.
And the matter has attained finality.
22.
Supreme Court.
Full stop. 22 in favor of the SSC. Full stop. Learned counsel appearing for the SSC notifies to the court that the challenge to the said order in SLP number so and so has been rejected by the apex court. Why the order dated so and so, so and so. First, next paragraph. The vehement submission of learned panel counsel appearing for the revenue that the fact matrix of this case is bit in variance with the one involved in the said in the cognate appeal is difficult to agree with. First, in view of the above, the appeal is liable to be dismissed and accordingly it is, costs having been made easy. Next. ಅಲ್ಲಿ ಒಂದು first paragraph revenue had challenged the order of the ITAT dated so and so made in favor of the assessee in ITA number so and so on so and so. First, the appeal memo has framed the following substantial question of law. Okay.
And this judgment was followed or relied upon by the tribunal.
Tribunal, the very same judgment.
Same.
ಅಲ್ಲೇ ಟ್ರೈಬ್ಯುನಲ್ ಮುಂದೆ ಅವ್ರ ಅಪೀಲ್ ಇತ್ತನೋ?
Tribunal ಮುಂದೆ
ಅವ್ರ ಅಪೀಲ್,
ಹೌದು.
ಇವರ ಅಪೀಲ್,
ಅಲ್ಲ,
ರೆವೆನ್ಯೂಸ್ ಅಪೀಲ್,
I'll just come.
ಕನ್ಕರೆಂಟ್ ಫೈನ್
Revenues appeal.
ಅಲ್ಲಿ ನೋಡು, ಅದು ಸೆಸಿಸ್ ಅಪೀಲ್ ಅಲ್ಲ, ಅದು ರೆವೆನ್ಯೂಸ್ ಅಪೀಲ್, ಅದು ಅಲ್ಲಿ ITAT ಮುಂದೆ. ಓಕೆ, ಓಕೆ. ನೆಕ್ಸ್ಟ್.
For the response.
Yes.
Lord, as per the directions, Lord, of this honorable court, filed a memo, Lord, on 3rd February 2025. Lord, your lordships had directed me to produce the document, the Google maps, which we had produced before the committee, Lord, honorable committee, Lord. I just received the copy today. Let me have a look at it. My lords may have it tomorrow or day after. Yes. He just gave it to me today.
Call next week, the request of counsel for the petition.
Lord, one more submission was made on behalf of the petitioner. That, Lord, during the pendency of, Lord, the interim order before the learned single judge, the Bangalore Development Authority had illegally taken possession. And Lord, and had destroyed the nurseries was the submission on the last occasion. And to that effect, Lord, it was contended that, Lord, the documents were produced before the committee. Lord, may I make one submission, Lord, subject to your lordship's permission. Lord, a contempt petition was filed by the contempt petition was filed by the petitioner.
Dropped on the ground that.
Dropped on the ground. Dropped on the ground that the allegation much prior to the interim order being passed by the learned single judge, and Lord, the possession was taken. Lord, may I request your lordships to kindly take.
All right, we agree.
Page 4. Yes.
We don't doubt you.
No, Lord. Lord, that this is what I was required to clarify before your lordships. That's.
That was the requirement.
That was the requirement for me to make a mention of it, Lord.
Lord, on this particular, the BDA panel council submission that the petitioners CCC number 2085 and 2086 of 2018 civil alleging violation of the interim order made in this case.
Not in this.
In the WP.
In the WP, writ petition number.
In WP numbers.
60013 of 2014.
60013 of 2014.
Please.
Has been dropped by the coordinate bench of this court. Wide order dated 1/3/2019 is noted. First, a copy of the order placed on, is taken on record.
Please.
Okay.
One more request. Here, Lord, your lordship had directed the government advocate to secure the records from the committee.
They will not obey antalla. Yen records ಬೇಕಾಗಿದೆ ಇದನ್ನ?
Lordship may pass a formal order so that the committee sends the record.
The
May be directed to
CGP is directed to secure.
It may be directed to the registry, because if it is registry within 2 days, they will.
The registrar general to secure the ಎಂತ ರೆಕಾರ್ಡ್
Records from Keshwanarayan committee.
Yes, from the committee.
ಇದಕ್ಕೆ ಸಂಬಂಧಪಡೋದು.
ಹೌದು, ಹೌದು.
The record relating to this petition
KNKC number 97 of 2020. Please.
bearing number so and so from the Justice Keshavanarayana Committee office.
Please.
From the office of Justice Keshavanarayana, Honorable Justice Keshavanarayana Committee.
Please.
Committee, forthwith.
Please.
Forthwith. Okay. ಯಾಕೆ ನೀವು ಹೇಳಿರ್ ಕೊಡಲ್ಲ ನಾವು?
Lord, in this, Lord, in this Arkavati layout matter, Lord, it has become.
ಲಾಯರ್ AGA, ASG, HCGP ಅವ್ರು ಹೇಳಿದ್ರೆ ಆಗಿಂದಾಗ ಒಬೇ ಮಾಡ್ಬೇಕು. Anyway, ಆ ಕಲ್ಚರ್ ಇಲ್ಲ ಈಗ. Anyway, we understand.
The honorable chairman, I am told, Lord, that the honorable chairman, Lord, had readily agreed to give it, but Lord, in
Order ಬೇಕು.
No.
Order is necessary.
Order, but the fact is that, Lord, insofar as Arkavati layout matter files are concerned, Lord, so many documents are so much manipulated.
Oh,
and
that fear he has got.
That
They
fear-
may do something.
No, Lord. And the honorable chairman doesn't want, Lord, that something may go missing and it should not come on them, Lord. That is what, Lord, it's a politically. They can like index it, my Lord. They can They, index it. just now like
uh,
they'll, that's why, Lord, they requested us also to make a.
Security in a sealed cover ಅನ್ಬಿಡಿ.
Please,
Security in a sealed cover.
please, wait.
Let it be indexed, my lord, indexed also.
They'll do it.
Because, my lord, once the cover is open here, then, my lord, it again, so if it is indexed, just like in the trial court, my lord.
It hardly needs to be stated that the file papers shall be indexed and paginated so
then-
that there shall be no scope for any possible argument of possible manipulation.
Please.
And further, a photostat copy of the said record be retained with the committee.
Great.
For possible, for comparison if need arises.
Great, great.
Lords, in this matter, I'm told the SSC has filed an application for settlement of the dispute under the Vivad Se Vishwas scheme. Lords. Only Form 1 has been filed. No further developments have happened just at the moment.
So what should we do?
My lords, I suppose matter can be adjourned until Form 2 is issued by the department.
Form 2 issue ಮಾಡ್ರಿ ಅವರಿಗೆ.
Please.
Dispose of ಮಾಡ್ಬಿಟ್ರೆ ಆಯ್ತು.
I'll take it successfully.
All right. Call next week.
Grateful.
At the request of learned panel counsel appearing for the revenue, who assures that the steps would be taken for issuance of Form 2 if it is legally permissible. Okay.
Grateful.
Next week, Marnand. Next week, call next week. For compliance. Okay.
My lord, serial number 34, in this matter, I require some time, my lord. This is the reallocated matter. Files are not available with me.
2 weeks at
2
the
weeks,
request.
please. 34 and 35.
For respondent in 35, my lord.
All right. Next.
My lords, I appear for the petitioner. I'm sorry I'm appearing through VC.
Why should we be sorry? If you appear, it is more than sufficient for us.
Grateful, grateful.
Yes.
My lords, this is a case where for the first time, penalty under service tax law was imposed on the petitioner in a revision, without considering two jurisdictional decisions of the Honorable High Court, which said that penalty enhancement in revision is not permissible when discretion has been used by the adjudicator in not imposing penalty. Now, the facts of the case, my lord, in this case was that the proprietrix who was registered.
You need to bring your friend also.
My lords, week after next, if it is possible, I'll be there in person.
See, post this matter week after next to enable panel counsel Mr. Nirali to come and argue.
Deeply obliged, deeply obliged.
Respondent number 1 year.
ರಮೇಶ್ ಎಲ್ಲಿದ್ದಾರೆ? ಏನಿದು?
ಇದರಲ್ಲಿ ಈಗಾಗಲೇ ಒಂದು IA ಸಬ್ಮಿಟ್ ಮಾಡಿದ್ದೀನಿ ಅಂಡರ್ ಸೆಕ್ಷನ್ 340 ಆಫ್ CRPC. ಯಾಕೆಂದ್ರೆ ದೇ ಸಪ್ರೆಸ್ಡ್ ಲಾಟ್ ಆಫ್ ಮೆಟೀರಿಯಲ್ ಫ್ಯಾಕ್ಟ್ಸ್ ವಿಚ್ ಆರ್ ರಿಲೇಟೆಡ್ ಅಂಡ್ ಆಲ್ಸೋ ಪೆಂಡಿಂಗ್ ಕೇಸಸ್ ಬಗ್ಗೆ ಎಲ್ಲ ದೇ ಹ್ಯಾವ್ ಸಪ್ರೆಸ್ಡ್. ಸೊ ಅದರಿಂದಾಗಿ
ಫೈಲ್ ಕೊಡಿ. ನೀವೇನ್ ಕಂಪ್ಲೇನೆಂಟಾ?
ಐ ಆಮ್ ದ ಕಂಪ್ಲೇನೆಂಟ್ ಇನ್ ದ ಲೋಯರ್ ಕೋರ್ಟ್.
Second matter, my lordship.
Second matter also I am respondent number 2.
However, they have filed a discharge application, my lordship. Discharge application has been rejected before the KLJ special court. And they're seeking the quashing of that said order, my lordship. But order is very clear in before the KLGC. The report has been filed by the BBMP and Tahsildar in para 12 and 13.
Supporting the complainant.
Please, my lordship. Annexure A, para 12 and 13 in the discharge.
ಯಾವ ಊರಿಂದ ಬರ್ಬೇಕು ನೀವು? ಯಾವ ಊರವರು?
ಇಲ್ಲ ಬೆಂಗಳೂರು. ಹೊಸೂರ್ ಹತ್ರ.
ಒಂದು ಡೇಟ್ ಕೊಡ್ತೇವಿ, ಅವ್ರು ಆ ಡೇಟಿಗೆ ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ನೆಕ್ಸ್ಟ್ ನೀವೇ ನಡೆಸಿಬಿಟ್ರೆ ಅವ್ರ ಸಲುವಾಗಿ ಕಾಯಲ್ಲ ನಾವು. ಒನ್ ಡೇಟ್ ಕೊಡ್ಬೇಕಾಗ್ತದೆ.
ಆಮೇಲೆ ದಯವಿಟ್ಟು ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ನ ಇಂಟ್ರಿಮ್ ಸ್ಟೇನ ವೆಕೇಟ್ ಮಾಡಿದ್ರೆ, ಯಾಕೆಂದ್ರೆ 2016 ಮ್ಯಾಟರ್ ಇದೆ.
ಹಂಗ್ ಮಾಡಕ್ ಬರಲ್ಲ, ಅವ್ರು ಅಬ್ಸೆನ್ಸ್ ನಲ್ಲಿ ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ.
ಯಾಕೆಂದ್ರೆ
ಅವ್ರಿಗೆ ಹೇಳ್ಕೊಂಡ್ ಮಾಡ್ಬೇಕಾಗ್ತದೆ ಅದಕ್ಕೆ.
ಅಲ್ಲ, ಯಾಕಂದ್ರೆ ಪೆಂಡಿಂಗ್ ದಿ ಫೈನಲ್ ಆರ್ಡರ್ ಏನೋ
ಹಂಗ್ ಮಾಡಕ್ ಬರಲ್ಲ. ಅವ್ರು ಇದ್ದಾಗ ಮಾಡಕ್ ಬರ್ತದೆ, ಅವ್ರು ಇಲ್ದಾಗ ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ. ಅದಕ್ಕೆ ಅವ್ರು ಬರ್ಲಿ ಅನ್ಕೊಂಡು ಒಂದು ಆರ್ಡರ್ ಮಾಡೋಣ. ಈಗ ಅವ್ರು ಬರ್ತಾ ಇಲ್ಲ ಅಂತ ಹೇಳಿ ಒಂದು ಆರ್ಡರ್. ಕಾಲ್ ದಿಸ್ ಮ್ಯಾಟರ್ for possible dismissal and for the appearance of counsel for the petitioners for possible dismissal on the next date of hearing. First week of March, one date. 4th of March. Till then, interim order continues. ಇದೇನು interim order ಇದ್ರೆ ಮಾಡೋದು ಬೇಡ.
In fact, in this matter, I have engaged the senior counsel, Mr. T.R. Ravishankar, sir. And this is the matter wherein, your lordship, I have challenged the decision taken by the committee, third respondent, the Honorable Justice Keshonaran committee. They rejected my claim on the ground that, your lordship, because the claimant who are before the committee, they sold the property when the matter was pending.
To others.
To the others. So in fact, your lordship, the subsequent owners, your lordship, they steps into the shoes of the earlier vendor. And the claim is, your lordship, because at the time of the land owner, the owner of the Katadar of the land is one Mani Venkatappa. And your lordship, he sold the property in the year 1995 itself. And at the time of issuing the preliminary notification, your lordship, the site owners, because while selling the property, your lordship, he sold it, he formulated his sites, your lordship, thereafter he sold it. And then, your lordship, I purchased the property. At the time of preliminary notification, your lordship, my name was not shown, Katadar's name was shown. And subsequently, your lordship, I filed objection to the respondent, to the BDA. And even after filing bid objection, your lordship, even in the final notification, your lordship, the name of the Katadar is shown.
Henry.
And
But what has happened is, they claim that they have purchased the property subsequent to the acquisition proceedings.
Subsequently acquisition.
Subsequent to the.
Compensation ಕೊಡ್ಬೇಕು.
Compensation.
They'll need acquisition challenge ಮಾಡಕ್ ಬರಲ್ಲ ಅಂತ hold ಮಾಡಿದೆ ಅಪೆಕ್ಸ್ ಕೋರ್ಟ್.
ಇಲ್ಲಿ ಹೌದು.
But compensation ಕೊಡ್ಲೇಬೇಕಲ್ಲ.
ಕೊಡ್ಲೇಬೇಕು.
ಮತ್ತೆ ಅದನ್ನ
compensation ಕೊಡ್ತೀವಿ. ಇವರು what they have sought is they want to deletion of the land from the acquisition proceedings.
No,
that is why they go
have, no, because of Supreme Court judgment.
Yeah,
Supreme Court said you are entitled to compensation, but not any challenge to the acquisition or seeking deletion from acquisition. At least ಏನಾದ್ರು representation ಏನ್ ಕೊಟ್ಟಾರಲ್ಲ ಅದನ್ನ ಕನ್ಸಿಡರ್ ಮಾಡಕ್ ಬರೋದು.
ಅವ್ರ representation deletion ಕೊಡ್ತಾರೆ, compensation ಕೊಡ್ತೀವಿ ಅಂದ್ರೆ ನಾವು we have no issue.
Deletion ಕೊಟ್ಟರು ಸಹಿತ ನೀವು ಇದು ಕೊಟ್ಟಾರ, ನೀವು ಹಿಂಗ್ ಕೊಟ್ಟಿರಪ್ಪ, ಇದ್ರ ಮೇಲೆ ನೀವು ಹಂಗ್ ಮಾಡಕ್ ಬರಲ್ಲ, ನೀವು ಕಾಂಪನ್ಸೇಷನ್ ಕೇಳಿದ್ರೆ ನಾವು ಕಾನೂನು ಪ್ರಕಾರ ಕನ್ಸಿಡರ್ ಮಾಡ್ತೀವಿ ಅಂತ ಒಂದು ಉತ್ತರ ಕೊಡೋದು ಬೇಡವಾ?
Adhan that will
That
reply.
even, why you made her to come to court?
Lord,
You
they,
owner.
no, Lord, may I make one request? The case is not here that they want a compensation.
Huh.
The case is that
They
their,
should delete it.
their land should be deleted.
ನೀವ್ ಹೇಳ್ಬೇಕಿತ್ತು.
They are all that-
Deletion ಕೇಳಕ್ ಬರಲ್ಲ ನಿಮ್ಗೆ.
ಹೌದು.
ಅದ್ರ ಮೇಲೆ ಲಾ ಹಿಂಗಿದೆ, ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹಿಂಗ್ ಹೇಳಿದೆ.
ಹೌದು.
ಆದ್ರೆ ನಿಮ್ಗೆ ಬಿಸ್ಕಿಟ್ ಕೊಡಕ್ ಬರಲ್ಲ, ಪನ್ನನ್ ಕೊಡ್ಲಿಕ್ ಬರ್ತದೆ ಅಂತ ಒಂದ್ ಮಾತು ಹೇಳೋದ್ ಬೇಡವಾ
ನಾವು ಇದನ್ನ ಸಿವಿಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಡೆಪಾಸಿಟ್ ಮಾಡಿದೀವಿ ಅಂತಾನು ಹೇಳಾಗಿದೆ
ಅವ್ರಿಗೆ?
ಹೇಳಿದೀವಿ. ಇವ್ರು ಏನ್ ಮಾಡ್ತಾರೆ ಅಂತಂದ್ರೆ they adopt a dilatory tactic. Sorry, Lord, to say use this word.
No, not against her.
Not against the petitioners also, Lord. Why I say so is, in 2013, Lord, he sells the property. They know about it, the acquisition proceeding, they file objections to the
During
acquisition.
the pendency, those were.
They were sold. And in 2000, before this redo notification happens, they all come before the BDA and seek for a deletion of the land from acquisition proceedings. Thereafter, these petitioners, purchasers, keep quiet. They send the earlier owners to the court to challenge the acquisition proceedings in 2014. Lord, that was disposed of. That was disposed of.
Disposed of means what?
Disposed of, directing them to go to the committee.
Committee.
These people don't go to the committee. Again, they send the owners to the committee. They don't want to go before the committee. That way
Committee ಮುಂದೆ ಅವ್ರು ಹೋಗ್ತಾರೆ, ನೀವು ಕನ್ಸಿಡರ್ ಮಾಡ್ತೀರಾ?
committee ಮಾಡೇ ಮಾಡ್ತಾರೆ. Committee has rejected it on the ground that the earlier owners, you have no right over the property because you have sold it. That is the only ground. Lodge may kindly seek 193.
May I make one
Lodge may
submission?
kindly take that.
In the year 2013, Your Lordship, after the division bench order,
Good.
there was a resolution passed by the BDA to exclude my
When-
property from.
When you bought the property,
Your Lordship, I purchased on 18/7/2013.
ಇದು preliminary ಯಾವುದು?
Preliminary 2002.
2002.
Sorry. Lord, preliminary notification is 3/2/2003.
3/2/2003.
Yes, ma'am. And the final notification is on 18/6, sorry,
23/2/2004.
23/2/2004.
18/6/2004 ಅಲ್ವಾ?
18/6/2014 is further modified notification.
ಅಲ್ಲ, ಅದಕ್ಕಿಂತ ಮೊದಲಿಗೆ ಯಾವುದು?
Lord, I shall give two.
3/2/2003 is preliminary.
Yes.
Yes.
my lord.
ಆಮೇಲೆ
Final-
ಫೈನಲ್ ಯಾವಾಗ ಇಶ್ಯೂ ಮಾಡಿದ್ರು?
23/2/2004.
2004.
Yes. my
Yes.
lord.
ಆಮೇಲೆ
Then modified notification on 18/6/2014.
modified final ಇದು.
ಇಲ್ಲ, ಅದು
Fine.
ಸುಪ್ರೀಂ ಕೋರ್ಟ್ಗೆಲ್ಲ ಬಂದಾದ್ಮೇಲೆ
ಹಾ.
ರಿಮಾಡಿಫೈಡ್ ಸ್ಕೀಮ್ ಅಂತ ಹೇಳಿ ಒಂದು
Scheme is modified.
Yes.
ಸ್ಕೀಮ್ ಇಸ್ ಮಾಡಿ 18/6/2014.
ಅದರಲ್ಲಿ ಇವರು ಈ ಲ್ಯಾಂಡ್ ಉಳಿದಿತ್ತಾ?
ಎಸ್, ಮೂರು ನೋಟಿಫಿಕೇಶನ್ ಅಲ್ಲೂ ಇವ್ರ ಲ್ಯಾಂಡ್ ಇದೆ. ಸರ್ವೆ ನಂಬರ್ 42/4A of Geddalhalli village.
Included.
Yes.
They bought the land on
18/7/2013, my lord.
two 2013.
Yes.
Yes.
Landowners challenged the acquisition.
Yes, ma'am. Landowners challenge the acquisition.
WP.
Lord, WP number, Lord, 56686 of 2018.
Disposed of on
Lord, this was disposed of in 2021.
27/9/2021.
Huh?
27/9/2021, my lord.
saying that you should go before the committee.
Committee.
Honorable
Yes.
committee, yes.
Because along with other matters,
Lord, there also, Lord.
ಅವ್ರ committee ಮುಂದೆ ಹೋದ್ರಾ?
Committee ಮುಂದೆ ಇವರು ಬರ್ಲಿಲ್ಲ, ಅವ್ರು ಬಂದ್ರು.
Owners.
Owners who had sold the property in their favor.
ಹಾ.
but
Committee says, since you have sold the property, you have no right over the property.
No, wrong. Where a person, see section 54, 55, 56 of Transfer of Property Act.
Yes.
Where a person sells the property, he owes a duty to oust the title of the vendee.
Yes.
Therefore, it is his duty. Otherwise, tomorrow the buyer may sue him for damages. Therefore, you can't say, once you have sold, everything is over, hangilla.
ಇದ್ರಲ್ಲಿ ಸ್ವಲ್ಪ ಡಿಫ್ರೆಂಟ್ ಇದೆ, ಯಾಕಂದ್ರೆ these people It is not that they are depending on their vendor for everything. These people go and file a suit against the PDA.
That's for the.
That is, they file a
For?
suit for injunction.
ಅದೇ ಅವ್ರನ್ನ ಡಿಸ್ಟರ್ಬ್ ಮಾಡ್ಬಿಟ್ರಿ ಎಂತ ಮಾಡಿರ್ತಾರೆ ರಿಜಿಸ್ಟರ್ ಆಗಿದೆ ಮುಗಿದು ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ ಅದು ಇದು ಇದೆಯಾ
Decreed, my lord.
ಇಲ್ಲ suit decree
Decree ಆಗಿದೆ.
RFA is filed. We are in appeal against that judgment. Now what has happened is, Lord, the committee, Lord, would not have any this one decide on their application if the person who has purchased would have gone before the committee and to say that my land ought to have been deleted from acquisition.
It's not like that. Where the owner of the land, ex-owner of the land makes an application.
Yes.
And if the application is allowed by the committee,
Yes.
then the doctrine of feeding the estate title by estoppel.
Stop.
Feeding the
Feeding.
title by estoppel concept ಇದೆ.
Right.
ಅಲ್ಲಿ ಇನ್ವೋಕ್ ಆಗ್ತದೆ.
ಹೌದು.
Section 42, 43 of Transfer of Property Act.
Yes.
I don't remember. I speak from my knowledge of student days. There is such a doctrine. Feeding the
Feeding the law by estoppel.
title by estoppel.
Yes.
Feeding the grant by estoppel.
Grant by estoppel.
Section
ಹೌದು.
ಇದೆ ಅದು.
ಹೌದು.
But that's how it will inure to the benefit of that person.
Please.
You reconsider that application as if it is made by the person who is having locus standi.
It's a committee, they'll have to go. Your lordship may have to extend the time for approaching the committee because the learned single judge had fixed the time limit of some period to approach the committee. Your lordship may extend it, let them go before the committee, plead their case.
Extend ಬೇಡ ಈಗ ಅಪ್ಲಿಕೇಶನ್ ಏನಿದೆಯಲ್ಲ
ಅವ್ರ ಅಪ್ಲಿಕೇಶನ್ ಇಲ್ಲ.
ಓನರ್ದ ಅಪ್ಲಿಕೇಶನ್ ಇದೆಯಲ್ಲ
Please.
ಆ ಅಪ್ಲಿಕೇಶನ್ ಅನ್ನ
Please.
you should reprocess the application by hearing these people.
Yes.
So
Lordship,
that it will help. ಅದು ಏನು ಮಾಡ್ತಾರೆ ಏನೋ ಆಗ್ತದಲ್ಲಿ
yes,
ಆ ರೀತಿ ಮಾಡ್ಬೋದಾ?
ಮಾಡ್ಬೋದು. ಬರೀ
And
ಒಂದು
one more submission, because why I purchased the land is in the year 2013.
we do not. Why did you purchase it? There is a legislation which prohibits buying of the land.
Yes, that is true,
Yes.
my
ಹಾ,
lord.
ಮತ್ತೆ
Because
ಇಷ್ಟು
there was
ಕೊಡೋದೇ ಹೆಚ್ಚಿಂದು.
Yes.
ಏನೋ ಅತ್ಲಾಗ ಅಪ್ಲಿಕೆ ಏನೇನೋ ಪಾಪಲ್ಗೆ ಮನೆಗಿನೇ ಕಟ್ಟಿರನೇ ಇಲ್ಲಿ.
ಮನೆ ಇದೆ, sorry, ಮನೆ ಇದೆ, because I produced the document to show that electricity bill ಅದೆಲ್ಲ ಹಾಕಿದೀನಿ, so that before the trial court also I produced all the documents, ಖಾತಾ ಎಲ್ಲ
ಮನೆಗಿನೇ
ಇದೆ.
ಇದ್ರೆ ನೋಡ್ರಿ ಏನಾರ ಮಾಡ್ಲಿಕ್ಕೆ ಬರಂಗಿದ್ರೆ.
ಮನೆ ಇದ್ರೆ if it is totally built up, Lord,
Why can't you keep, you want to spoil the case? You have to evolve as a lawyer. When court is in your favor, don't spoil it. Alri?
please. ಮನೆ ಇದ್ರೆ regularization, if it is totally built up, Lord, there is a direction for the committee to see whether it can be converted into, integrated into the layout itself. That is the direction which has been already given by the learned single judge. If they establish a fact that the house is in existence and the demolition of it or taking away such a site from them is not of any good use to the Bangalore Development Authority, Lord, the committee is definitely considering it. It's considering it on human.
Application ಅವ್ರು ಮಾರ್ಯಾರ ಅನ್ಕೊಂಡು ರಿಜೆಕ್ಟ್ ಮಾಡೋದಿದೆಯಲ್ಲ.
ಅಲ್ಲ ಅವ್ರು ಮಾರಿದ್ದಾರೆ ಅಂತ ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ರು, ಸಪ್ರೇಷನ್ ಅಂತ ಹೇಳಿ ಮಾಡಿದ್ರು. ಅವ್ರು ಅದನ್ನ ಡಿಸ್ಕ್ಲೋಸ್ ಮಾಡ್ಲಿಲ್ಲ, ನಾವ್ ಇಂಥವ್ರಿಗೆ ಮಾರಿದೀವಿ ಅನ್ನೋದು. ದಟ್ ಇಸ್ ಹೌ.
ಎನಿವೇ ಅದನ್ನ ಒಂದ್ ಮಾತು ಏನಾಗ್ತದೆ, ಅದು ಏನೇನೋ ಸಮಸ್ಯೆ ಆಗ್ತದೆ. ತಗೊಂಡೋನ್ ಗತಿ ಏನು? ತಗೊಂಡೋನು ಅಷ್ಟೆಲ್ಲ ಗೊತ್ತಿರಲ್ಲ ಅವನಿಗೆ, ಎಕ್ವೈರ್ ಆಗಿದೆಯೋ ಬಿಟ್ಟಿದೆಯೋ ಏನೇನೋ ಇರ್ತದಲ್ಲಿ. ಹೌದು, ಅವನಿಗೂ ಅನ್ಯಾಯ ಆಗ್ಬಾರ್ದು.
ಇಲ್ಲ, ನಾವು
ಅವಾಗ ನೀವೇ ಕೇಳ್ಬೇಕು, ನೀನ್ ಯಾರಿಗಾರ ಮಾರಿ ಅನ್ಯಾಯ ಆಯ್ತಾ ಅಂತ ಕೇಳ್ಬೇಕು ಒಂದ್ಸಾರಿ. ಅವಾಗ ಅಡ್ಜುಡಿಕೇಶನ್ ಆಗ್ತದೆ. ನಾವು ಎಗ್ದಮ್ ಬರೀ ಫ್ರೇಮ್ ವರ್ಕ್ ಈಸ್ಟ್ ಇಂಡಿಯಾ ಕಂಪ್ನಿ ಟೈಪ್ ಎಕ್ಸ್ ವರ್ಸಸ್ ವೈ ಹಂಗೆ ಹೋಗಕ್ ಬರತ್ತಾ? ಜಸ್ಟಿಸ್ ಆಗೋದೇ ಇಲ್ಲ. ಪ್ಲೀಸ್ ಆರ್ಡರ್ ಆಗ್ತಾವ ಅಷ್ಟೇ. ಬರ್ಕೊಳ್ಳಿ.
One submission, my lord. I have produced the map. When the map itself shows that it's a built up area. That's one submission. Second is your lordship, adjacent lands, your lordship, this is all excluded from the acquisition.
ಅದನ್ನೆಲ್ಲ ನೀವು ಅವರಿಗೆ ಕೊಡಿ ಮಟೀರಿಯಲ್. ಐ ವಿಲ್ ಪರ್ಮಿಟ್ ಯು ಟು ಗಿವ್ ದಟ್ ಮಟೀರಿಯಲ್.
Please, your lordship.
ಕೊಡಿ.
Page 1193 is the impugned order.
Shorn of thickness, ಕೂತ್ಕೊಳ್ಳಿ, thickness of the case paper book, comma, the essential grievance of the petitioner is as to non-regularization of the structure allegedly built on the subject property, either by deleting the same from the acquisition process or in the making. First, learned counsel for the petitioner submits that her client was not aware of the acquisition proceedings commenced by virtue of preliminary notification dated 3/2/2003, resulting into a final notification dated 23/2/2004, and that the very scheme underwent some modification way back in June 2014. First, she also argues that when the erstwhile owner, that is, the vendor of the petitioner, had sought for some relief at the hands of Justice Keshavanarayana committee. ಕೂತ್ಕೊಳ್ಳಿ, ಅಲ್ಲಿ ಯಾಕೆ ನಿಂತ್ಕೊಂಡಾರ ಅವರು? ಕೂತ್ಕೊಳ್ಳಿ, ಇಷ್ಟೊಂದು ಚೇರ್ಸ್ ಇದೆಯಲ್ಲ, ಹೇಳಿ. Relief could not have been denied to him on the ground that he had already sold the property by registered sale deed dated 18/7/2013, in as much as under the scheme of sections 54, 55 and 56 of the Transfer of Property Act 1882, right, there is a duty cast on the vendor to vouch the title of the subject property in favor of the vendee. First up, this aspect, according to the counsel for the petitioner, having not been properly appreciated by the committee, there is error apparent on the impugned order warranting interference of writ court for undoing the injustice. Yes, Ravi Shankar, you know.
I wanted to appear in serial number 40. Your lordships have already indicated. Lords, I understand, my lords, but if the BDA had made a statement before this court as to whether all the properties surrounding this property is either developed by as private layout or as a part of the BDA layout, matter could have been closed here itself, my lords, because two things which we have said.
ನಿಮ್ದೇ ಮ್ಯಾಟರ್ ನಲ್ಲಿ ನಾವು ಹೋಲ್ಡ್ ಮಾಡಿದ್ವಿ. ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಪ್ರಕಾರ ಮಾಡ್ತಾ ಇದ್ದೀವಿ.
I understand, my lords, I understand.
Which you had argued, because your arguing counsel told your name. Yes. Immediately I recalled one matter which you had argued before us.
Your lordships have passed this.
Relief ಕೊಡ್ತಾ ಇದ್ದೀವಿ.
Very well, my lords, very well.
Next paragraph. Learned panel counsel appearing for the respondent BDA committee garu. Learned HCGP appearing for the Justice Keshavanarayana committee resist the petition. How is your health now?
It's all good.
Making submission in justification of the impugned order and the regions on which it has been constructed. First, they contend that it was the bounden duty of the seller of the land to disclose to whom he had sold the property, semicolon. This he having suppressed, no relief could be granted to a person who had approached the committee with soiled hands. First up. Next paragraph. Having heard the learned counsel for the parties and having perused the petition papers, we are inclined to grant indulgence in the matter, limited indulgence in the matter as under for the following reasons. First, the subject land is
comprised in the acquisition process, even in the modified scheme of June 2014 is not in dispute. Semicolon. There is some evidentiary material on record that arguably vouches the stand of the petitioner that a structure has been brought up in the subject land, subject site, and that various developments have taken place in the vicinity of the land in question, warranting a second look as to whether the said part of the land be deleted from the acquisition process, or the structures brought up in the vicinity to be examined for being integrated in the layout in the making. First off, the committee, with due respect, we observe, the committee, with due respect, we observe, missed this aspect of the matter while treating the application of the erstwhile owner of the subject property who had approached it under the shadow of an order in WP 56686 of 2018, disposed of on 27/9/2021. First, this it could not have done merely because the erstwhile owner ceases to be the owner of the property site in question because of the registered conveyance dated 18/7/2013, there being a duty on the part of the vendor to vouch the title of the subject property in favor of the vendee. First, next paragraph. We have yet another reason to make the observation as above, where the application is made by the vendor, the outcome of the application, if were to be positive, would have inured to the benefit of the vendee because of the doctrine of feeding the title by estoppel, or an akin doctrine. Regardless of invocability of section 43 TP Act
Section 43 of TP Act.
43 of TP Act in stricto sensu. First off, an argument to the contrary, learned senior advocate Mr. Ravi Shankar would submit, would be bereft of justice, which a welfare state like Article 12 entity should not venture to do. First off, that being said, we do not agree with Mr. Ravi Shankar that this court itself should accomplish the task which the committee should do again in accordance with law. Since a host of factors enter the fray